Well, good morning, and thank you so much for joining us on WLTX Plus. I'm Xavier Harris.
And I'm Whitney Sullivan. Today is the day. All eyes will be on the state Supreme Court. The man once at the center of one of South Carolina's most high-profile murder trials. His team is back in court, this time fighting to overturn his conviction.
Yeah, attorneys for Alex Murdaugh are arguing his 2023 murder conviction, it should be thrown out. Now, they claim jury tampering and other trial concerns impacted the verdict. Now, today's appeal, it won't retry the case, but judges, they're going to weigh whether legal errors may have affected the outcome. As state Supreme Court prepares to hear the arguments this morning.
Yeah, that's right. Now, questions remain about just how often murder convictions are overturned and what the justices will actually be weighing. Well, this morning we have team coverage at the state Supreme Court with Kiki Gushu and Christy Calcagno, who are going to be painting a picture of what it looks like outside right now and what we can expect throughout the day. So we're going to go ahead and start with them. Good morning, Christy. Good morning, Kiki. How's it looking outside right now?
Hey, good morning, Whitney. Hey, good morning, Xavier. Yeah, alongside Kiki Gushu right now, we're kind of basically breaking it down as there is already a line. Ezekiel, let's go ahead and step out of the way and show that sign, that line that we're seeing right now behind us. You can already see about 20 people are already waiting in a line to get into this hearing. Let's bring Kiki back on in here. Kiki, you have been really studying this case for a long time right now. We do want to go ahead and mention to our audience, this is not a retrial. All of this is a hearing.
It is. It is a hearing where Alex Murdaugh and his team are appealing his trial, his previous trial. They want to say there were issues with that trial and we want another trial. So this is a hearing for a new trial. It is not a new trial itself, and there will not be a jury. There will not be, the same Alex Murdaugh will not be here. So it is different. It's different.
Yeah, there's also no witnesses, no new evidence, nothing that's going to be coming in that is going to be new. This is exactly what is going to be happening with the Alex Murdaugh defense team as well, going against the state, as we are hearing with Creighton Waters as well. So can you kind of give us right now a bit of a refresher on how exactly we got here today?
Right. So about 5 years ago, 2021, June, Alex Murdaugh and his family were living in Hampton County. Now, his wife, Maggie, and son, Paul, were murdered. Alex was convicted, and that's where we started. Now, in 2023 was his original trial under Judge Newman out in Colleton County, and now we are here at the South Carolina Supreme Court.
Yeah, and so right now he did receive those 2 life sentences. That's what we know, of course, with the murder of his wife and son. And again, all of this week's proceedings, all of this is going to be a heel. Again, as we mentioned, there's no new testimony. Simply put, there's no jury, no testimony. It's law, and it all comes down to the witnesses. Now it's also coming down to what happened even just a couple of months ago, even of court, with the clerk of court, Becky Hill, as well as the fraud charges that we're seeing as well.
Yeah, and I actually talked to criminal defense attorney Jack Swirling, and he says in South Carolina, the bar is higher to overturn a conviction, especially on those jury tampering allegations. And Becky Hill was never charged with jury tampering. That's the Colleton County clerk of court. She was charged with perjury, so it is not the same. And so they're going to have to fight that high bar and actually prove that the verdict was impacted by Becky Hill's behaviors in order to overturn the verdict on those charges.
Yeah, there's also 2 charges that will be going on. We're going to kind of break down, coming up in the next half hour, break down who is going to be in that courtroom. Again, what we do know is incredibly limited seating, right? So that's why we saw behind us, there's already a line waiting on in that door. Less than 100 people are going to be getting in there. What we do know is there are going to be a lot of media outlets. There's already, I think what we can say, 10, 15 tripods that are currently next to us right now, getting ready for these live shots throughout the entire day. But the doors are going to be opening at 8:30, and that's where we're going to be seeing you, Kiki.
Yes, I am going to be heading into the courtroom, get us a first look, be taking notes, and really seeing what these justices are going to be hearing in those arguments. Now, they actually already know the arguments that the defense and the state are going to give. They had to submit those briefings, so that knowledge they already have. They've already studied that, and they're ready to ask questions. So that'll be a big part of today's hearing.
Yeah, and also it's going to be really quick. We talked about this. It's only 20 minutes for each side. 20 minutes, 20 minutes, then another 20 minutes, 20 minutes, and then 10. So it's going to to be a really quick case. Again, as we mentioned, there's no new witnesses and no new evidence that are going to be coming in, and no new jury. And so they've already been briefed on the thousands of documents that they've already received with this.
Yeah, absolutely. So they're ready. I talked to Jay Bender a little bit earlier. He's a longtime attorney here in Columbia, and he said they will be ready. They're anticipating every argument. They're ready to ask questions, and they are ready to hear the arguments.
Yeah, they're going to be ready, and we're going to be ready as well. We're going to keep you live right here outside the Supreme Court. We got Kiki Gushy, Christy Calcagno. We'll send it back over to you guys in the studio.
All right, my friends. Now, we know so many of you have questions because this case garnered millions of people interested in it. I mean, all eyes were on South Carolina as this trial was happening, and we know the same is going to be said for this hearing. So if you have any questions for attorneys, like we've been telling you all week, we're going to be sitting down with attorneys throughout our show, really breaking down this hearing, taking a look at how we got here. But if you have questions for them, all you got to do is text that number at the screen. It's 803-776-9508. And you can ask the attorneys any questions that you have related to this Murdaugh hearing or even the Murdaugh double murder trial that happened before, because we know that legal jargon can sometimes be very difficult
confusing
to understand, and we know there are a lot of moving pieces with this, so we want you to be informed and really understand what is happening moment by moment. And again, that's why we are connecting you right with the experts. So ask the attorneys your questions. Just text us 803-776-9508. And if you could, please leave at least your first name and where you're watching from.
Absolutely. Now turning things over to our meteorologist, Lana Foss, for your most updated and accurate forecast.
Coming up for tomorrow morning. So here's...
Yeah, it's going to be a pretty nice day as far as temperatures are concerned. However, we're going to be dealing with some of the looking great on the roads, and they're continuing to look good out in the skies. Now, we will see the showers mostly all day today. It's going to be on and off showers. They're not going to be constant. That's going to be for the weekend. But as of right now, we're seeing some calmer skies. We do have some scattered showers, and I'll show you exactly where we're seeing those. But let's look at your temperatures. We have the 60s right now. Some of us are in the 50s, but that's because we are seeing a little bit of wind out there. It's going to feel a little breezy along with the rain that we're seeing. So your temperatures may feel a little bit lower than this. However, this is still above normal, still where we are normally supposed to be for highs, and we're seeing these in the morning getting into the 70s later today. But here's a look at those showers that we're still seeing across South Carolina now. It is going to be mainly scattered to isolated showers, nothing widespread, nothing heavy, at least not yet. That could occur as we head into the weekend, but as of right now, we're just going to be getting a little bit of a wet down here for us, and I'll show you the timeline. But right now, if you want to go out, time's the best time to do it. We're going to be seeing some scattered showers. However, the showers are staying all day today, so if you do have to go out, maybe walk your dog, wear that rain jacket or have an umbrella, because it is going to be quite a wet one, but a warm one at that. So what do you need out the door? Maybe some sunglasses if we do have that sun coming out. Short sleeves, yes, you will need them. That's why I'm in them today. And of course, an umbrella or a rain jacket, because we're seeing the rainfall for today. And some people may not even get any today, but mainly going to see just some scattered showers across the Midlands for today. But as far as your temperatures are going, 69 to 70 is kind of where we're going to be sitting. But we have that high chance of showers, 70%. It looks like a big number, but like I said, it's not going to be everywhere and it's not going to be all day. But we are still expected to see some type of rain today. It's just going to be over the span of a couple hours. So, but today, 70 degrees there. Showers going to be pretty windy. Tonight, we're back into the 30s. So last night, we were seeing 40s, 50s, and like we saw early this morning, 60s, but we're backing those down into the 30s. So we are going to be seeing some colder weather coming in. We're going to see the showers late tonight, but then as you head into, as you can see there tomorrow, 63 degrees, so a little cooler. However, we have the sunshine, so we're taking a little bit of a break from the rain. However, it could continue to stay with us as we head into the weekend. Here's a look at your radar, kind of showing you where these showers are going to be. So this is 10 o'clock this morning, still seeing scattered showers. But as you can see, they kind of lessen up as we head into your afternoon. This is 2 o'clock. And then as you head into dinner time, it's moved off. We've cleared out, and we may even be able to see a nice sunset with that as well. And it goes away. And then as you're waking up on Thursday, we're back to seeing clearer skies and some nicer conditions with temperature just a tad closer to what we're seeing as far as our normals go. So Over the next couple of days, what are we going to see? Showers today, mostly sunny tomorrow. And then as you head into Friday, we are going to increase those clouds. And then Saturday could potentially see some late day showers, which means, hey, Valentine's Day, we could see some showers for your dinner time. I'll have a full look at this forecast and letting you know, okay, the timeline and what system we're watching. So stick around to hear that full forecast. But for now, make sure you have your umbrella if you're heading out the door. We're going to take a look at what we're seeing as far as today's forecast goes. So we do have some scattered showers, but those aren't really tracking the roads as much right now. So let's look at your travel time. It's going to be popping up here in a second, letting you know, okay, what are we seeing? So it is going to be a little bit slower there on I-20, 43 minutes for your roads there, 8 minutes on I-77. We've had good luck with I-77 over the past couple of days, but if you are traveling, make sure you go a little slower if you're having any issues with the rain. Otherwise, add a couple minutes if you need to, just to make sure that you get to work safely today.
Well, time right now, 7:12. Let's get to your morning headlines. Some of the other top stories worth knowing, not only here in the Midlands, but also around the nation. Now, first up, a Columbia man facing multiple charges in Marion County involving 2 minors. Investigators say 29-year-old Eric Marshall Favor Jr. charged with 2nd and 3rd degree criminal sexual conduct with a minor, criminal conspiracy, and promoting prostitution of a minor. The Marion County Sheriff's Office says the investigation began back in 2024 and involved 2 victims under the age of 16. Favor is being held at the Marion County Detention Center, waiting on a bond hearing. Well, at the State House, a proposal that would allow alcohol to be delivered directly to South Carolina homes has advanced through a subcommittee. Now, the bill would permit liquor stores to deliver alcohol or even partner with third-party services, with customers required to show a valid ID and deliveries barred from delivery from schools, churches, or college dorms. The bill now heads to a full House Judiciary Committee for a vote. And this morning, we are continuing to follow breaking news regarding the disappearance of Nancy Guthrie. The Pima County Sheriff's Department confirms authorities have released a man detained earlier as a person of interest in connection to this case. The person was reportedly detained at a traffic stop on Tuesday in a city south of Tucson. This development comes 11 days after Nancy Guthrie, the mother of Today's Show co-host Savannah Guthrie, was first reported missing. Now here's what he had to say moments after being released this morning.
Were you shocked?
Yeah, I was.
Tell me.
Come on, like, what do you expect me to do? ¿Cómo quieres que reaccione cuando algo pasa así? Pero yo no sé qué está pasando. Me agarraron como si yo fuera un criminal, me secuestraron. They held me against my will. They didn't even read me my rights until 2 hours later. Okay? Luego, mira, my wrist is all swollen from the handcuffs. Like,
and did you have any idea
No.
that this was about?
No.
Do you know who Nancy Guthrie
no.
is?
That's the problem. No, I don't know anything.
You were like, where is this coming from?
How did they come up on you?
I don't know.
Like, what, were you just driving around?
Yeah, working.
Much more on this story and where the investigation now stands coming up in just a little bit on News 19 this morning. And don't go anywhere. We have more coverage of Alex Murdaugh's murder conviction appeal, and we're breaking down with attorneys what we can expect today. Stay with us. Well, as today's appeal hearing unfolds, a lot of legal questions surrounding what happens next, what's going to happen in the courtroom, and what's going to be done to actually decide this.
Yeah, and to help break it all down this morning, we are sitting down with attorneys Dane Phillips and Taylor Bell. They have no connection to the Murdaugh trial or today's hearing, but they are experienced legal professionals who can walk us through how the appeal process works and what the possible outcomes could be. Thank you so much for joining us this morning.
Thank you.
All right, y'all. Again, all eyes on South Carolina. Taylor, we did this a couple of years ago where we were breaking everything down. Dane, you've been joining us the past couple of weeks breaking stuff down. So for people who are at home and are like, okay, how did we even get to this place? Could you break down how he went from being in prison convicted of double murder to now there is an appeal hearing?
So he has an absolute right to a direct appeal. Once he was convicted, the first thing they did, they had 10 days to file a notice of appeal. That's what started all of this. Once they filed that, then they had a deadline to file the brief, and then get it. Basically, that starts the whole process of where we're at now, which is the oral argument. We're there before the South Carolina Supreme Court. Normally, you would be before the Court of Appeals, but because of the high-profile nature, they jumped it straight to the South Carolina Supreme Court, which is where it would have ended up eventually anyway. So. We're finally going to be before the justices, and they've have their issues that have been raised, and they can ask any of the questions they want related to those issues. However, they have blocked it in terms of the times, and I know y'all have put that out for your viewers.
Yes, the 20 minutes. Taylor, let me ask you this. How often is an appeal hearing granted?
I think it's a very rare thing that an appeal is granted. They're looking for legal errors that the trial judge made. It's not going to be on the facts of the case. They're not retrying it in front of the justices. That would be if the appeal is granted. But it's a rare thing. I couldn't give a percentage, but if I tried, I'd say 1 to 5% maybe.
Wow. Are we surprised that it made it to this stage?
No, this was always going to happen procedurally. So no surprises. This day was going to happen from day one in terms of an appellate procedure. Now, what happens after this is all the next steps. So, you know, who wins, who maybe petitions the United States Supreme Court. That's all the big question marks. Today was going to happen one way or the other, and it's finally here. I mean, in terms of the percentages, you're probably looking at nationally 3% overturn on appeals, but this high-profile nature and the issues, it's impossible, as Taylor said, to really put a percentage on it.
Yeah.
And when we talk about the justices, what would they be listening for today from the defense?
So I think that there's two big issues here. Number one issue that I think they're going to focus on is whether the standard that former Justice Toll used of what was the state or Rimmer, which is the United States Supreme Court, she decided to go with State versus Green, which is a South Carolina case, which kind of abrogated a little bit of the Rimmer standard and added another requirement. I think they're going to be questioning that and whether or not that was the correct standard. So I think a lot's going to be focused on that. And then the other issue is going to be whether or not the financial crimes should have been admitted into the trial by Judge Newman, and whether or not that was appropriate. And whether or not there was any improper evidence admitted, which would be the financial crimes that was used in the murder trial.
Go ahead.
Let me ask you from the financial crime standpoint, because a lot of people at home are like, I don't understand why financial crimes would not be allowed to be used or could be up for debate in this case, because a lot of people point to that as the motive for the murders. And so can you speak to why the financial crimes are being looked at again?
Absolutely. So there's two specific rules of evidence. It's Rule 404B, which is basically prior bad acts, that character evidence. And then 403, which is anything that has relevance, whether it's substantially outweighed by unfair prejudice. And so one of the exceptions is exactly what the South Carolina Attorney General's office is arguing, motive. that this is the reason why we're able to get into unrelated acts, because it goes directly to the heart of their case, their theory of why the murders occurred. Now, I believe some of it should have been admissible. It just was too far. It should have been limited in scope in terms of the office manager finding the financial crimes, basically bringing it to his attention, and the temporary, from the timing of it, the temporal nature, it was all within a day or two when all this stuff, as they said, the storm was building, the opening statement of Creighton Waters. So I think from a limited standpoint, it should have came in, but 2 weeks worth was just too much. That's where you start to tip the scales and go beyond what I believe would have been admissible. And I think that's what they're going to really focus on, is whether, and the other part is whether the defense opened the door to allow them to get into additional inadmissible evidence, because the defense asked certain questions that would allow the government to basically go into that evidence.
And I also want to talk about the jury tampering issue. How hard is that to prove that that actually happened?
Well, I think that depends on what standard you use. The Rimmer standard said it's a presumptive, it's presumptive that the impact on the jury. The Green standard said that you had to prove actual, that tampering actually influenced the jury's decision. And that's where that hearing with Justice Toll occurred, where she heard from the jurors. She questioned them. And then you had that one juror that submitted, I think, 2 affidavits, one initially and then a second one, but she didn't accept the second one that said it actually influenced her verdict. And so I think that comes into play as to whether or not the correct standard was used there. Now, the bigger issue is that I see is now that Becky Hill has been convicted of crimes related to her truthfulness. How does that come into play? Did the state know that they were going to be pursuing charges and not actually, tell the defense that about Becky Hill? Did they hide that from her when they were, going through the request for a new trial based on the comments that she made to jurors? I don't know. Will that be brought up? Possibly. But that's really what I think is an issue here, is the standard that was used. At the presumptive standard, that it was presumed that it impacted them because it was a state actor, being Becky Hill, or whether Justice Toll used the correct standard in State v. Green.
Absolutely.
And Juror Z's affidavit made clear that it affected her verdict. That was the issue, the prejudice. So Murdaugh's lawyers have made clear, even if you take the United States Supreme Court standard under Rimmer of irrebuttable prejudice, even if you look at it from Green, there was prejudice. They have proven it's not harmless. We have one juror, which is all you need for a mistrial, saying that this conduct occurred and it affected her verdict, period.
Well,
I got so many more questions, y'all.
Absolutely. And our producers are in our ear like,
Yeah.
We have 1 minute, but we are going to get so much deeper into these questions after a quick weather update. Stay with us.
Where we're going to be taking a look at some of our temperatures for today. Now, we're way above normal for our highs, and we had the 8 to 14-day outlook. I mentioned it earlier on social media last week, and yes, we've followed that with the 60s and the 70s as our temperatures, but we are watching some rain that we've got going on here in the Midlands, and mainly just scattered showers, nothing too heavy, nothing too widespread, but still going to cause some effects today. We were dry for the past couple of days, but now we've got some rain on the way. Staying with us for today, that's really going to be about it. But here's a look at your future radar. So this around 10 o'clock. We're still going to have those scattered showers here with us, and they're going to start to dissipate just a bit as we head into the afternoon. So 2 p.m., we're going to see some isolated showers rather than scattered. And then as we head into the next couple of hours, talk about 6 p.m., really nothing, and most of the clouds are staying off to the east. And then as you're waking up in the morning on Thursday, we're going to be seeing some nicer skies and some sunshine. But we are seeing that northern wind bringing in some cooler temperatures, so do expect us to start decreasing the temperatures after today. But as you can see, moving as well, we have this cold front that moves through. Things are looking a little better for us as the low pressure system moves off. But take a look here at your 7-day forecast. 69 degrees here for us today. But then the weekend, going to have another chance of showers here for us. So have the umbrella today. You won't need it for Thursday, Friday, but you may need it again for the weekend.
.30 on your Wednesday morning, and the countdown is on as Alex Murdaugh's appeal hearing in front of the state Supreme Court is going to happen in just a few hours.
Absolutely. We want to go live right now to Kiki Gushu, who is breaking everything down, what we need to know. And Kiki, what updates do you have for us right now?
Xavier, we are talking about who is going to be in this courtroom today. There's not a lot of seating. It's about 100 seats. So I do want to step ahead. We showed the line last time, so we're going to step out and show it again because it is just getting longer. I'm actually about to head out there so I can get in line. There is no special press access for this hearing today, and really only 60 seats, probably.
What I also think is interesting is we already saw Joe McCullough over here, a very prominent attorney in our area, is actually waiting in line, as well as some other high-profile attorneys, as well on top of that, of course, as we talked about, the media, and people who have actually been following this case since the beginning. So there's no line. There's all just one line.
Yes, absolutely, absolutely. There is no special access, no privilege here today.
Yeah.
But, Christy, I do want to talk about the justices. So there's 5 Supreme Court justices, and the Chief Justice is John Kittredge. Now, a really interesting tidbit, we got a little ambulance behind us, but a little interesting tidbit is that all 5 of the justices went to USC Law School, which I thought was very interesting, as did Alex Murdaugh, the defendant in this case.
Yeah, so right now, like Kiki just mentioned, we have the Chief Justice, John Kittredge. We also have their names right here listed on over here. We have Justice John Cannon Few, Justice George C. James Jr., Justice D. Garrison Hill, as well as Justice Letitia H. Verdin. All of them are going to be there hearing this case. And let's also go ahead and break down who is on the defense and also who is on the state. It is going to be only 20 minutes on each side. So 20, and then another 20 minutes, another 20 minutes. So in total, only of this is going to last about an hour and a half.
Yeah, and a very prominent member of Alex Murdaugh's defense is Dick Harpootlian. He's been a long-time criminal defense attorney here and also involved in the State House. So he will definitely be fighting this argument. He says he's sticking by Alex.
Yeah, and so one thing that I was actually able to talk to Dick Harpootlian even before all of this happened. So he spoke with me before this hearing. This is what he said. I'm going to read this to you. He said this verdict should be thrown out because of alleged improper influence of involving former Toccoleton County Clerk of Court Becky Hill. So that was one of the things that he's going to argue, as well as on top of if the financial crimes should have been brought up during his murder trial.
And Christy, that jury tampering allegation, that's going to be a high bar for them to beat. Now, in order for a jury tampering conviction to be proven, you need to prove in South Carolina that the verdict was effected by the jury tampering. In this case, by Becky Hill's statements to the jurors. And in the original hearing, Justice Toll asked the jurors if they were influenced. Only one said he was influenced by Becky Hill, and an alternate also said that they were influenced.
It is also important to know that she was convicted over of the perjury as well as obstruction of justice, but it also was not jury tampering. So that was something that we're going to be hearing as well, or we're expected to be hearing coming up in a little bit. We also, again, want to reiterate this is not a retrial. Harpootlian is just asking the justices for relief based on the process of fairness issues. And again, as we were mentioning in the last half hour, there is no new evidence. So no jury, no new witnesses, no new evidence, because these justices, these 5 justices, have already heard this case.
Absolutely, Christy. Also an interesting tidbit, there won't be a verdict today. There won't be a new trial granted today. We're going to have to wait for that. The justices will work on their opinions, and that'll be a little bit further down the line that we'll actually know what their verdict is today.
So basically, as the sun is coming up right now, we have a little less than an hour before the doors are going to open. Kiki, you're actually going to be saying goodbye to us right here, but you're going to be heading on into the courtroom. Is that right?
I am. I'm going to be bringing you all the details. I'm going to let you in on what's going on in the courtroom, how people are feeling, and I'll bring that all to you right here on WLTX and WLTX Plus.
All right, everybody. We're going to send it back over to Whitney and Xavier over in the studio.
It is going to be a packed house there at the South Carolina Supreme Court. Now, as we promised, we are bringing in legal experts to break down everything that is going to be happening over the course of this hearing, because again, we know it's a lot of moving pieces, a lot of moving parts, and it can be confusing to understand. So joining us right now, we have attorneys Dane Phillips and Taylor Bell, familiar faces here in the Midlands. They are legal professionals, legal experts. Some would probably call y'all goats of your field, right? But really breaking down what we can expect and helping us understand really this whole process.
Yeah, so I want to get right into that time. So originally we were told that they would have 30 minutes each to argue, but then that switched to 20. And then there's that 10-minute rebuttal that the defense will get. So kind of just tell me, why is it structured this way, and why do they get that specific time?
So normally it's 15. I've argued at the South Carolina Supreme Court numerous times, Court of Appeals even more. And so there's very structured amount of time where the appellant will go up, present their case, their time will expire, then obviously the other side will go. It is structured that way because it allows everybody to have the opportunity for the court to present their side. Because there's so many issues, the brief from the appellant side is over 130 pages. The record on appeal is over 8,000 pages. I think it's like 8,500 pages. And so the record is so expansive, so many issues. So they had to kind of break this down. It's such a unique case. So they're allowing them to do the motion for a new trial, segmented in 20-minute segments. Then you have the actual trial issues segmented into 20-minute segments. And then they'll have the kind of like final rebuttal. And I think they're going to have Dick Harpootlian argue one, Jim Griffin argue the next, and then Philip Barber argue the rebuttal. And
that last 10 minutes for the defense, how important is that for this appeal?
I think you're going to be finalizing any questions that the justices had. Throughout this time period, throughout the 20 minutes regarding the new trial, throughout the 20 minutes regarding the evidentiary issues during the trial, you're going to be having questions from the justices. So they're going to have arguments laid out. Each attorney that's going to be arguing for the appellant, they're going to have arguments laid out, but the justices are going to ask questions, and they're going to key in on what is important to that justice. And so I think the last 10 minutes is, let me get to my arguments, but let me make sure I hit on questions that were important to those justices so that you can make that impression to answer those questions that they have.
How do you, as defense attorneys, how do you prepare that 20 minutes, that 15 minutes in front of this? I mean, there's so much that you can talk about. What does that process look like, and what did it potentially look like for Murdaugh's defense team?
So many lawyers will do mock oral arguments where they'll have, and I'm sure they did in a case like this, where they'll have individuals pretend to be the justices, asking them questions, peppering with every question they can think of. But from an internal standpoint, it's reading all the cases again. It's reviewing that record on appeal thoroughly, making sure you know exactly every bit of testimony, because there can be a part where you get a question from one of the justices that's so specific about a case or about something that happened in the trial that you need to be able to specifically reference the holding of that case or how the nuance of specifically that case, how it addressed it from a factual standpoint, or something that happened in trial and know, well, this part of the record, this is the testimony that came out at trial that applies to that specific issue. So it's just countless hours of preparation.
Let me ask this too. We were talking about former Justice Jean Toll, looking at like state versus this, state versus that in regard to making her decision about jury tampering. Could this case set a new precedent? Could in the future we talk about state versus Murdaugh?
Well,
absolutely.
Yeah.
I think absolutely we could. I think that they're going to look and see whether or not the proper state. That's the first. That's the first 20 minutes of argument, and I'm going to key in on, as the attorney for Alex, I'm going to key in on they didn't use the right standard. Rimmer is the constitutional standard for the Sixth Amendment. Under the Sixth Amendment constitutional standard, you have a right to a fair trial, and Rimmer's the proper standard to be used there. Yet Justice Toll completely ignored Rimmer and went with State v. Green, which added an extra prong of actual prejudice. So I'm going to be prepared to argue that the improper standard was used to start with, but even if Green was the proper standard, that benchmark was met by showing that juror actually changed their mind based on what Becky Hill said, and using the affidavits, using her testimony when she was questioned by Justice Toll. So that's, yes, absolutely. We could have new case law out there, or we could just have affirming Rimmer.
Okay.
Absolutely, and I want to go back to the appeals, the likelihood of that getting approved or it happening. Why is it so hard for murder convictions to get that appeal?
Well, when you have, it's not that, again, they have a right to the appeal. So anytime somebody's convicted after a jury trial, they're going to have a direct appeal. And I know a lot of the public doesn't know that, but anybody that goes to trial and gets convicted, they're having an appeal. Not everybody gets oral argument. Only a select few cases will have the oral argument. And then only a select few cases will have good legal issues. This case is littered with them. Again, whether the proper United States Supreme Court standard was applied, whether these rules of evidence were properly applied. And there's additional issues that we haven't even touched. We're highlighting the two primary issues, but there are numerous other issues that were raised by Murdaugh's legal team. And so there's a lot of moving parts, and we may get some of those questions from the justices during the oral argument. However, I do believe primarily they're going to focus on those two.
Absolutely. And when we talk about how nationwide this trial was, in the likely or unlikelihood that this appeal is approved and we get a new trial, how hard would it be to find a jury that has no connection, no idea, or haven't heard anything about this? Because I feel like now you say the last name Murdaugh, everybody knows who that is. It's almost a household name at this point.
I think that it's going to be impossible to find a juror or 12 jurors that have not heard of this. I think that if there is a new trial, the defense will make a motion for a new venue. Don't know whether that changes anything or not, because you could go up to York County, you go to Spartanburg, you go to Greenville, they know about it. I think it's so, intertwined now with the South Carolina legal community and the news in South Carolina that within South Carolina, everybody knows about it.
Absolutely, and it almost kind of reminds me of a trial that I followed with Tyree Nichols, where he was murdered in Memphis, Tennessee, but once they recently just did a jury selection again in Chattanooga, Tennessee, because they were trying to find jurors that had no knowledge of this, and we see the likely outcome of that. So do you feel like this would be the same connection?
What the judge would be asking in a new trial is this. He would say, based on the knowledge that you have, can you set aside those beliefs and be fair and impartial? They under oath, each potential juror would have to answer that question directly. Knowing what you know, can you set that aside and base your opinion, you base your verdict solely on the evidence presented and be fair and impartial to both sides? And they'd have to say yes or no.
When speaking of the justices, what are some of the key questions that we should be listening for? What do you think they're going to be asking?
So if I were getting ready to argue, I would have my argument prepared and be prepared for anything. I can't sit there and think, but I'm going to believe that one of them's going to ask, well, why was justice Toll wrong? Why was that the wrong standard? Because clearly, if you've read the briefs, Jim Griffin, Dick Harpootlian are arguing that Rimmer's the correct standard, and so I think they're going to ask, why is it wrong? Why was Green wrong? Why was that the wrong standard to apply here? I'd be ready to rebut that. Well, even if she wasn't wrong, this is why it was met there. So if I was arguing, I'd be prepared for that.
When it comes to the burden of proof, I don't know if I'm using the correct language, but like who comes in carrying the heaviest burden into this hearing? Is it the defense? Is the burden really on them to prove that there were errors in the trial, or is the burden really on prosecutors saying, hey, we did everything correctly? So who is really coming in with that like heavy weight?
It's the appellant. I mean, it's Murdaugh. He's in prison. He is coming to the court saying, here are the legal reasons why I did not receive a fair trial, why this case needs to be reversed and remanded for a new trial. The burden's all on them. Now, legally nuanced, the main issue that we keep talking about with the Becky Hill and improper influence is that under that standard, the United States Supreme Court case that everybody's talking about and fighting over is because that says there's a irrebuttable prejudice that's put in place, because you always got to prove that an error occurred and that there was prejudice that would have affected the outcome. And so for that first issue, that's going to be all the argument, is whether the proper standard was applied. But as we have just stated, we've made it clear that, or at least what Murdaugh is going to argue, that under Juror Z, it doesn't matter whether they apply either one of the standards, that there is prejudice. It's proven.
Now, let me ask you this, too. This is something that we've seen a lot on social media. Folks are like, why am I not going to see Murdaugh at the hearing? Can you explain that that's actually normal? It's not because it's a high-profile case.
Very normal.
Very normal that the individual that was convicted is not going to show up to oral arguments.
Yeah, I'm sorry, you guys. A lot of people are like, wait, what's going on? We want to see, but really this is just for them. This is just a hearing. This is not a trial that is happening.
And the pressure that's on the justices right now, obviously we know there are a lot of eyes on Columbia, South Carolina right
International.
now. Absolutely. So, talk about that pressure that's on them at this point, because obviously we know there are victims in this case. So if they grant this appeal, how does the victim's family feel? And if they don't, where do we go from here?
I would say certainly there's political ties to this case. There is legal ties to this case. There's international eyes. I mean, everybody is watching that's part of the legal and true crime community, and even people that are just interested. I believe that knowing the justices, yes, sure, it lays heavy, but they are prepared for it. They're ready for it. I think the real issue is all about ultimately what's going to happen next and all the things that are going to follow. They'll be more than prepared for this oral argument.
Absolutely, and we talked about this during the break. If you guys were standing in front of those justices this morning on either side, how would you approach this?
Well, I'd start again. I think I kind of alluded to this a little bit, and when I mentioned I'd have my argument prepared and be prepared to answer questions that are coming along. You got to come back to what your argument is after each question. Come back to that argument, hammer down that this was wrong standard, that even if it was the right standard under State v. Green, that we met our burden. As it relates to the second line of arguments, which is related to the actual trial and the evidence, I think Dane hit on it a little bit earlier underneath 404B that they argued motive. Well, you get to a point underneath 403 that it's just so prejudicial that it outweighs what it's providing the jurors. Essentially, I'd argue that the trial became proof that he was a liar and that he was a thief, but not a murderer. And that's what we had so much testimony about. It just got into the weeds about that he lied about this and he lied about that he stole this and he stole that, and not that he committed the murder, and that overall underneath 403, that outweighed any kind of, proof of the murder, and they tried, the financial crimes and the thefts as opposed to the murder, and hit it that should have been limited.
Absolutely. And do you foresee any surprises happening to this morning?
Look, anything can happen. They can ask any question they want, and any response could come out from the parties. I'm sure there will be a curveball thrown at some point that will have one of the sides thrown a bit and how they answer, and it'll be clear that they'll have to take a moment to kind of really make sure that they answer the question directly. But I guarantee you there'll be at least one, if not more, curveballs that the justices, I'm sure, have been kind of cooking up in preparation for it.
Mm-hmm. And speaking of surprises, when you learned that this has made it to the state Supreme Court, based off of what you have seen from the murder trial and based off of what you have read keeping up with the case, were either one of you surprised that we have made it to this place? Or while you were watching the trial, were you like, I could, as a defense attorney, I could see this is what I would be arguing for the appeal?
Nothing about this surprises me. I think we're still going to have additional legal issues after this, despite which way it goes.
What are those legal issues, you think?
Well, I think you've got also the ability to appeal to the federal courts. If the state court does not agree with the federal standard that Murdaugh team's arguing that should have been used, I think you're going to see that go to the federal courts. If they do agree and it's overturned, then we're going to have another trial. So we're going to have more drama no matter what.
Mm-hmm. And we've been talking all week long about what's going to happen in court, what's going to happen. What won't be decided today?
Oh, there will not be a decision at the end of the oral argument. It can be months. There's no set deadline. The court's going to take their time, and it will be a long, painstaking process as they outline their arguments. Because ultimately, there may be some dissenting judges that will lengthen this process because there's a bunch of back and forth. There's a very set procedure of how that's done in terms of writing out the opinion. So it's going to take months, and they're going to do this the right way. It's too high profile for them not to have some kind of short opinion that doesn't address every issue, especially when this case, regardless of who wins or loses, is going up to the Fourth Circuit or United States Supreme Court. The case doesn't end today for sure.
When we are taking a look inside that process, how many justices have to agree in order for that appeal to be granted? To help us understand what needs to happen in order for appeal to be granted and for appeal to be denied.
So there's 5 justices. They need a majority. So it's 3-2, and that's where it'll come down. It could be all 5 in one side. It just depends on the way it works. It could be 4-1, but they just need a majority, and the majority wins.
And if that does happen, that it is granted and there is a new trial, I want you to kind of talk about how everything starts fresh. It's brand new all over again.
Well, it is brand new, but not necessarily, because you already know what certain witnesses are going to testify to, right? So you're prepared for that. I think you also have him, you have Alec under oath already, having testified. So anything he previously said during that trial will be fair game to be used. I think the defense will be, or the state will be prepared for that. I think the defense will be prepared for expert witnesses. You also have evidence that wasn't used in this case that could potentially be fresh game. So yes, it is a brand new trial. However, the evidence is not brand new. We've seen that before, and you could potentially see additional evidence brought in or not brought in, depending on what the ruling is and whether or not evidence that was used was limited in its ability to be used in a new trial. And that's why he didn't get a fair trial, or that's why the inappropriate standard was used, or just there's a lot of different, it's got to be tailored to the order in the appeal.
Absolutely.
And strategy-wise, the government, the prosecutors don't have to call the same witnesses. They could call different experts. They could call different witnesses for different, I mean, they are not locked in any way, shape, or form. But as Taylor said, we have a transcript of everything that was testified to. So any witness that's already testified to that's essential to the case, you already know what they're going to say. And if they say something different, you would impeach them with it. But they're not locked in specifically to that. They can have new experts review evidence and go through. So there can be some new things that would happen if it was a retrial.
And because everything would pretty much be the same, can we change the characters? Can his team put a motion in for a new judge?
Well, I think there's clearly going to be a new judge because Judge Newman has retired. And so he would not be sitting on that. But I think the Supreme Court would appoint a judge to handle the case as they did the first go around, handle anything related to Alex Murdaugh's matters as they appointed Judge Newman. I think they'll do the same exact thing.
We've got like 30 seconds left. Last question for you guys. When it comes to a retrial, is it more challenging for the defense, or is it we've done this before and we've got momentum?
Very, very challenging. Any advantage you had of, I don't want to say ambush, but any advantage you had of the state not knowing, the government not knowing what you were going to do from a strategic standpoint is gone. They're going to have to go back to the drawing board in a retrial and come up with a new strategy. And they certainly will have that opportunity, and I have no doubt that's what they would be doing. But it does make it tough because what you believe to be your best strategy has already been used once. And so it's like playing the same team again, and you got to come up with a new game plan.
Yeah, it's like showing your hand.
Yes.
All right, my friends. Well, we will have more on the Murdaugh appeal hearing that's going to be happening in just a few hours, in just a second. But first, let's get to weather. Well, it is 7:56 here on your Wednesday morning. We're taking a look at what we're seeing out the door. We have some scattered showers across the Midlands right now. We're going to kind of be dealing with that through the rest of the day. But here's a look at the wider stance here. We have a lot of showers that are going to be coming in here from Tennessee. Those are going to bring in some scattered showers as we head into the next couple of hours. However,
it's mainly going to be scattered. We're going to see the showers now, and then by this evening, they're going to be gone, and we get a little bit of a break. Here's a look, though, at that forecast. So we have the rain now, but then we have this cold front that comes right on through, pushes that rain out, and then the low pressure system kind of sits on top of us, bringing in that northern wind. It's going to move offshore afterwards, and then that's when we're going to see our temperatures take a decrease. This is going into Thursday morning where we're going to see the 30s. Those temperatures will decrease and will stay in the 60s, but after that we kind of clear out for Thursday and have a nicer day before we hit the weekend, in which we will then see, some more rain happening. So just prepare for rain now, a break, and then rain again. So 69 degrees here, 70% chance of showers for today, windy as well. So make sure you have an umbrella or rain jacket with you. We cool temperatures down by Friday. We're back into the 50s, but don't worry, the weekend will hold the 60s again. The weekend will also hold another rain chance. Late day shower on Valentine's Day. And then on Sunday, the rain chances continue to increase and stay up through the rest of the week. But enjoy your day and stay warm.
Well, good morning, and thank you so much for joining us on this half hour of WLTX Plus. I'm Xavier Harris.
And I'm Whitney Sullivan. Now, today is the day. We've been talking about it for weeks. All eyes will be on the state Supreme Court. The man once at the center of one of South Carolina's most high-profile murder trials, well, his team will be back in court this morning, this time fighting to overturn his conviction.
Yeah, attorneys for Alex Murdaugh are arguing his 2023 murder conviction, it should be thrown out. Now, they claim jury tampering and other trial concerns impacted the verdict. Now, today's appeal hearing, it won't retry the case, but judges will weigh whether legal errors may have affected the outcome. As the state Supreme Court prepares to hear arguments this morning, questions they still remain about just how often murder convictions are overturned and what the justices will actually be weighing.
That's right. Now, as promised this morning, we have team coverage at the courthouse with Christy Calcagno and Kiki Gushu. They're painting a picture of what it looks like outside right now. And we have learned that Kiki has actually stepped off to the side so she can go ahead and be inside the courtroom because there is limited seating. So right now we're going to hand things over to News 19's Christy Calcagno. And Christy, I can tell it's getting a lot busier at the Supreme Court.
Oh, yeah, absolutely. Definitely a lot busier. Let me go ahead and step out of the way. I mean, when we started before the sunrise, when you guys came to us earlier, there wasn't a lot of people. Let me go ahead and show you what we're looking at right now. Right now, the line is completely around through that handicap and now around the building. It might be hard to see, but actually through those trees that's where you can find Kiki. So she is in there right now waiting in line. And the reason why this is so important is because, as you mentioned, guys, this is limited seating. And so that means people who are standing in line and who have been standing in line since when we got here, and we got here right before 7 o'clock this morning, there is a lot of people. Now, we're talking about any attorneys who are involved, any high-profile people who are not going to be involved in this case, who just want to be listening in. As we mentioned, one of the high-profile attorneys that I was able to speak to earlier before this hearing, Joe McCullough, is, yes, waiting in that line. We also had the opportunity to speak to some Clemson students as well as USC pre-law students who wanted to say that they wanted to come here and witness history as it's right here in our own backyard. So there is a bunch of people, as we mentioned, of course, every type of media is also out here. There is about a dozen tripods that are kind of gearing up and getting ready to go, but we have been out here again since 7 a.m. and you can already see the line is pretty steep and pretty long out there. Doors open at 8:30 this morning, so that's why it's getting pretty packed out there. And then the hearing is going to start at around 9:30 this morning. Now, this is all going to be very quick. That's something that we want to put in mind and keep informed about this, is that it's not going to be a very long process. So, as Xavier did mention a little bit ago, is that we're going to be breaking down basically two issues that are on the table for the defense, involving who pled guilty, the clerk Becky Hill, who said that she pled guilty, of course, to what we know of perjury as well as obstruction of justice, but not jury tampering. So that's going to be one case, and see if there's a reason to be throwing that out and to have a new retrial. Also, another thing is the financial crimes. Should the financial crimes have been brought up during his murder conviction? And that is going to be another argument that they're going to be arguing to see if Justice Jean Toll was, Judge Clifton Newman was going to see if that was going to be something that was brought into evidence during the murder conviction. So that's going to be what they're breaking it down on over here. Because it's a limited seating, well, it's because it's the Supreme Court. And that's why not only is there limited seating, there's also going to be limited cameras that are going to be out there as well. So that's why a lot of the cameras are going to be in here. There is going to be only one feed. So every single network is going to be seeing the same exact feed from inside the courtroom. That's why Kiki is going in there without a camera. So she'll be able to take down notes on her laptop and give us an inside look of what's going to happen. And then when she comes out after the hearing, we're going to be hearing from some press conferences on both sides about what happens and, of course, what happens next. But let's go ahead and toss it on over to somebody who I was able to talk to a little bit earlier. He's a pastor over in Marion, South Carolina. He was telling me that he has been following this case since the beginning. He said that he was in every single courtroom again since the beginning. Take a listen.
Whole time. Yeah, we every single one. I ain't never missed one.
Why?
Because he hurt so many people, you know what I mean? So many people came up to me and they said, Rev, we're preaching here, the advantage he took people. A lot of folks want to come and they couldn't come. And they said, Rev, would you go and be our voice? A lot of ministers, they couldn't leave the church to go. And so I said, Lord, send me, I'll go. Just like David, when David, the whole gold liner came to kill everybody in the town, and David said, Lord, send me, I'll go.
Now, you know I'm going to... Yep, you just heard from him. Let's go ahead and take another look right on out here. You can see him there with his sign out there as people are still waiting in line. And as the sun is rising, he has been hearing a couple of honked horns since we've been out here this morning, people coming up and people talking to him as well. But again, he's not the only one who wants to be inside that courtroom and just witness everything that is going on. As I mentioned earlier in this live shot, we've been hearing from USC as well as Clemson University pre-law students who just wanted to sit inside that courtroom and learn more exactly what a bunch bunch of media frenzies are going to be doing as well. So you can see a lot of young students who are in this line, as well as some prominent attorneys in and around South Carolina. We are going to be continuing to bring you this live coverage, both on air and online at WLTX.com. But I'll be back in the next half hour to break down who exactly is going to be in the courtroom and what they're going to be hearing coming up in the next half hour. I'll send it on over back to you guys in the studio, reporting live outside the South Carolina State Courtroom. I'm Christy Calcagno.
Christy, before you go, I want to ask you, I know you said you've been speaking with some of those USC students and different folks walking by. What are they saying out there this morning?
So what they've been telling me is that they just wanted to be involved. So that's why a lot of them got up so early in the morning. All they wanted to do was sit here. You know, there's a difference between learning about it in a textbook and learning about what happened versus actually being inside the courtroom and witnessing it for themselves. So that's why we were able to talk. I think in the next half hour, you'll be hearing from some Clemson pre-law students about why they came out so early today and why it was important for them to be a part of this. But that's really what it was. You read about it in textbooks, right? You read about these laws as far with criminal defenses and criminal cases. You read about all of that, but actually being in the courtroom is a lot different. So that's exactly why they wanted to come out here today, as much as a lot of other people who are out there. As we mentioned, it's not just people who are out here who are going to be attorneys. Nobody that is going to be up there, like we're talking about Dick Harpootlian and Creighton Waters, they're not physically in here in this line, but we're talking about maybe other attorneys, as I mentioned, Joe McCullough, who are out here, as well as other members of the media, and of course the public who just wanted to be a part of this.
And then one more quick question for you, Christy, and you talked about it a little bit earlier during our 7 o'clock show. We can't stress enough that really all eyes are going to be on South Carolina today because this is such a high-profile case. Has any more media joined you? I understand there's like a line of media. If you're driving down Gervais Street, you'll see that across from the South Carolina Supreme Court. Are you seeing more folks gather?
Oh, yeah, absolutely. Ezekiel, he's our photographer right now. I'm going to actually have him right on over, pan to my left. At this point right now, you can see crews on top of crews. This is everybody lining up here. Now, we have been seeing some very nice people from the State House coming out here and saying hello and saying good morning. It looks like another person is doing a live shot out here. There's about 4 tents as well. So there's definitely a media frenzy as well out here. But it looks like what we have been seeing is not a lot of people doing like these early morning live shots. There is only one other person that I can see on my right that is doing that. A lot of people are, of course, gearing up for what is going to be happening after the hearing. So that's when you're really going to see all of the lights on. I mean, our lights are on, obviously, because I'm doing this right out here this morning, but everybody is going to be gearing up until after 12:30 and after this hearing. So they'll be coming out here. But yeah, there is a lot of equipment out here this morning. There's a lot of people right here. Actually, to our left, I do see Fox News is over here to my left, as well as we have WCSC. They're over here to my right. And there's a couple of others that I see that I believe over in Atlanta. They also came down as well. So again, as you mentioned, Whitney, all eyes are going to be here on South Carolina. Actually, coming up in the next 10 minutes, I'm going to be going live for our sister station, WYFF, to kind of break down what I'm seeing as well for them. So yeah, as you mentioned, everybody's going to be wanting to tuning in, listening in, and that is why WLTX is going to be the place to get all the information.
Absolutely. I was going to say that proves our name. We're on your side, covering this from beginning to end, in the middle, within, everywhere. We are on your side this morning, bringing it all down.
Yeah, thank you so much, Christy. Yeah, covering this from sun up to sundown. We appreciate you so much. And just a little note, too, for folks who are traveling in that area. This is outside of the case itself. Definitely be careful when you are driving downtown because there's going to be so many people out there, so many media outlets out there. There are going to be a lot of folks who are going to slow down in that area to see what's going on. You already know because you're watching WLTX, but there are going to be people who are probably driving a little bit slower, taking a look at what's happening. I'm sure there will be a lot of just folks out there in general just wanting to see what's going on. So this is like the little sister in me wanting to make sure that you guys are safe. So be careful when you are driving in that area. I can definitely see that could be congested, especially around lunchtime. So take your time when you are driving through the Gervais Street area of downtown Columbia. Now we're going to send it to weather in just a second, but we also want to remind you guys that we have attorneys here who are going to be and who have been answering questions regarding this trial. And we know that so many of you have questions as well. And so once again, News 19 on your side, we are connecting you with those experts. So if you have any questions related to this hearing or even Murdaugh's previous trial, his murder trial, or the Becky Hill trial, please text those in. We want to make sure that you are well informed so that way you know exactly what's happening minute by minute. That number is 803-776-9508. Many of you have it memorized by now because we use that number a lot. But again, 803-776-9508. You see it right there on your screen. Text those numbers to us. And coming up in a little bit, we're going to be sitting down with attorneys, going through your questions, getting you those answers. And if you could, please leave at least your first name and where you're watching from.
All right, now we're going to turn things over to our meteorologist, Tim Miller, for your most accurate forecast. Good morning, Tim.
Good morning. It was interesting watching Christie outside because you notice it was relatively dry. We've had what we call a lot of virga outside, which basically it's raining in the upper atmosphere. The radar detects the raindrop, but by the time it reaches the ground, it pretty much evaporates. So we have to moisten up the air first before we get any rain. But it is going to do so with these southwest winds. We have plenty of rain out towards our west. Look at these temperatures, 63 in Columbia, 60 Lexington. Generally speaking, we're in the 60s. So, yeah, this looks really impressive, right? And there is some rain here involved with this. But again, a lot of it I don't think is reaching the ground. So, again, it's dry, but that will be changing as we moisten up the atmosphere. The rain will start to fall up towards the north. I-77 certainly was a little drippy. Maybe a little virga up there where it wasn't raining. Catching some breaks, that's going to be the case. On and off rain today. Further towards the south now, Springfield into Orangeburg, into St. Matthews, Calhoun County, some showers. And maybe getting some lighter showers, Manning, Sumter. Y'all probably saw a little bit of light showers as well. Satellite view pretty much matches, obviously, the radar perfectly. Notice as we go through the statewide view here behind me, this is where all the rain is. And some of this rain is pretty heavy at that. This is north of Atlanta. This is the real McCoy here. We've got to get through all of this before everything is said and done. And the real culprit is out here towards the west. There's that low south of Memphis right now, quickly moving in our direction. This is tomorrow's weather. So once we get through this, we'll be fine and we'll be done with it. How much in the far as percent? About 70% chance of rain on and off today. Certainly drier Thursday and Friday. Saturday's going to be more clouds than anything else. The rain comes in Saturday night for Valentine's Day, and right now Sunday looks to be the wettest day at about 80% with a decent chance of rain. Let's look at Futurecast. We'll start at about 10 o'clock this morning. Yeah, that's when we'll start to get that rain. The rain that we saw in Georgia, that'll be moving our way. Periods of some heavy rain, not expecting any big thunderstorms at all, so there's no storms here with this. Atmosphere is not conducive for that. Here's 2 o'clock. Notice we'll have some holes in these clouds again, maybe some peekaboo sunshine. That's why we'll get up to about 70 today. After about 4 or 5 o'clock, the rain departs. The front will move through. Winds will switch, and we'll get down to some much cooler temperatures as we get into tonight. This is Sunday. There's a timeline right above my head there. Maybe I'll duck so you can see it. There it is. Sunday, we'll start to have the showers by about 5 o'clock in the morning. Through the day on Sunday, on and off rain. Not really a big deal in the beginning, but by later on in the day, yeah, that's when things change here. I think that low basically picks up a ton of moisture here. Notice the darker green, right? This is about 6 o'clock Sunday night. So really from Sunday afternoon, Sunday night, that's when we'll get in some rain. Wouldn't be surprised if there's a thunderstorm, hear a rumble of thunder or so. This is 11 o'clock Sunday night. Notice the leading edge is pretty much by Sunday night towards our west. That'll move on through for the wee hours of Monday morning. I think Monday will be fine, just maybe a shower or two in the morning. So my forecast for today, around 70 degrees, pretty much. That's where we'll hang our hat. That's pretty much above normal. And that'll feel nice, but it will be noticeably muggy outside with these showers on and off. Skies will clear, and although we're in the 60s earlier this morning and still are, 37 tomorrow morning. So yeah, it's a big difference. 35 up in Newberry. I don't think we'll be near freezing, but certainly chilly for sure. 63 on Thursday, 58 for Friday, a little cooler air, but again, that's pretty much on average where we should be. Saturday, Valentine's Day, 63 degrees, more clouds than anything else. The rain moves in Saturday night and then is with us for Sunday, pretty much all day, especially Sunday evening. Notice early part of next week, We're in the 60s, right? So no big Arctic outbreaks of cold air that I'm looking at anytime soon. So that certainly is good news, is it not? Let's look at traffic. That's not good. Situations on the roadways here. Sort of zoom in and take a look here. Well, actually, 3 of them have gone. Still one off of 77 and the other one just near 26 and 20. And a quick look at some of the roadways. You can see, again, everything's running fine so far this morning. That's the latest with weather and traffic.
Today's appeal hearing unfolds, there are still a lot of legal questions surrounding what happens next and what the court is actually needing to know in order to decide.
Yeah, and to help break it all down this morning, we are sitting down with attorneys Dane Phillips and Kyle Hobbs. They have no connection to the Murdaugh trial or today's hearing, but they are experienced legal professionals, and they're going to break it down this morning and tell us everything that we need to know. Thank you guys so much for joining us this morning.
Thanks for having us.
We could call them professors the way they're schooling us. Y'all are schooling us.
I'm taking notes over here.
Absolutely taking notes. All right, so we know that this is going to be happening pretty soon, in just a couple of hours. And so if you are the defense right now, what are you I'm always wondering, what are you doing the moments leading up to going in front of the Supreme Court? Are you looking over everything? Do different defense lawyers have different ways that they go about it? What is the strategy even the morning of?
So I believe everybody has their own way of doing it. It's very personal. Some people want to be somewhat removed and get their head right. Me personally, I've been there. I've argued at the South Carolina Supreme Court numerous times, as I said. I have my outline of the points I want to make, and I'm going over that outline. I'm trying to just make sure that it's, not a last-minute cram session, but you're really just going through the outline and making sure you have your points made, because as the justices ask questions, they're not going to follow your outline. And you just want to make sure that you can keep coming back to your points and hitting the highlights of the arguments that you want to be made. And so it's really just getting in your own head and making sure you have all your arguments laid out and how to get back there. If the justices' questions are trying to pull you somewhere else, how do I get back to where I want to be, what I believe to be the winning argument?
And when it comes to the purpose of this hearing, because they've already taken a look at all of those documents ahead of time, then we know it's going to be months until we get a verdict on this, right? Because they're going to be, again, looking at all of those documents again. What is the purpose of today's hearing?
Well, the purpose of today's hearing is going to be to hone in on the arguments. We've got a voluminous trial transcript. And then we've got even briefs, the appellate briefs and the response from the state are just huge in the amount of information, the amount of case law, the amount of facts that they are citing within them. So what today is a time to hone in on those issues, to identify the most important things that you want the Supreme Court to consider, and also give those justices an opportunity to ask those questions, to say, hey, I caught this thing in your brief, but I want to take you in a different direction. Would you clarify this? Would you expound on this fact? And that becomes such a crucial part of this process, is this moment in time where they can have that back and forth to ask those questions and hone in on these really significant issues.
And if this appeal doesn't go through, the next step after that would be federal, correct?
That's right.
What does that process look like?
So if Murdaugh loses, the Supreme Court decides to affirm the convictions and sentences, then the next step would file a petition for a hearing, which is basically just saying, we want you to reconsider and here's the reasons why. But if that's denied, the next step would be with the Fourth Circuit Court of Appeals, and then potentially up to the United States Supreme Court.
And when we talk about this trial in particular, what does this trial show in the public trust as it relates to the justice system?
Yeah, I think our judiciary realized the weight of this moment well before this trial started. Through the appointment of Judge Clifton Newman, a tenured and experienced judge who I think at that point had 23 years of circuit court experience. And then even when it came to a motion for a new trial, who do they call in? Retired Chief Justice Toll. They understood the magnitude of this moment. And while our judiciary would never intend to put their finger on the scales of justice, for them to show any partiality about whether or not this man should be convicted or not, they did want to have a clean trial. They did not want to do this thing twice. I feel very confident about that. And with everything within the judiciary's control that they could exercise, they wanted to be prepared for this moment so that this man had a fair trial, but that they did not have to relitigate this issue because of the amount of time and resources exhausted in this trial and the coverage that the nation has given to it. Our judiciary does not want to relitigate this trial at the end of the day, but they do want to uphold those rules of law and make sure that he, like every other member of our community, is entitled to a fair trial. And that's what today is for, is making sure that no one is above the law as they prosecuted him. No one is below the law either. So they want to make sure that the standard they apply to Alex Murdaugh is going to be the same standard that's applied to every citizen in the state of South Carolina who's been charged with a crime.
Absolutely. Now, they have already provided us with a wealth of information since they've been joining us at 7 o'clock this morning. And we know many of you have questions as well. So don't forget to text the number 803-776-9508. We're going to continue this conversation with our legal professionals, giving you an in-depth look at how this process works, what we could expect during this hearing, as well as what could happen afterwards, whether this appeal is granted or not. Again, my friends, just text that number on your screen, 803-776-9508, and we'll be right back.
Semi-wet morning. A lot of this is sort of well, what we call virgo. It's actually raining, but not actually reaching the ground. So the atmosphere's got to moisten up first before we get a lot of rain. So it looks impressive, but it is yet to really produce a lot of rain. That's going to be changing as we go through time here. So notice we have some lighter showers. We'll catch a break with some of this rain today, and then it will continue. So it's sort of on and off rain throughout the day today. If you're traveling I-77 all the way up to Charlotte, on and off showers. Same thing further down towards the south, Batesburg, Leesville, Gilbert from Lexington, some showers. I-20 east and westbound, a little wet as well. And some decent rain through Sumter, but again, I think a lot of this started off as what we call that virga in the atmosphere. Look at these temperatures, though. They're warm this morning, 63 in Columbia, 61 Lexington, 61 Bishopville, far cry from where we were just a few weeks ago. The wind's the big issue. Southwest at about 10 to 15 miles per hour. So that's going to be the case today. That'll bring our warmer temperatures. Futurecast starts at 10 this morning. As we go through the day here, these scattered showers will come and go. We will see maybe some peaks of sunshine. No big thunderstorms. Don't want you to worry about that. But certainly the rain will be on and off. There's 3 o'clock. Notice 4 or 5 o'clock. The rain starts to depart, and we should be done with the rain. So that certainly will be much needed rain, but good news because we'll get rid of it early, hopefully by the time we head home today. 60s. Pushing near 70 will be our high today. Again, notice we'll cool off tonight. That front will move on through and bring noticeably cooler temperatures. We're at 38 degrees coming up for tomorrow morning. 63 will be the high. Valentine's Day looks to be nice at 63 degrees. That's not too bad at all. We can certainly handle that as far as temperatures are concerned. But notice as we get into Sunday, an 80% chance of some rain by Sunday, with a temperature of 65 degrees. An early part of next week is looking nice. 63 Monday, 65 on Tuesday. Everything I'm looking at, I don't see any big cold Arctic air headed our way anytime soon. So that is certainly going to be a big relief. Let's do traffic this morning, get you where you need to be safely. And looking at traffic, we've got a number of accidents here. We can't get to all of them, obviously, for time, but let me get to the biggest one that's causing the biggest issue here. And this has been Killian Road off of 77. Killian and 77. That is, look at the backup there on Killian Road, so give yourself a little extra time there. Traffic on I-20, both at Broad River and I-77 rolling fine. That's the very latest. We're back in 30 minutes with more.
Hey everybody, here at ShopTVDeals.com, we love to bring you products that we've tested and we know for a fact are really the best out there. Now you see these things in my ears right now. These are everywhere now these days, earbuds. But the static earbuds, they give you something a little bit different that really could make a big difference in your life. What's so great about these two things, it's an open ear concept. Take a close look there. You can see it's not all the way inside the ear canal. And there's two reasons why that's important. Number one, after long-term use, something being that far in your ear actually can do some damage. And number two, most importantly, because it's open ear, it allows you to hear the outside world better, which is really, really important as you're working out to keep you safe as you're kind of jamming along to your favorite music. What I also love about this product too is check out the case. It charges really, really fast. At a full charge, these earbuds will last you for days at a time. And let me let you in on a little secret. The whole time that I've been talking to you, I've actually had these earbuds going in my ear with real music from my phone. So don't tell anybody, but that's how good these things are. And we have a really great deal for you on these earbuds. You're gonna get 33% off and get these for $39.99. That is a really nice deal for a pair of not only effective and sleek looking, but safety minded earbuds. Can't beat that. So scan that QR code at the bottom of your screen or check us out at ShopTVDeals.com.
Good morning from the South Carolina Supreme Court. I'm Christy Calcagno. We have been live out here all day across from Gervais Street and showing you right before the doors are going to open, right before the Alex Murdaugh hearing. Let's go ahead and take a live look of what this line looks like right now. We started at around 7 o'clock this morning and there was about 30 people to now more than 50 people are in line waiting to be having a first row seat to the next part of the Alex Murdaugh trial. Now, this has been going on for years, right? Exactly how did we get here? Well, we do know is that Alex Murdaugh was convicted of the murder of his wife and son. And then there were multiple cases surrounding now getting to here involving the clerk of court, Becky Hill, as well as financial crimes. And those two cases are exactly why the defense is out here to argue today, to see if there needs to be a new trial. Again, first was the financial crime should have been brought up at all during the murder conviction. And because the judge at that time, Clifton Newman, did let it in, are they calling that now for grounds of a new trial? And then also what happened with the clerk of court, Becky Hill, who pled guilty to not only perjury but obstruction of justice involving that case as well. So those are going to be the two arguments that we're going to be hearing from Dick Harpootlian as well as his defense team. And then on the state side, we're going to have Creighton Waters, who's going to be representing the state. Already here since the past 2 hours that we have been out here, our colleague Kiki Gushu is actually in that line. When it started to get about 40 or so people, that's why we had her take away from this live shot and go out and get in that line. Here's the reason why she's getting in that line. Just to reiterate, space is extremely limited. Less than 100 people are going to be allowed inside that courtroom, not because of their limiting that, but it's just because of how many seats are in there. It looks like my photographer just go ahead and said that the doors are officially open. If you guys can see through the pillars at this point now, they are going to be checking everybody in one by one to make sure that they are getting ready to be seated before the hearing starts at 9:30. Here's what's interesting. We were able to have a conversation with the people who are already in this line. So not only are they already prominent attorneys, not the ones that are going to be at this hearing today or any of the Supreme Court justices, but we're talking about prominent attorneys who may have their hands with maybe victims in previous cases or anything that they just wanted to be sitting in and witnessing this. But not only are we seeing attorneys, and we're also seeing members of the media, we are also seeing people who they said just wanted to witness history. Here's what two Clemson University pre-law students had to say about why they got up so early to stay in this line.
Awesome. So first question, hard one, your first and last names and how you spell them.
Okay, Morgan Stone, M-O-R-G-A. We're a part of the Clemson University Pre-Law Society, and so we've come here bright and early. We left at like 5:15 this morning to come and watch this trial, and well, I guess just...
Yeah, I wanted to give the opportunity for our students to come in and sit on this trial. I think it's really important for even undergraduate students, especially at Clemson, to sit in on something so important for the state.
Are you all from South Carolina?
I'm not. I'm from North Carolina.
So did you grow up, I mean not grow up, but have you been following this case for a long time?
Yeah, I've been following, I'm from Savannah, Georgia, so not South Carolina, but obviously near like Beaufort, Hampton County area. I've been following this case since 2021 when everything happened, so I'm really excited to be here and see what happens and what's revealed and said. Yeah.
What are your expectations for today?
Oh goodness, I guess just kind of my expectations going in as someone who wants to be a law student is just to learn more and just also kind of like see it firsthand, such an infamous case just for the state of South Carolina. I'm excited to see how it all works out. I haven't been able to sit inside, especially Supreme Court, so excited for that opportunity.
And so what do you think is going to happen?
I'm not sure. I don't know what to expect, to be honest. I'm just here to get the experience, and I've never been to the Supreme Court before, so I'm really excited. South Carolina Supreme Court, so yeah, I think I'm just here for whatever is revealed. Yeah.
So that was Kiki Gushu actually doing that interview with those two pre-law students from Clemson University. You can actually see a close-up right here across from Gervais Street where she is standing right now with those pre-law students as she is gearing up, getting ready. As we just mentioned, the doors are open. Taking a little bit more of a wide shot here, as you can see how long this line is as well. It already wraps around the building. Again, as we've been mentioning, there's only 100 people who can get in at the time. Actually, what you you can see right on over here, if we can pan onto it, it looks like a trooper is talking to all of those people, just saying, hey, you know, there's not really going to be a lot of seats on in there, but just go ahead and do what you need to do. See how many we can get on in here, how many we can get in here, and what the process is going to look like. So it looks like there are 3 troopers that are going to be out here conducting this, and the doors, as we mentioned, just open at 8:30 this morning ahead of the trial that is going to begin, the hearing that is going to begin at 9:30. All right, we are going to be wrapping up here over at the Supreme Court. Again, you can follow us right here on WLTX, WLTX Plus, and of course WLTX.com. We are going to be live streaming the entire hearing as it begins at 9:30, and you've also been hearing from a bunch of attorneys across the Midlands who have been there over in our studio breaking down your questions. But this is going ahead and give you a look on over there as well. You can also see Joe McCullough out there waiting in line as well to get his seat, if you all can see that on over there. But yeah, a lot of people getting out there, being able to want to have what, of course, those students over at Clemson University said they wanted to be a part of this. All right, I'm sending it back over to you guys in the studio, reporting live here at the Supreme Court of South Carolina. I'm Christy Calcagno.
All right, Christy. Well, thank you so much for that report. We are back in studio this morning speaking with our attorneys this morning that have no connection to the case, but they are the professionals breaking down everything that we need to know, any questions that we have and any questions that you have. And we're actually going to take some of those questions now that you guys have texted in to us this morning. So we're going to pull those up now so we can ask. So first off, here's our question. Why did Alex Murdaugh decide not to be present for today's appeal hearing, especially since he was present for the previous appeal hearing presided by Judge Toll?
Easy question, or easy answer. It's not his decision. So for standard oral arguments, defendants, or at this point, the appellant, they are never brought to the Supreme Court or the Court of Appeals for oral arguments. It just does not happen. So it's not his choice.
Absolutely. And I want to talk about the appeals process and how we got here. It was one of one was into question of, jury tampering. Do we see misconduct from court folks, or is this truly a rare one-off?
I think it's a pretty extraordinary and rare circumstance. You've got inappropriate conduct alleged by Becky Hill in her communications with the jurors behind closed doors. And in this particular instance, even the state admits that her communications were inappropriate. Dana and I were actually talking during the break about some issues here and wondering if this would have happened in other counties, if other clerks of court would have been caught up in the moment so much that they would have made such a big error in communicating. And as the Chief Justice Toll has stated, the moment was so big for Becky Hill. She saw this opportunity to make a name for herself, to publish a book and profit. And I think they even said maybe she was trying to buy a lake house, right? So that moment was so big that she got caught up in it and did something inappropriate. The state agrees and even admits that what she did is inappropriate, and it is extraordinary. We don't see this kind of conduct happen very often, but we also don't see Alex Murdaugh's kind of trial come up in South Carolina very often either.
That's true. And speaking of Becky Hill, so one of the questions that I've been seeing a lot is people are saying, well, if she didn't get, if she wasn't found guilty for jury tampering, how can they then argue this case that she was involved with jury tampering in front of the Supreme Court?
So they made clear in her recent guilty plea that it had nothing to do in connection with the central issue, the hard issue that we're dealing with here. However, we do have the affidavits. There's some jurors who say they didn't hear anything, some jurors who said they heard those comments, but it didn't affect the verdict. But then you have that juror Z, whose affidavit said she made the comments and it did affect the verdict. And so that is the cornerstone of the appellant's argument in proving the prejudice. Go into what you asked a minute ago. That's the State versus Green, the state case that they're going to talk a lot about. Deals with a bailiff making a comment, and that's where they kind of deviated from the standard. So these things happen, but it's very rare. Offhanded comment by a bailiff. It's such a unique situation to have a clerk of court who knows they're not supposed to make any comments to a jury about the case at all. And so I think it's unequivocal that there were comments made. It's all about, again, the prejudice. So it's all looking at that affidavit from Juror Z and former Chief Justice Toll's decision about the credibility of that affidavit and how they're going to determine that.
I think when we talk about appeals, too, when we talk about this case in general, it's so many rare instances, the popularity of it, the situation with Becky Hill. How rare is it, speaking of that, for an appeal to be granted?
Very rare. If you're looking nationally, it could be 3%. It's such a small amount of cases that get reversed on appeal. And it has to deal with, it's just, you don't have legal issues that go to the prejudice of it, that affect the outcome. There's many cases that the appellate courts find that there's been error, but they find that it's harmless error, that it didn't affect the outcome. So it's very few cases actually get reversed and remanded for a new trial.
And how much power does a clerk of court actually have as it relates to the integrity of a trial?
Well, the clerk of court is integral to so many processes within the trial, right? They have this record-keeping function, they have this administrative function, and many times the clerk of court is the face of the court administration at a trial, sometimes dealing with the jury, sometimes ushering them into the jury room, making sure that they have refreshments or anything that they need. So she had that exposure to the jury, and that exposure is a big part of her job and her responsibility as a clerk of court. So what she did, again, was clearly out of line, was clearly beyond the scope of what she should have been doing, and she should have known better than to make these comments to the jury, especially to the extent that one of the jurors says it affected their verdict. It affected the way that they viewed the case and the verdict that they rendered. But she had so many functions throughout this trial. She was intimately integrated in it, and she had that exposure and that access to the jury that so few people would have had. And again, we would say that she was inappropriate and she abused that access.
And moving forward, do you think the courts will, on down the line, put some type of something in place where a mistake like that can't happen again? Maybe have two clerk of courts?
No, again, it's such a one-off, such a rare situation. I actually had a case right after Murdaugh with Judge Newman that was on Court TV in Colleton County, and this was right before she ended up getting arrested and charged. So I was able to even interact with her right after the Murdaugh trial myself, and it's such a unique situation where the clerk of courts, we talked about being professional, they know their role, they have sworn duties. This is a very serious job, and they know they're not supposed to be making comments to the jury. And I know Ms. Hill has testified that she denies making those specific comments, but there's not going to be any other procedures in place because it is such a serious nature that they know that they could be found in contempt. They know they could be charged with misconduct in office. It's, again, as we said, everything is a unicorn rare type situation in this case.
When we are talking about what this morning or this afternoon's hearing is going to look like, really this morning into this afternoon, can you walk us through what we can expect? Because for a lot of people, it's going to be their first time watching an appeal hearing in front of the state Supreme Court. So what can we expect? What will that look like?
Yeah, so the appellant will go first. They are the ones bringing the case. So they will, I would imagine that Dick Hartpillion will be the one addressing the first issue, basically the clerk of court issue. So he will be the first up. He'll have his 20 minutes. We discussed this off air, that what happens if the time goes out, it will keep going. If the justices have additional questions or he's in the middle of answering a question, they will absolutely go past that time. This is not a set thing. It is their court. They control it. But he will have his opportunity, his 20 minutes, to present his side. I believe it'll be what we call a hot bench, where it's not going to just be him giving a speech. He's going to get out a few words, and I think they're going to start bringing the questions that'll dictate where the arguments go.
And one of the other questions that I have is specifically about Alex Murdaugh. Earlier, we explained that he will not be in court, or he will not be at the Supreme Court for this. Are the defendants in the trial, or in the hearing, are they allowed to be taken somewhere to hear this, or do they just wait for a phone call from their lawyer? Like, where will, if we can know, where will Murdaugh be while this is all taking place? Like, we can watch it. Do they set him aside, or how does that work?
Generally, no.
Okay.
I mean, they're not in a position to watch it live, even though now they have this for all the oral arguments. This is not something unique to Murdaugh. They actually stream all the live through ETV. Oral arguments are streamed for the public. It's just unfortunate that they're not able to watch their own oral argument. I had one at the Court of Appeals just recently, and that was the big question the family had. Can he be able to watch? And unfortunately, no.
And can simply planting doubt about jury interfering, is that enough to win this appeal?
I don't believe so. I genuinely believe that Chief Justice Toll, or retired Chief Justice Toll, was fully aware of the direction that this was going. There were some curveballs brought in as far as Juror Z, and some of the things that she said was conveyed to her by the clerk of court. However, the standard that Chief Justice Toll was going to apply in the motion for a new trial was well established before the hearing actually started. They had contemplated whether the United States Supreme Court precedent was going to hold, or State versus Green was going to be the controlling law for this hearing. And she was very much aware of the direction this was going to take, and also very much aware that whatever ruling that she made was going to be challenged. And so we are here at this point to look back and say, okay, when she assessed the legal parameters of this hearing and the standard that she was going to apply, did she apply the correct standard in that particular hearing? And that's going to be a huge issue today, and that's probably going to be the primary focus of the jury tampering argument is, hey, did retired Chief Justice Toll look at this legally in the correct manner and make the right decision in that hearing to deny the motion for a new trial?
And if you were up in front of the justices, how would you tackle today's task?
Oh my goodness. Well, you have to recenter yourself on the issues and hammer home what you're trying to convey to them as the most significant and strongest parts of your arguments, right? They're going to be asking you questions, and they're going to be peppering you with questions and kind of taking you off track. You have to recenter. You have to refocus to make sure that you're coming back around to the points that you need to convey, the most important points. Again, we have briefs that are 130, 180 pages long. We have a trial transcript and volumes that are 8,000 some odd pages. You have to focus in on the most important things because you have such a limited window to convince them and convey that important information in this moment in time.
When it comes to the arguments that will be made by the defense, we've talked a lot about the jury tampering. I also want us to speak too quickly on the financial crimes, because that's a big thing here. Is one of the things that the defense is saying is that, yes, some of the financial crimes should have been talked about, but not as many as were presented. And so can you speak to what we're looking at when it comes to the argument for the financial crimes?
Yes, and I've said this on Court TV back when the trial was going on, is that sure that some of it absolutely was admissible. It just needed to be limited in scope. 2 weeks worth of testimony, improper character evidence testimony is the way defense attorneys argue it, it's just too much. I mean, they went into each individual case and went into very specific details, all having very minimal to zero relevance of proving any of the elements of the charge of murder. They had maybe 2 days worth of what I would argue is relevant testimony of the office manager finding the financial crimes, confronting him of the financial crimes, his reaction, the temporal, the timing of everything. All of that is relevant. So I think maybe several days, several witnesses worth, but 2 weeks worth was just beyond the scope, because the relevance of it versus weighing the danger of unfair prejudice, where it's all about just his character, that he's a liar and that he is a crook, he's a cheat, a thief, all the things, all the bad names. Because I think I said one of those nights on Court TV was, they're going to bring somebody if he stole somebody's money in middle school. I mean, they literally went to everything he had ever done wrong during those 2 weeks instead of having anything. There's 2 weeks of testimony that had nothing to do with the murder case.
When it comes to the two arguments that the defense will be presenting, which one do you think is stronger?
The clerk of court issue is such a unique issue. That's the one, that's the reason why it's number one. You put your strongest argument first and you outline it from there. That is such a unique issue, and it's one that has a constitutional standard. And this isn't a federal case. Earlier I said we'd go to the Fourth Circuit. That's not true. You'd go directly to the United States Supreme Court because we're in state case with a constitutional issue. You have all of the major themes there that says this is a reason why he should get a new trial, and at the heart of all of it is making sure he received a fair trial, regardless of whether you felt like the verdict was correct or whether he did it. It's all about ensuring that he received a fair trial so every person accused can receive a fair trial.
Based off, oh, I'm so sorry.
No, you're good. Go ahead.
Based off of what you have seen, what you have heard, and based off your knowledge of the justices, what do you think the outcome will be?
I'll tell you my personal opinion.
That's what we want, your personal opinion, yes.
My personal opinion is I believe he did not receive a fair trial. Juror Z's affidavit for me is enough. She said the comments were made and it affected her verdict. You got to have a unanimous jury verdict. If not, it's a mistrial, a hung jury. So I believe prejudice presumed, regardless of the standard. We take away the legal part. Was there prejudice? Would it affect the outcome? Answer is yes. So regardless of whether the standard was used, we have the prejudice. Also on the 404B, the 2 weeks of financial crimes, to me, is just off the rails, too much. You got other issues that were raised. When you look at the appellate record, to me, the scales were tipped to where he didn't receive a fair trial, and he deserves a fair trial, regardless, again, of where you think morally or personally about him and the evidence, but it's about the legal standpoint, and we don't need to create a standard of a slippery slope of allowing clerk of courts to somehow inject themselves into trials or to turn a blind eye to injustice.
And if the justices feel the way you do, and this appeal is granted and a new trial happens, what kind of backlash could Becky Hill get for that?
Oh my! I mean, you imagine her whole life has been turned upside down.
Yeah, absolutely. I mean, if this is truly the issue that sends it back for a new trial, and it solely points to her and what some might say was selfish conduct, self-serving conduct for her to profit off of this circumstance, I imagine that there's going to be a lot of repercussions and a lot of backlash over that.
And could anything legally happen with her in that, if that were to happen?
I mean, she's already been unrelated to the specifics,
right.
but she's already been charged with misconduct in office, already pled guilty. I mean, would they go and charge her again? No. I think, unfortunately, she's in many respects destroyed a lot of part of her life and credibility and all the things that, obviously from a defense attorney standpoint, I have empathy. I hope she is able to correct her wrongs and do the right thing.
And our final question, we have just a few seconds left. Do you believe that this hearing and moving forward, whatever happens with this case, do you think it will still garner as much attention as the original double murder trial?
I think that this has been something that has captivated everyone from the start. Before the trial, before Alec was even charged with anything, the nation's eyes were on this case and this circumstance. And it goes all the way back to the boat accident with Paul, the history of the Murdaugh family in this community, their legacy, and just the nature of this has been so captivating. It's hard to imagine that this next stage and whatever comes next is not going to be the same.
You can't put the genie back in the bottle. I mean, at this point, everybody's all in. Between the TV shows, the documentaries, people are riding this one to the end. And so I'll be interested to see where it goes.
Absolutely. Well, thank you guys for joining us in the studio this morning. And we're going to have so much more coverage on this Alex Murdaugh appeal. We have Christy Calcagno live outside of the courtroom, and she's going to break down everything that's happening down there. But we're going to be right back after this break.
Good morning. It's 8:55 on Wednesday morning. Let's get you your weather and traffic this morning. We'll start off by looking at our Doppler radar. And we've had some showers move on through. This looks far more impressive than it really is. What we're seeing a lot of is virga. And what is that? It is rain, and the radar's detecting it, but the time it reaches the ground, though, it pretty much evaporates. That's because the air hasn't moistened up quite yet. It will as we get through the day, I promise you that. Zoom into town here. So the showers have moved on through very, very light, if some of this is reaching the ground. That one last shot towards Pillion and Gilbert, little shower activity. I-77 is going to be sort of a wet ride between here and Charlotte, really. It's going to be pretty much the case all morning. I-20, pretty much same thing. Showers through Batesburg, Leesville. Again, these are getting very, very light showers. And off towards the east we go, maybe Sumter to Manning. A few little showers there as well. Temperatures, 63, our current temperature reading. It's a mild morning, no doubt, with these southwest winds that are blowing around 15 to maybe even up to 20 miles per hour. So it will be a windy day. There's no doubt about that. Futurecast starts at 10 o'clock this morning. Pretty much matching radar now. You can see the showers that'll be moving on throughout the day. There's noontime. So lunchtime, a shower here and there. Not going to rule out some sunshine. That certainly is possible, but I think for the most part, we'll see partly cloudy skies and then clearing skies as we get to the nighttime hours for sure. And then temperatures will start to cool down as that front moves on through. So here's the forecast for today. We're looking at really mostly cloudy skies, on and off showers, but it will be a mild day with these temperatures again, upper 60s to around 70 degrees. That's pretty nice. 7-day forecast brings in the cooler temperatures as we get in towards tomorrow. Again, not colder, but just cooler. Valentine's Day, showers late. Much of the day will be dry. Our next decent chance of rain comes Sunday at 80%. All right, let's have a look at traffic this morning and see how that's doing. Again, a number of accidents. I'll just show you the big map. We can't get to all of them. Just extra caution because some of the roadways certainly are wet this morning. Look at them. There's quite a number of them from I-20 even up near Killian Road. Broad River and I-77 and I-20, everything's running fine. That's the latest with weather and traffic. We're back at 12 noon. We'll see you then.
Hey, good morning, everyone, and happy Wednesday. I am right now live outside the South Carolina Supreme Court. As you can see, the doors are actually closed right here behind me. What started as multiple people waiting in line, as the line wrapped around the building there, it looks like the doors are going to be closing in. Actually, a little less than 10 minutes ago, I would say, I did see Dick Harpootlian walking into the South Carolina Supreme Court. It looks like they're just making sure that people are out there, getting those last-minute people in and shuffling everybody here. Just wanted to kind of break down what this is. Again, just as a quick reminder, this is not a trial. This is all a hearing. That is when the defense is going to be bringing up any type of issues that they said happened during the murder conviction trial and then pushing for a new trial, while the state is going to say and going to argue that there is no means for a new trial. But that's all up to the South Carolina Supreme Court to decide. But a lot of questions that we've been getting so far is, are we going to have an answer right away? Is how long is this going to take? Well, I can tell you that this does not take very quickly. So the court rarely does rule from the bench. Just wanted to put that out there. So after the arguments, the justices will then deliberate internally, and then a written decision will then come later. So that could possibly take weeks, if not months, all depending on, of course, the complexity of this. And as you know, there are already thousands of documents involving the Alex Murdaugh trial. So that is something that the state Supreme Court has already looked at. They looked at those documents. So that's why there's no new evidence. There's no new witnesses. There's nothing new that the Supreme Court is going to hear from. Just in that 20 minutes each time for each of those issues, they're going to be asking questions. So it's 20 minutes on each side and then another 20 minutes for the other one. So, and then they're going to have 10 minutes in total. So it's only going to take about like an hour and a half. It's really going to be wrapping up. That's how quick this is going to be. So there is no specific deadline as far as when there is going to be a decision, but decisions are of course released as written opinions through the South Carolina Judicial Branch's opinion system, which is then published for the public to read. So that's where we're going to be waiting on. So this is what could happen. If the court affirms it, then the conviction stands. If the court orders a new trial or other relief, the case then goes back down to the lower courts again for the next steps. So it's pretty windy out here as I'm stepping out of the way here. Again, you can see that the Supreme Court here definitely a lot more empty as they are gearing up for that 9:30 hearing that's going to be starting in just a little bit. Already the media has been out here just like us since as early as 7 o'clock this morning. We have tents underneath us. We have a bunch of crew out here and they're gearing up. So at around 12:30, when all of this is over, Gervais Street is going to be crowded with people. So that is a great thing to just put on your radar. If you do have to go at all in and around the downtown area this afternoon, just make sure you have plenty of distance because people will be stopping. We've already been having a lot of people stopping by, honking their horns, and just asking what's going on. But of course, we will be keeping you updated both here and online at WLTX.com. As always, we'll keep you updated with what is going on inside the courtroom as well as once it is ending as far as any press conferences that we're going to be hearing from both sides. But for now, live here at the South Carolina Supreme Court, I'm Christy Calcagno for News 19 WLTX.
As today's appeal hearing unfolds, of course, still a lot of legal questions surrounding what happens next and what the court is going to actually decide. A lot of miscommunication about that as well, I've been seeing on social media.
Oh, yeah, and to help us break it all down and give you the facts straight up and down, we have attorney Dane Phillips and Cal Hobbs. They have no connection to this case or the appeal, but they are professionals. They're teachers, and they're giving us everything we need to know this morning, from every question that we have to every question that you guys at home have when you text in and send it in. And we're just so grateful that you guys are able to join us this morning.
We appreciate the opportunity.
Yeah, thanks for having us.
Absolutely. Now, are we expecting to see today, we think maybe the fanfare that we saw around the double murder trial? Are y'all expecting to see that today with everybody talking about it?
Certainly outside of the court, yes. Inside the court, it is very formal. There will be no circus, no outbursts. That will be taken care of very quickly. There is a set order of things. It's very traditional. You'll hear a pin drop outside of the individuals being asked questions. So there should not be any craziness going on. But I would imagine that there's a bunch of people that are that were wanting to get in that maybe limited seating, right?
So what do they tell the folks who are actually going to be able to be in the courtroom during the hearing? Like, what are the rules for them?
Oh yeah, I mean, it's no nonsense atmosphere. I mean, these are our best of the best judges in South Carolina sitting as justices in the Supreme Court. This atmosphere is as serious and as formal as you are probably going to see in the judiciary system within South Carolina. So there's no room for outbursts. There's no room for making noises and hemming and hawing, and there are strict rules and strict enforcement of those rules about the professionalism and how things are going to be conducted in that courtroom here today.
And you actually spoke about when the justices arrive in, that there's like I don't want to say ritual that kind of happens, but tell us about that for folks who aren't able to go inside of the courtroom.
I'm not sure if they'll show this on the live feed, but the justice will come out in the order of their seniority. There's a very formal, traditional process. We won't use the word ritual. Sounds interesting, but yes, they will come out in the order of the seniority. They will have their waters placed in a certain way in these silver glasses, so to speak. But it'll be interesting if they show that in live feed. But when you're there, it certainly sets the stage of how serious, how formal, how professional this is. That this is, in Latin, you'll see above them is the seal. Nil ultra. This is the highest court in South Carolina State Court, and so it sets the stage for it.
We talked a lot about the defense's strategy going into today's hearing. Let's switch sides now, my friendly defense attorneys, and go to the prosecution side of things. How are they preparing for this hearing?
The same way, just hours of combing over the cases, honing in their arguments, making sure that they, within that limited period of time, if attorneys could do it, they would talk all day. That's just the nature of it. So they have to hone in on these issues, be prepared and anticipate the questions that they're going to be receiving, and then really focus in on what they want the Supreme Court justices to hear. Now, part of the state, as opposed to the appellant in Alex Murdaugh, they're going to be focused on whether or not things were properly preserved for appeal, whether or not they were raised appropriately before the court. And so they're going to have another spin on it where it's like, sure, we disagree with their position, but we don't even think they preserved this issue. We don't even think that they presented this appeal in the appropriate manner for y'all to even consider this issue. And I think that's what's lost on a lot of people from the outside perspective. They're not coming through every mistake that was made in this trial. These issues have to be preserved. They have to be contemporaneously objected and ruled on in an appropriate manner, and then they have to be raised on appeal. So the state, from their perspective, is not only beating up these factual allegations that Alex Murdaugh's team's bringing, they're also going to be saying, hey, justices, we hear them, but they can't even bring up that issue because they have not raised it properly. It's not properly in front of you.
When we speak about the defense, going back to the defense, let's say, a retrial is granted, are they allowed to bring in new theories?
So they certainly can. What we've said is they're not going to be bound by the arguments previously made. They can call different witnesses. They can have different strategies. There are different theories of what they believe to be, as far as prosecution and defense. If we have a new trial, it is wide open.
Okay.
And as a defense attorney, do you feel it would be the best strategy to come at it from a different angle?
It can't be completely a different angle.
Right.
He testified, so they're locked in to many different things now because he did decide to testify. Because your cross-examination can certainly move the needle one way or the other. But from a factual standpoint, he did testify. Now he doesn't, in a new trial, he would not have to testify. It would still be his decision whether to testify. But from a strategic standpoint, I believe both sides will do things differently. They'll see what worked, see what didn't, and believe what, from a game plan standpoint, what they believe is the most strategic way to present the case to the best of their ability.
And with your experience, watching this trial or, hearing the results of this trial, if the incident with Becky Hill had not happened, what do you think would have happened?
I think that the evidentiary issues that are going to be presented to the court today are much less likely to succeed than the issue of jury tampering, that retired Chief Justice Toll heard in the motion to reopen. So this jury tampering issue, as it's been separated and put into the forefront of the arguments, I do believe it is the biggest issue that's going to be before the justices here today. And while there are some evidentiary issues about the scope of the financial crimes that were presented, I do believe that the weight of this decision here today is going to be focused around that jury tampering and the actions of Becky Hill.
And speaking of Becky Hill, one of the questions that I've been seeing is, will she be at the hearing today? We know that she will not be. Can we explain why?
Well, one, she doesn't have to be there. I can assure you the South Carolina Attorney General's office doesn't want her anywhere near there. But she would only kind of put a spotlight on herself. There's no way she would be there. I would be shocked if she's anywhere to be found today while this is going on. But as to the other issues, we talked about these evidentiary issues. Again, they have more than just these two issues we focused on. They've raised an issue about whether the government improperly commented on his right to silence. They've raised issue about whether there's been improper expert witness testimony in multi different ways, and whether there was unreliable firearm testimony presented. So there's a lot of other issues. I'll be interested to see if the justices decide to go down some of those side roads of what we consider not the major two issues, and how much time gets put and placed on those other issues. That'll be, I think, the most interesting thing for the lawyers who have read the briefs, is how much time gets focused on the two, not the two primary issues, but the kind of the sub issues.
And just at the end of the day, is today's appeal more about one man's convictions, or is it about the integrity of this entire ordeal justice system?
I think the short answer is it's both, right? This is very much attuned. Everything that's happening today is about Alex Murdaugh. However, because of the scrutiny, because of the spotlight that's on this, I do think that the judiciary appreciates the gravity of this moment, in that Alex Murdaugh should not be treated differently than any other citizen who is in front of them with an appeal who has been convicted of a crime. So I feel that while, of course, this is Alex Murdaugh, that's what the coverage is all about, because of the sensational nature of his charge and of who he is, our Supreme Court is going to be focused on upholding those standards, upholding the standards of justice, and making sure, again, that whatever they do is fair and just across the board for anyone that would be appearing in front of them, and anyone who's been convicted or appealing a crime.
And I know some people may be just joining us, and you spoke about this earlier, but if once we finish with the appeal today, it isn't a decision made right off the bat?
Unfortunately, no. It's going to be several months, and it depends on whether there's dissenting justices, because they will be writing their opinion that will be responding to the majority. Majority will then modify their opinion to respond to the dissent. This will be a painstaking process for their law clerks, for the justices, as they write their opinions. It'll be interesting to see. I assume, given the high-profile nature, that the Chief Justice will be the primary author of the opinion. That's not all. The author of an opinion doesn't have to always be the Chief Justice. It changes. But I believe in this case it certainly will be, given the high-profile nature of it. But it will be months, I would imagine, before we see an opinion.
And kind of break that down for me, because you were talking about one justice will write this, and then explain exactly what that means.
Yeah. So we have the 5 justices, and the majority wins. So, whether it's 3-2, 5-0, ultimately the justices will have their opinion on each issue, and they will go into a room essentially and start giving out. They already have read the 8,500 page record on appeal, the 100+ page briefs. They know this case backwards and forwards. They've put in the long hours, and it's all about them sitting down and saying, all right, here's my position on these issues. They'll get basically a read of the room, and it'll start the process of where basically the vote is. And then once that kind of gets set in stone, then they start writing the opinions. And if there's dissenting justices, ones that disagree with the majority, they will decide which justice will be the primary author, and sometimes they'll maybe even break off and have multiple dissenting opinions. So you can have more than one, and you can even have concurring. Even in the majority, they may not all agree on it. It may have what they call concurring opinions. So you could have multiple justices writing their own individual opinions, and this could be a very, very lengthy opinion with multiple justices providing their perspective on this. And given the high-profile nature and the serious constitutional issue that we have, I could see that happening.
And I want to make sure that I understand what you're saying. So, the justices will go into a room and they'll begin to write their opinions. So when you say it could take a long time, does it mean in the sense of that at this point, one justice change their thoughts or another one change their thoughts?
They could.
How does that work?
They could change their position. I would say for the most part, they're pretty deeply rooted into what they believe the law is and the way it was interpreted. There's maybe some nuance and context that can push them one way or the other, but I would imagine they're pretty deeply rooted in their belief of whether the law was applied correctly or not.
And that speaks to why this hearing is so important, because I think they have their idea, and then those questions that they ask really are going to help solidify or change what that opinion could be. So that's one of the reasons why we're having a hearing, because a lot of folks are like, all right, so they've read everything, they've seen everything, so why are we doing this? But again, it's a chance for both sides to present their arguments. Now, speaking of this Murdaugh case, I mean, how often do we see cases like this in South Carolina?
We certainly have had some high-profile cases, and I'm sure that y'all have covered plenty of them in South Carolina, but something about the Murdaugh family and something about the nature of how this all played out has just been extraordinary and on a level that, honestly, I don't think I've ever witnessed here in South Carolina. We've got the documentaries, we've got series, we have just a countless number of coverages and interpretations of this story. And again, it's something captivating. It's something about this particular situation, and I think a lot of it has to do with the legacy of the Murdaughs within the community, this power, this idea of the fall of somebody from grace and from power. And I can honestly say I can't think of anything that really parallels to it that we've seen here in South Carolina.
Feels straight out of Hollywood. I mean, it's just so many different levels to it, that unique rural area, dynasty of great-grandfather, grandfather, everybody having, it's just literally, like you said, a made-for-TV movie, and unfortunately it played out to this point. But yeah, it's unique. I think you can't recreate this.
And with everything that you guys just said, in the event that this appeal is granted and we start a new trial, because Alex Murdaugh is a household name, how hard would it be to get an impartial jury?
The jury selection process is going to be extensive. Going through and making sure that each juror says they can set aside what they know about the case and be fair and impartial. They'll have to be sworn under oath and say, given what you know about this case, can you base your verdict solely on the evidence that's presented, and can you be fair and impartial to both the defense and the prosecution? Each one will have to answer that, because it's going to be impossible to find jurors who don't know anything about this case. I mean, there'll be some, but that would be very rare.
And I've only seen a jury selection process once, and I was the media at the time, so of course I was not allowed in the room. But when these folks go into these rooms and they're sitting there and they're having this conversation, what other questions are asked to them to make sure that they could actually be fit to sit as a juror?
Well, there are a series of standard questions that are asked from the court to make sure that jurors are qualified, make sure that they don't have any connections to the case that would be inappropriate, and those questions are just standard issue. In a case like this, I believe that the court would entertain much more extensive questioning of the jury, and the biggest question at the end of the day is, based on what you're telling us as questioning these particular jurors, can you be fair and impartial? Can you put this aside? Because it is going to seem like it's almost impossible to find people who aren't somewhat aware of this case because of the coverage. So again, can you be fair? Can you be impartial? Can you put aside the things that you think you know about this case and listen to the evidence that's presented from the from the witness stand and the evidence that's presented in the court, and not bring in all this baggage of what we think we know, what we've seen on HBO or wherever these shows were showing at. So again, they have to put this aside. It has to be fair and impartial, and they have to affirm that to the court to make sure that they're not going to be swayed by any of this information they carry in.
Well, bringing it back to the hearing, because we don't even know if we're going to get to that retrial, right? So let's bring our attention back to the hearing. Do you think that the amount of attention that this case has received, does that hurt or help either the prosecution or defense heading into this hearing?
Both. It's a unique thing in the sense that it helps the appellant, it helps Murdaugh, because when you have this many eyes watching the case, that puts intense pressure on the court to make sure that that opinion is, it's going to be the best that they can put out, best product, so to speak. But it's also weighs heavy on the prosecution side because it points out a lot of the things that otherwise the public wouldn't know about. I think that's what's so great about the fact that this is a high-profile international case, because it gets, as lawyers, it gets the public to see what we do for a living. It's not this TV style where they're getting force-fed things that aren't true. They're going to be able to watch what a true appellate oral argument is from the South Carolina Supreme Court, and that is a net positive to me, in my opinion, for the public. Specifically South Carolinians. They get to see how our justice system works, and they get to actually see it play out live on a case that they've followed. So I think this is a great thing.
And then you're speaking about like TV and what we've all learned from, Law and Order. Had a lot of nights watching Law and Order. So what are some misconceptions that you would like to clear up about what is taking place today when it comes to the hearing? Anything you may have heard or seen on social media or people talking about, and you're like, that's actually not going to be happening?
Well, I think that the format of what's happening today is going to be very direct. It's going to be very legally focused. And I think that a lot of people want another trial of the century to go on today, and our Supreme Court doesn't operate in that fashion. This is going to be very direct, it's going to be very structured, it's going to be very legally focused. Certainly there'll be some commentary on the facts and the evidence produced at trial, but there's going to be a lot of very specific and complex legal issues, constitutional issues, that are addressed today that the public might not find as sensational as the trial itself.
And I kind of want to go back to what you were talking about how South Carolinians will get to see, how everything plays out as far as this this hearing goes today. I want to go back to years ago before we could get into the live streaming and the different things like that. I mean, it was just through like word of mouth, or they just had to watch the 5 o'clock news to see what happened in the courtroom. How would you say with the new digital age, how is this putting more integrity into the court system now that folks can see it live as it's happening? All of the questions that the justices may have for whoever.
The legal community is not in agreement on this. There's certainly one camp that does not like cameras in the courtroom, believes it causes nothing but problems. I'm in the camp that I like transparency. It's like police with body-worn cameras. Mm-hmm. If you can see it, I can assess what I'm seeing with my own eyes and ears and determine whether I like it or not, right? In other words, is this procedure proper? Is this what's supposed to be happening? And the fact that transparency, if we didn't have cameras in that courtroom and seeing the oral argument, you have conspiracy theories, you have all these, people are going to be able to watch and see exactly the questions that the justices ask and see how the procedure's done. There won't be any of this, well, was it backroom deal stuff? You get to watch it live, and that is a great thing. So I'm all for transparency. As they say, sunlight's the best disinfectant, right? So in the sense that if there is and Murdaugh's case put a horrible, horrible taint on the legal community. Mm-hmm. I mean, it just put a big black cloud over all this horrible things and exposed where criminality can be put in by lawyers and people that take this job very seriously and uphold the rules of professional conduct. The last thing we want is for our profession to be demeaned or to have any, we already have public perception problems. And so Murdaugh's case highlighted that, exploded that. And when we have the ability to have cameras in the courtroom and to have the public to be involved, I think that only helps promote us in a positive way.
And when you were speaking earlier about the fact that we're not going to get an answer today regarding what the justices have decided when it comes to this appeal, what will the next couple of months, while we're waiting on their decision, what will that look like for the defense and prosecution? Are they still working on the case? Do you continue to move as if you are getting a retrial? How does that work?
You can go for it.
Yeah, so they are in the waiting game. There's nothing left for them to do. They are literally working on all their other cases. They're living their life. It's next man up kind of thing in terms of they are just waiting for the decision. There's nothing more for them to do. This is the pinnacle, the oral argument. Now, once the opinion comes out, that will trigger a whole nother set of things that will need to take place, but they're just waiting.
Absolutely, and I want to kind of touch back on, for folks who may just be joining us, this is not a trial today.
No.
This is a hearing. And explain to us what will be heard today.
Okay, so when issues were brought up in trial and objected to, those issues are then subject to challenge whether or not the judge's rulings were correct. And then those issues are presented as an appeal. There was also another component of this which was the motion for a new trial, which I think in our question from the viewer, they said, well, that was an appeal. That wasn't an appeal in the truest sense. That was a motion that was back at the trial court level. We did have a different judge and retired Chief Justice Toll taking over that role. But at the end of the day, they are just going to be looking at these specific issues that were appealed and raised on appeal. They're not going to go back to fundamental issues that were decided by the jury or issues that weren't raised on appeal or not contemporaneously objected to. They are going to be honed in and focused on these particular issues, and the justices know the issues, they know the law, they've reviewed the information, and they know what to expect today, and as will the counsel who's going to be arguing today. They anticipate there's going to be some curveballs, I believe, from the justices and their questions, but everyone knows the scope of what's going to be heard and adjudicated here today.
And could today's appeal impact how jury selection happens in South Carolina moving forward?
Primarily with the issues, it wouldn't affect jury selection. I could get on a soapbox about jury selection. We have very limited voir dire. If there was a retrial, there's very limited things that defense attorneys can do. They can propose questions, but they can't do attorney-conducted voir dire like they have in other states. But that's not one of the issues raised. As Kyle said, this is all legal-based issues that are specifically raised in that appellant's brief, and they've broke it down because of how many issues there are and kind of the unique perspective of this post-trial, this motion for a new trial hearing, and so purely legal issues.
Yes, and then you guys, we are about 1 minute from this start. Now, let us know, do they start right on time?
Generally,
Yes.
I would say that when you don't have the whole nation watching,
Right.
it may be 10 minutes late. But I would imagine today is one that they're not going to be very late. I would imagine 9:30 strikes, they're going to be ready to move.
Ready to go. And then again, for folks who, like Zay was saying, who are just joining us, a big thing, you will not see Murdaugh at the hearing today because this is not a trial. Also, we won't get a decision today, but we will be able to watch live that whole argument about whether or not he should get a new trial based on many of the things that they have laid out. And we also learned they could potentially also, for lack of better words, get into the weeds about some of the other little things that the defense is saying, hey, not only are we questioning jury tampering and financial crimes, but we're also talking about these other little things that we don't think were right. And so definitely we'll have all of that streaming live on WLTX Plus right here. And then, my friends, my next question for you, and then we'll kind of wrap this up and we'll check back in with Christy. As we are continuing to move throughout this hearing, do you believe that this could set a precedent for like a new state law, like in future trials we could be talking about, in State versus Murdaugh? So do we think that this could set a new precedent?
Certainly, it'll be a published opinion. That's one that can be relied on for precedent.
Yeah.
Not to go too deep in the legal part of it, to be relied on and cited. One, clarifying the constitutional issue that we have here of whether Rimmer, the United States Supreme Court case, the Green, the South Carolina case, how they're going to interpret whether former Chief Justice Toll properly and applied that case to that law. That certainly will have implications in South Carolina law, and then depending on the other issues as well. The other issues, there's many other cases on those issues. It could just be another case to cite, but the primary one is whether he received a fair trial from an impartial jury through the tampering issue.
All right, so you heard it here, my friends.
Absolutely. We have been following this appeal hearing all morning long, and we are just moments away for it to get started. And of course, we're going to check on that and check on several other things that we've learned today. So much information came from you guys, and we definitely appreciate you so much for joining us this morning and giving us that vital information this morning, because I know several people at home had many questions. They were even able to send in messages to us to get you guys to answer those questions. And I myself, not being from South Carolina, continuing to follow this case, I appreciate you guys for filling us in and giving us that information.
I love that. Yeah, you guys can be professors now as well. We accidentally said, when we were saying legal professionals, we said legal professors, but that actually counts as well. All right, my friends, we're going to take a quick break so we can give these gentlemen a moment to breathe, because they've been answering all of the questions that we have and that you have at home. We'll be right back.
The case for oral argument this morning, State versus Murdaugh. I believe the clerk of court, Ms. Howard, has already instructed to turn off your cell phones. If you have not, please do so. The courts in South Carolina are open, and we appreciate those who are present and here to observe, not participate. For those present who are not arguing in this case, please do not disrupt the proceedings. Any outburst or disruption will result in sanctions for contempt of court. As we proceed with the argument, just want to notify counsel that on the primary argument, as you begin your 20-minute allotment, 5 minutes will be given without court interruption. So you'll have 5 minutes before we jump in with questions.
It's gonna be tough, Chief.
And we'll have to show some restraint to do that. At the end of the first issue on the post-trial motion for a new trial based on alleged misconduct of the clerk of court, and before we get to the underlying trial evidentiary challenges in that matter, we will take a short break. And I believe, Mr. Harpootlian, you're going to handle the first issue.
Yes, Your Honor.
We're ready to proceed.
Please the court, Your Honor.
Yes, sir. Good morning.
Good morning, and as I understand your instructions, I get 5 minutes without being interrupted?
That's right.
Wow. Well, first of all, I want to thank the court for, I know, what has been a very diligent effort to wade through this record, a 6-week trial, and then a post-trial hearing that went a few days with additional, 2 hearings, I think, with additional record. So this is not a simple matter. But before I get to that, I want to just remark on this. As I came into this courtroom this morning, I'm reminded that half a century ago, I sat right about there as Chief Justice Woodrow Lewis had us stand and hold our hands up to be sworn in as new members of the bar. All of us could fit in this room. That's how long ago that was. But one of the things that impressed me that day was the oath. And part of that oath was that we swore to uphold the Constitution. And as I stand here today, I'm honored to be arguing about how to interpret that Constitution, the Sixth Amendment specifically. And in my opinion, I would suggest the Sixth Amendment may be the most important amendment because the First Amendment, which gives you the right to speak without government interference, or the Second Amendment, which gives you the right to carry a weapon or have a weapon without government interference, mean nothing without the right to a fair trial and a fair jury. So this matter we're discussing this morning, a fair trial, a jury not poisoned by outside influences, I would submit to you is 51 years ago, as I stood there, I did not realize what I was swearing to do, but I do today. And that is to defend Alex Murdaugh's right to a fair trial. And I've got to admit, in the 51 years since then, I've never seen a factual pattern like this, where the clerk of court, sets out to influence the verdict, to get a guilty verdict for financial gain. Now, I do want to go to the record fairly quickly and summarize it so that there's no misunderstandings. Rhonda McElveen, who's the Barnwell clerk of court, was asked by Becky Hill, the Colleton clerk of court, to assist her during the Murdaugh trial. She testified under oath that she was told by Ms. Hill that she, being Ms. Hill, might write a book because she needed a lake house. A guilty verdict would sell more books. That was said before December of 22. We didn't pick a jury until January of 23. The best way to sell books was a guilty verdict. A guilty verdict would be better for the sale of books. So she explained she had a financial incentive for a guilty verdict. She also made comments to her like, don't be fooled by the evidence presented by Mr. Murdaugh's lawyer. Watch him closely. Just before he testifies, look at his actions, look at his movements. Identical to the statements that I'm going to read you in just a moment by the jurors as they were questioned. Juror P, on the day Mr. Murdaugh was taking the stand, Becky Hill made a comment, watch his body language. Juror X, prior to Mr. Murdaugh's testimony, Juror X heard Becky Hill say words to the effect of, looks like the defendant's going to testify. This is an important day. This is an epic day. It's rare for a defendant to testify. Juror Z, watch his actions, watch him closely. In addition to that, Juror Z said in an affidavit and affirmed in court that Ms. Hill told her not to be fooled by the evidence presented by Mr. Murdaugh's attorneys, which she understood to mean Mr. Murdaugh would lie when he testified, and that Ms. Hill instructed the jury to watch him, Murdaugh, closely immediately before he testified, including look at his actions, look at his movements, which Juror Z understood to mean he was guilty. Alternate Juror 741. Before the defense put up their case, Ms. Hill told the jurors the defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Hill told jurors 741 Murdaugh was going to testify before he testified. That's what the jurors said under oath. That's what the clerk of court of Barnwell County said under oath. Judge Toll, from the bench, said at the conclusion of the hearing, asked the question, did Clerk of Court Hill make comments to any juror which expressed her opinion as to what the verdict would be? Ms. Hill denies doing so, and so the question becomes, was her denial credible? I find the Clerk of Court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed it as early as November 22, long before the trial began. She denies that this is so, but I find that she stated to the Clerk of Court, Rhonda McElveen, and others her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified. She made some of those comments before he testified to at least one and maybe more jurors. The Clerk of Court allowed public attention of the moment to overcome her duty.
Can we consider the egg juror's affidavit?
I'd like you to.
Well, in the record, of course, you mentioned during the hearing, she's across the street. Judge Toll said, no, she's not going to testify. She let the alternate juror testify for impeachment of Ms. Hill. That's
Correct.
what her stated reason for was during the hearing. What was the rationale for her not allowing the egg juror to testify?
I don't know. Because, as you point out, if Juror 741 was to impeach Becky Hill's credibility, now, of course, she was not a deliberating juror.
Well, neither was the alternate.
Correct.
Who did testify.
Correct.
So my question is this, and I'm sure Mr. Waters will cover this. If the egg juror's testimony was just as theoretically impeaching as Juror 70 or the alternate juror's testimony, 741, why wasn't the egg juror allowed to testify?
And I'm not sure that she stated a coherent reason other than she wasn't going to. Remember now.
But she said, her affidavit is in the record, so we know what she said, Ms. Hill said,
Right.
and we now know what Ms. Hill said she didn't say.
Yes.
So I take that to mean that it was considered. The egg juror's affidavit was considered by the court, and we can consider it.
In our defense, when you look at the record, remember, we were starting off with no one was going to examine anyone under Judge Toll's initial order. And then it was a moving target. Then there was going to be some that were going to be examined. We weren't going to be allowed to examine. Then we were allowed to examine. So it was an evolving process. If she, in fact, considered the egg lady's affidavit, she did not cite it in her order, just as she did not cite Juror Z or 741's statements about do not be fooled, comments about how the attorneys are going to try to
The state
deceive you.
argues in its brief that Judge Toll, in making specific findings as to certain things jurors did say, was an implicit rejection of the other statements the jurors said Ms. Hill made. What's your response to that?
Well, I would say that's wholly unsupported by the record. I mean, a judge in an order is going to say what they considered, and they should say what they didn't consider and why. This implicitly, I mean, the statements by 741, by Juror Z, and by the egg lady all had bearing on Clerk Hill's credibility and what happened. It's critical. And let me say this also. Even if you didn't have what they said, if a judge, as the jury came in on the day Mr. Murdaugh was going to testify, said, it's an important day, it's an epic day, you better watch how he testifies, and doesn't say that about any other witness, except some sort of charge at the end of the case, or maybe before, but specifically points that out?
Mr. Harpetlian, let me ask you this. Judge Toll placed the burden on your client to prove prejudice in this case. Does Green establish in a case with external influence on a jury, a different standard and burden of proof than Rimmer and the Fourth Circuit jurisprudence?
No, it does not. It's consistent with Rimmer. All Green says is, we're not going to go through this burden shifting or any of this until we determine whether the statement was inconsequential. I say inconsequential or consequential. And if it is inconsequential, we're not going to go through this analysis. That's all it said. And I'd point out in Green, the process used by Judge Toll of calling all the witnesses up and asking them if it had any influence. Judge Hill, in a footnote in the Court of Appeals Green decision, points out that 606B, he says it's not raised in this case, but should we be asking jurors anything about verdicts? And that's another complicating factor with the process that Judge Toll used. So
that's an interesting point, because Rule 606B says that you can't consider the effect of something on jurors, because otherwise you're invading the thought processes of the jury. But how could the state rebut the presumption without doing that?
Well, I mean, I think very simply, all the other cases that you look at, if you look at like Parker versus Gladden, where a deputy says he's an evil fellow and he's guilty,
right?
They say you can't rebut that. That's not rebuttable, and so he gets a new trial.
But in Parker versus Gladden, they talked about the prejudice.
Well, the prejudice is apparent if you use the standard some of these cases use, which is the hypothetical juror. Would it objectively influence the hypothetical juror? I mean, I think that's what the state has to do, is say these comments would not affect the hypothetical juror.
But in your brief, you also say that the presumption ought to be irrebuttable. Are you standing by that here today? Are you wanting us to follow Rimmer and Parker and say it is rebuttable, but you have to use the objective standard on an average juror in considering the effect?
Well, it is. I would concede that it should be rebuttable, but in a situation like Parker versus Gladden, I don't know how you rebut it. I mean, it may just be it's rebuttable, but there may not be any way to rebut it. So
in some circumstances, the conduct can be so reprehensible and egregious, it becomes a de facto structural error.
Well, I read your opinion, Rivera, Court of Appeals, on structural error, where the judge refused to let the defendant testify in a death penalty case. And I've digested, or as my wife would say, digested, not digested, I'm sorry, that case and the structural error analysis. And I must say that Mr. Griffin and Mr. Barber and I have had a significant discussion on whether that would be structural error as opposed to not letting a defendant testify in a death penalty case. It could be, but I don't think we need to go there for this opinion, for this case. I think the clerk of court tells everybody that'll listen, I need a guilty verdict. She tells everybody, so I can make money. She tells everybody, so I can buy a lake house. And then she proceeds to talk to jurors, not about inconsequential things, but focus on how to view the defendant's testimony, and to juror Z and to juror 741 into the egg lady, don't believe him, don't believe his lawyers. I mean, that's, I submit, more than enough to meet the Parker versus Gladden standard, or the Cameron standard, or I think it's Bennett, the case we looked at, I just looked at yesterday. All of those are cases in which there's no question what was said wasn't inconsequential, wasn't neutral. It was an effective influence.
Is it a finding of fact or a conclusion of law by Judge Toll, where she wrote on page 31 of the record, this court further finds that the improper comments made by Clerk Hill were limited in subject and not overt as to opinion? I know you say that language was put in there by the state in its proposed order. I don't want to talk about that because she signed the order. But it is her finding that the statements were limited in subject and not overt as to an opinion, a conclusion of fact or law?
That's a conclusion of fact, which gives rise to a conclusion of law. But that statement is wholly unsupported by the record. And I would submit an abuse of discretion.
And how about her finding that those comments were cured by Judge Newman's overall jury instruction that the verdict was to be based on the evidence presented and the law as he gave it and not on anything else?
Well, then you would never have, as long as the judge gave the appropriate charge at the end of the case, you'd never have a case of jury tampering. You could have somebody bribing a juror, and according to her reasoning, they well, you know, yeah, I took the money, but I'm not going to do what I said I'd do. I mean, I don't believe for a minute that is an appropriate analysis of the law. Whether I believe it or not is really irrelevant.
So the allocation of the burden of proof is not dispositive in your judgment. Even if it was erroneously assigned to you, you believe you met that burden of establishing prejudice because of the nature and frequency, the pervasiveness of these comments by the clerk.
If you use the analysis in both the Court of Appeals decision of Green and then the Supreme Court decision in Green, if you look at the analysis, that's exactly what it is. There's not going to be any burden shifting or anything if it's innocuous, but if it is something other than that, then the burden does shift to the state, and we've met our burden. There's no second. She had a two-prong test. Second prong was, did it affect the verdict? Well, I mean, if somebody that can't work for Rule 606B for one, but more importantly, you're asking jurors to unpack for you what influenced their verdict. How did they get there, which you can't do under 606B, and people can't do, period. I mean, if somebody had walked in there with a gun and threatened everybody and then left, and the jurors were polled a year later saying, no, I thought the evidence was overwhelming. It didn't matter whether somebody walked in with a gun or not. And overwhelming evidence is not the standard. This Sixth Amendment, I was going to go somewhere historical. I'm not going to do that. But yeah, I am. The Sixth Amendment was based on, as you know, English common law. In the trial of Aaron Burr in 1807 for treason, this is not for killing Hamilton, this is for trying to sell part of the United States to Mexico. He was a piece of work. Chief Justice Marshall quoted from Lord Coke, who said, "A juror must be as indifferent as he stands unsworn. His verdict must be based upon the evidence developed at the trial. This is true regardless of the heinousness of the crime charged, the apparent guilt of the offender, and the station in life which he occupies." You can't say it any clearer, and that's what the Sixth Amendment guarantees. And that didn't happen in this case.
We understand that everyone, regardless of the heinousness of the offense, the character of the accused, or the apparent guilt of the accused, in no manner diminishes the right to a fair trial. In your effort to set up that this is a man for all seasons moment, we understand the gravity of the situation and the entitlement of every individual to a fair and impartial trial.
Your Honor, I never doubted that for a moment. I think I was saying that more from me than you, because it's such a great quote, and again, came up during Aaron Burr's trial, who's such a terrible person, but even he was entitled to a fair jury. We quote in our brief, and I want to expand on it just a little bit. If you look at United States versus Elbaz, which is a Fourth Circuit case written by our own Jay Richardson, he details what Remmer requires, what to trigger the presumption, the defendant must introduce competent evidence of extrajudicial juror contacts that are more than innocuous intervention. I submit we've done that in this case. But the presumption's rebuttable. The government defeats the presumption by establishing there exists no reasonable possibility that the jury's verdict was influenced by an improper communication, which was not done in this case. And you should exclude, well, at least one, I would point out, Juror Z said it did. I mean, if we're going to go that way, now it may have been ambivalent. Judge Toll says, I said in the record, it can be both pressure from the jurors and what Cork-Hill said. But I don't think we need to go there because 606B and almost all the cases about external influence don't allow you to ask the jurors questions about how they got where they got.
Part of Parker versus Gladden was that the Sixth Amendment was violated because the bailiff there who said this person's guilty, this wicked fellow, whatever, became a witness in the case. Is that what you're saying Clerk Hill became in this case?
Well, not necessarily. What I'm saying, Parker versus Gladden, they only needed 10 or 12 to get a conviction. And the Oregon Supreme Court said, well, we had 10 that weren't influenced by whatever the bailiff said. The Supreme Court said very clearly, doesn't matter, you're entitled to 12 impartial jurors. Also, that was the case in which the United States Supreme Court adopted, through the 14th Amendment, the Sixth Amendment to the states. So that's the reason I like Parker, because it's got so many different levels that are very helpful in this case.
And in Parker, did it took 10 to convict in Oregon, right?
Yes, sir.
How about Judge Toll's finding that even if the state had the burden, she found any possible presumption of prejudice was overcome by the facts and the court's findings? She did conditionally rule that if I'm wrong about the burden, then the state has overcome that burden.
Well,
the presumption, excuse me.
Two things. One, she doesn't detail what that overwhelming evidence is. And you're going to hear from Mr. Griffin in just a moment as to how underwhelming that evidence is, number one. Number two, that can't, the level of, if the level of evidence dictates whether or not you get a fair jury, then again, we go back to what Judge Marshall said, no matter how heinous, no matter how overwhelming the evidence, you're still entitled to a fair trial. I mean, if only the people that may be innocent get a fair trial, then our Constitution isn't working. I don't care. I would submit this court shouldn't care. No one should care when there's a Sixth Amendment violation like Becky Hill committed in this case. And let me say this. I know my time's up. We spent months getting ready for this trial, weeks, 6 weeks trying this trial, more months finding jurors to talk to and find out if the court could talk to them. We had more hearings, more briefing. Nobody wants to do this again less than we do. But that's not the issue. It's not how much trouble it's going to be. It's what is Alex Murdaugh guaranteed to under the Sixth Amendment.
Thank you, sir.
Thank you, sir.
Good morning, Ms. Waters. Good to see you, sir.
Good morning, Chief Justice Kittredge, and may it please the court. I'll start out with my 5 minutes, and I'll start by saying I also agree that oaths are important. That's something I always talk about with juries and the importance of their oath. And I think that that's also recognized very strongly in this court's case law and case law of other jurisdictions, and that this court has expressed that jurors are presumed to take that oath very seriously, that they're presumed to be people of ordinary firmness, that they are not presumed to blow with the winds of every opinion that swirls around them. And so I think that's an important place to start when we look at this particular case. And when we look at this particular case, what we are talking about is what Justice Toll described as a few fleeting comments. And in the face of that, we have to consider a 6-week trial with almost 90 witnesses, with almost 600 exhibits, with Judge Newman, with the entire prosecution team, with the entire defense team, and all of that presentation over 6 weeks. And to get there and to do what ultimately is the analysis is we have to assume that at some point prior to deliberation, during the presentation of evidence, with all of that going on, some jurors like, well, you know, I didn't know what I was going to do, but Miss Becky said, you know, watch his body language, and that made the difference. And I would submit to you that that is simply not a finding that is justified in this evidence. It's not a finding that's justified under what we know about jurors, and it's not a finding that's justified by what the jurors said in this particular case. Now, to sort of detail my my analysis in my free 5 minutes that I have here before the questioning comes, is we have 606, and we've got two issues. We've got number one is what happened. And then we've got number two, which is how do we analyze that particular issue? And when we start with what happened, that is obviously a credibility and fact-finding effort by the trial court. This court is very clear that the trial court, because this is not like a trial, this is a procedure that is in the discretion of the trial court, and ultimately any credibility findings, fact findings, this court respectfully would defer to. And so to determine that, what exactly happened? And this court ultimately credited the 11 jurors. And so what do we have with those 11 jurors? We have one juror saying that Ms. Hill said this is an epic day and the defendant is going to testify. All right. And then we have another juror who says watch his body language. And beyond that, the court clearly did not credit Juror Z, and I'll get into more about that, but there's plenty of the support in the record why the court could not credit what Juror Z said. Juror Z was ambivalent. Her answers were all over the place. None of the other jurors heard all those egregious statements. She couldn't even remember all of these egregious statements when she was on the stand. She said, I don't remember them. All of these things that really would take this analysis into a different level, she didn't remember. So when we boil it down to what happened, we're talking about epic day. All right, epic day, everybody in the courtroom knew it was an epic day. That is not news to anyone. Everybody knew it was an epic day. It is rare for a defendant to testify. That on its face is a neutral comment. That is not necessarily a comment one way or the other. And if anything, we've seen where instances of a jury in deliberation considering the fact that a defendant didn't testify, saying, you know, he must be guilty because he didn't testify. That's actually been an inference that goes more in favor of the defendant than against him, the fact that he's testifying. But again, it's rare that a defendant will testify. That ultimately is a neutral statement as well. And then watch his body language. Again, that is what was found, not don't get fooled by his comments or anything like that. That was not what was found by the trial court, just a neutral comment of watch his body language. And so that is the facts, the three facts that we have to ultimately assess. So when we move on from there, then the analysis is how do we analyze that? And first of all, we have the discussion of whether or not there's a presumption of prejudice. Justice Toll, of course, found, based on this court's clear case law, that there was not. But I would agree, I would submit to you that not only because of the alternative findings, but just because of a general analysis that regardless of who had the burden, that presumption of prejudice was overcome in this particular case. And I'll talk more about that in a second. But I think ultimately the legal analysis, whichever way you go, I don't think is going to be dispositive because of the relatively non-egregious nature of these comments. They are nothing like the comments that were in the cases that have led to reversal. So let's talk a little bit about more of the findings that were there. In looking at the evidentiary hearing that was done, we had, of course, Ms. Hill testify, and the judge found that she was not completely credible. We had Ms. Rhonda testify. The court did not credit that testimony because Ms. Rhonda conceded over and over again that she absolutely heard nothing whatsoever of any—
Mr. Waters,
Yes,
I
ma'am.
want to stop you right there,
Yep.
Since your 5 minutes is up, and talk a little bit more about Juror Z.
Yes, ma'am.
You're saying these are innocuous comments, not to be fooled, and look at his actions, look at his movements. The court seems to believe Juror Z when she says in her affidavit and when she testifies that these comments were made to her. However, she goes on in her affidavit to say, not to be fooled, which I understood to mean Mr. Murdaugh would lie when he testified. Look at his actions, look at his movements, which I understood to mean that he was guilty. The juror is testifying in her affidavit that the effect on her was significant. Why can the court, how can the court find that certain comments that she made, take them and incorporate them in the order, but not believe what she says about the effect?
Well, two things about that. I think that, first of all, Justice Toll did not credit any of the egregious comments that she didn't even remember herself on the stand, such as "won't get fooled." The only comment that was credited was what was testified by Juror P, which is watch his body language.
And let me, and I want you to finish your answer, but I want to ask you this. So far as the comments are concerned, are we limited, is this court limited to only the comments that are included in Judge Toll's order? Or are we able to consider all the comments that are included in the affidavits, even the egg juror affidavit?
Well, what I would say to that is the case law is clear that the trial court has the discretion to conduct this hearing and ultimately make credibility findings, which under typical appellate law, this court would defer to. And so my argument to that is if you look at Justice Toll's order, both her oral order and her written order, she credited the 11 and did not credit Juror Z and did not give any credence to 741, the alternate, and or the egg lady, which of course did not testify. Now there was on page 808 of the record where she says, I think we've got in terms of what she says, Ms. Hill says, and what Ms. Hill says she says. That's on page 808 of the record and talking about the egg lady juror. But ultimately, I would submit that this court in appellate review does need to defer to credibility and factual findings of the trial court. And the trial court only found the 11 credible. And
well, then help us understand the ostensible inconsistency when the trial court finds portions of Juror Z's affidavit credible and just carves out and doesn't deal with the part that dovetails with the alternate juror's testimony, which is far more prejudicial.
Sure.
How do we do that?
Well, so we're looking for, I would submit from an appellate court's standard of review, we're looking for support in the record for those findings. And so when you look at Juror Z, okay, and first of all, you look at the 11, which she did credit, and none of those 11 heard any of these other egregious comments or anything like that. None of them. What
do we do about the order that doesn't even mention that Juror Z did in fact testify about the comment, don't let the defense confuse you?
Well, I think that when you look at the order in her specific paragraph on Juror Z, what she says is that Juror Z was ambivalent, and ultimately, as she goes through the analysis of what Juror Z says, she's not crediting that testimony. And again, I think there's support in the record for that.
There may be, and that may carry the day for you.
Right.
Assume that we find that that statement was made. Do you still have a path to victory?
That don't be fooled?
At the end of the state's case, before the defense presents its case, the statement was made, do not be confused, do not be misled by defense and its counsel.
Right. Well, I would say, and this is like everything in this, it is a question of degree, okay? And there could, if the clerk had come in there and held a gun to their heads and said, you better vote guilty or I'm going to shoot you all, I probably wouldn't even be arguing that's not structural error, okay? But everything is a question of degree. I'm not going to concede that if those statements were credited and are part of the review, that our path to victory is not harder. But I think you have to look at that in the context of this entire trial and when those particular statements were made.
Right. And I think context is important too. We all can cherry pick some of these that are on the surface innocuous. Epic Day, Big Day. And when viewed in isolation, they don't move the needle, arguably. But when those seemingly innocuous statements are considered in the aftermath of the originating statement not to be confused and misled by the defense, those initial innocuous statements take on a very nefarious message.
I could not argue otherwise, that would absolutely be a question of degree. However, I don't believe that just ends the inquiry right there, because you still have to analyze it in the context of all of the factors and everything that went on. And so to look at that, let's look at all of the things, and let's assume that we're limiting it to what I contend Justice Toll found, which again, when I say innocuous, I'm saying relatively not egregious. I'm not saying that the clerk should be saying watch his body language, okay? But that is a far different comment from what you're talking about right there. But
Yes,
even
sir.
if we add that in, we're still talking about a limited, number of jurors who saw that. And then we're putting that in the context of where that occurred, okay? It occurred during the middle of the defense case, not during deliberations, not right before deliberations, but in the middle of the defense case. It occurred during, I think we counted no less than 60 times that this jury was told by Judge Newman to only, rely on the evidence, to not talk about the case, to not have external influence and all the rest of that. And we have to credit that. We also have to, again, put that in the context that when and if that occurred, and even assuming that there was a one bit beyond that it was attenuated from the actual point of deliberation by the rest of the defense case, by the entirety of the state's reply case, by all of the closing arguments of counsel, and by Judge Newman's very detailed charge. And so while that would be different, I don't think that is fatal when you look at the entirety of this 6-week trial. And again, go back to what I said ultimately at the beginning of my argument here is that for that to happen, you'd have to conclude that with all of that going on, with this massive evidentiary presentation, with multiple instructions from the trial judge, with all of these arguments of counsel.
So you're distinguishing a day-and-a-half-long burglary third trial from this trial?
No, sir, but what I am saying is that I do think time matters. I do think.
But you would agree that at the end of a Berg third trial with a guilty verdict, the judge finds out that the clerk of court was back in the jury room saying something like, well, that defendant's not going to testify. But I just want to let you know, this is the 5th time he's been up here for a burglary third. So I just want you to know that. Right. Egregious or not?
Your Honor, if that were the case, I would be very hard-pressed to argue otherwise.
Okay, so help me out with this. If we craft a standard based on the length of a trial, and heavens know, nobody wants to try this case again, how do we create a standard based on a lengthy trial versus a day-long trial when the constitutional right is the same?
Absolutely, the constitutional right is the same. And what I'm not asking is this court craft a different standard for a long trial versus a short trial. What I am saying is what is relevant to the ultimate inquiry that this court engages in is the timing of when these comments took place.
Okay, well, let's talk about that, and I'll weave in some questions about the egg juror. Ms. McElveen, the Barnwell County Clerk of Court, said she didn't hear any of these comments made in front of jurors, but the comments made to Ms. McElveen by Ms. Hill were remarkably the same as those related by the jurors. For example, watch him closely, look at his actions, look at his movements. Ms. Hill was saying that to staff and to Ms. McElveen. You agree that's what she testified, correct?
That's what she testified to.
That does match almost exactly what these jurors said Ms. Hill told them, correct?
It is.
Okay. So explain to me how we pass go under your theory. How do we accept the fact that Judge Toll maybe didn't mention all these things in her order, but they were supported by an impartial witness, that being the clerk of court from Barnwell?
Well, two things about that. I don't think we can get past what you've recognized, that clerk of court from Barnwell heard nothing going to a juror, or she would have brought that to the court's attention.
But the consistency of the comments or the similar nature of the comments is striking.
Well, and then my second part that I would say about this is that all of this arose months and months and months after trial. And the courts have been, historically reluctant because of that passage in time, because of the fact that jurors vote one day and one day only, and don't have to assent to their verdict and vote him guilty every single day for the rest of their lives. And so I think that passage of time is something that is relevant as well when this case is being talked about incessantly out in the world. And so I think that that's something as well that Justice Toll can consider in deciding what actually happened. And the best evidence of what actually happened, and whether or not it is whether you look at what the jurors said about it, not to get to the 606 aspect of it, or if you're objectively standing back and making that factual finding of this is what happened and this is whether or not there's a prejudicial effect. That is why Justice Toll credited those 11 jurors, and that is, I would submit to you, the realm of what this court needs to consider.
I want to ask you a question about this idea that you expressed that this event or these moments when the clerk spoke to the jurors should be considered insignificant when viewed among the entire trial, whether it's a long or short trial. There's no eyewitness, there's no DNA, there's no one thing on the part of the state that you could rely on to show him guilty. So you had to piece together a whole bunch of different stuff. We'll talk about a lot of that stuff in the next phase. But
yes,
but you spent, most of that 6 weeks was you piecing together small pieces of evidence to put together an argument that he did it. Mm-hmm. On his side, now of course he doesn't have the burden and isn't even required to testify. But on his side, whether he's guilty or innocent boils down to one moment, one thing, and that's when Alex sat up on the stand and said, "I didn't do it." Mm-hmm. So what I'm wondering is, you're wanting us to consider the statements by the clerk to be insignificant, but those statements go to the only thing that the defendant really had. I mean, the defendant can argue that you didn't piece it all together, but really the defendant's argument boils down to the one thing that the clerk of the court addressed. So we can look at all this context if you want to, but the jurors knew that if Alex was telling the truth, he's not guilty. If he's lying, he is guilty. And that's where the clerk of court's statements appear to focus. How do you respond to that?
Well, I would say that while I understand that obviously was very important, the defendant taking the stand, it wasn't as simple as just getting up there and saying, "I didn't do it," okay? And while there was a long piecing together of all of that, the defendant's testimony was also very long over the course of 2 days. And so I don't think that you can just view the defendant's testimony entirely in isolation of this entire trial. I don't think any analysis has ever said that we're going to ignore the entirety of what went on. Certainly the defendant's testimony was important, but they had been raising all kinds of issues as to lack of motive, as to other possible motives, as to the boat case, as to the cowboys, and all these other things along the way as well. Again, saying this is an epic day, saying it's rare for defendants to testify, those were all statements that everybody in that courtroom knew, everybody in that courthouse knew. So while I hear what you're saying, I think that you can't take out the fact that this was a complex matter with a lot of complex issues.
And, to the extent, though, that you've made some fine points about how we should interpret the statements. Mm-hmm. But if the statements, and Justice Kitchens was alluding to this, if the statements kind of collectively go to the point you should not believe him, to me it's hard to separate that from the critical issue in the case. But I want to bring up one other thing. You point out in the very beginning of your argument that the trial court here found that Becky Hill was not credible. Now that's a soft statement. That's almost like Richard Nixon or Bill Clinton, whoever it was, said mistakes were made. Sometimes people are not credible because they didn't get a good look at what occurred. Sometimes people are not credible because they don't remember what they saw.
Right.
Here, if Becky Hill is not credible, it's not because she didn't see it, it's not because she doesn't remember it, it's because she's a liar. Is that right?
I would say that ultimately she said she was not completely credible, and yes, sir.
So there's only one way that Becky Hill can be not credible, and that is that she is a liar.
I think that Justice Toll did not credit parts of her testimony as she looked at everything. Now, she didn't specifically find that she is a liar, but ultimately she didn't credit that testimony. But what I think is important is that neither Justice Toll nor the state relies on Becky Hill. What we rely on is what is most important, and that is the 11. The overwhelming majority of these jurors who sat there and looked Justice Toll in the eye, who judged their demeanor, who judged their credibility, and who ultimately were clear as a bell that there was no sort of improper influence on their verdict. And when you look at these questions and you know, whether or not they went beyond 606B, ultimately they were questions about impartiality. And I think there's a distinction, and Justice Toll made this distinction, that when she phrased these questions, first of all, she had the 4 exact questions that were in green, which I understand the footnote, Justice Hill, when you were on the Court of Appeals, but they were the same 4 questions from the record in State versus Green. So that was a reasonable set of questions to ask. I see I'm out of time, but...
You premise your response that she relied on 11.
Mm-hmm.
In Ethier, this court overruled Vestry versus Orkin exterminating, and that a party is entitled, and that was a civil case, 12 impartial jurors, not 11.
Yes, sir.
So how do we deal with that?
Because ultimately the 11 were credible and Z was not. And that is what Justice Toll clearly found. And when we look...
And how do we handle Ms. Hill with, as I think Ms. Harpootlian referred to one of the comments, that Ms. Hill was attracted by the siren call of celebrity. There's another quote in the trial court's order. She allowed her desire for public attention to overcome her duty to her oath of office and her oath as a witness.
Yes, sir.
How do we deal with that and pick and choose what parts of her testimony we accept or don't accept? We just refer to the trial court?
Well, I think when we look at Ms. Hill, and again, I'm not here to justify or to defend Ms. Hill. Ms. Hill, of course, said she didn't do, any of these things other than, occasional, just everybody pay attention, you need coffee and things like that. But so I think that ultimately Ms. Hill she didn't admit to any of those things. So you have to look at Juror Z. Juror Z is what's really in play as to whether or not Ms. Hill went beyond what we say and what the trial court found was the area of what this court is to consider, and whether it was something far more egregious. And even beyond that, even if you take some of what Juror Z said, even if you take some of what Ms. Becky said, even if you take some of what Ms. Rhonda said, when you do that analysis and you put it in the entire context of thing, and when you put it in the entire context of this entire trial, and you put it in the context of where it occurred and everything that went on after that point, then the state has overthrown prejudice. And as Justice Hull said, she finds it, she did not find that a few foolish and fleeting comments in the entirety of this trial would be enough to have infected this verdict and to make it unfair. I completely agree that somebody's entitled to all 12 jurors, but this is a credibility finding that 11 told the truth and 1 did not, and the 11 set the standard of what this court should consider, and those comments were not egregious.
Please, yes, sir, Justice James, and we may have some other questions as well. Just one second, please, Mr. Wonders.
A few. You go ahead.
No, you go ahead.
The jury of 11 versus 12, in the defendant's brief, he argues that Judge Toll studiously avoided Parker versus Gladden. Mm-hmm. And I think that's the case where it took a vote of 10 out of 12 to find somebody guilty.
Correct.
There is no mention of Parker versus Gladden in this order. Is that still good law?
Yes, sir, and I'm not
Okay,
contending
so,
this.
but you said several times, and I would too if I were you, that 11 jurors said, no, my verdict was my verdict.
Right.
So that takes me, I just want to, you can respond to the Parker versus Gladden part in a moment, but you also need to explain to me about the egg juror. She was removed from this jury on the day deliberations began. Is that correct?
Yes, sir.
So she was not an alternate, she was a sitting juror.
Correct.
And so she was there and removed minutes before they began talking about the case, began deliberating, correct?
Correct.
And she said in her affidavit, that her ex-husband called her as she was getting on the bus to ride to the courthouse that morning. That upset her because she had a restraining order prohibiting him from contacting her. So she called, or she spoke to Ms. Hill, correct?
Yes, sir.
And Ms. Hill told her, according to the egg juror, the Murdaughs probably got to him. You agree that's what she said in her affidavit?
That's what she said in her affidavit.
Okay. And then Ms. Hill asked her if she was leaning one way or the other. And the egg juror said, Mr. Waters' closing was good, but I still have questions. And she said, what kind of questions? And she told Ms. Hill she had questions about the guns. I suppose couldn't find them or there were two used. And then Ms. Hill asked her, what makes you think he's innocent? And she said, the video at the kennels. And then she said, Ms. Hill said, everything the defendant has said has been lies, and you should forget about the guns. They will never be seen again. Are those fleeting comments or are those egregious?
Your Honor, those would be hard pressed to defend, yes, sir.
Okay.
That would be much different from when I'm arguing this record.
And then Ms.
reflects.
Hill told her that the foreperson should just go in and ask for a raise of hands, and this will be over and done with, and everybody needs to be on the same page. So I'm struggling, number one, with why the egg juror wasn't allowed to testify, because that was directly impeaching of Ms. Hill's testimony that she said nothing, correct?
Yes, sir.
And Judge Toll did say that the egg juror's affidavit is in the record, so we know what she said, Ms. Hill said. So can we consider that affidavit?
Ultimately, I think that Justice Toll, when she made her ruling on, and again, within the discretion of the trial court, as the case law allows her to do, to set the tenor of this inquiry, was only looking at the jurors who actually deliberated. And I think ultimately we got to the alternate because the alternate was there to the end. The difference with the egg lady, and we have to remember this too when we look at the implicit rejection of all of that, is that the egg lady was, and it wasn't like she just got kicked off that morning. That was the product of a couple of days of in-camera hearings that ultimately disclosed that this egg lady juror, who initially said she had not talked about the case, it was ultimately discovered that she had. And all of this stuff about, the Facebook and all that other stuff, Judge Newman was very clear was not the basis for her removal. It was the basis for her removal was her violation of the...
When somebody delivered a refrigerator.
Correct.
And they said she was talking about the case.
That's correct. And that was after she denied it. And then ultimately it came to pass that was not the case. And Judge Newman removed her, frankly, for that misconduct. And so that in and of itself is supported in the record as a basis in the record for Justice Toll's rejection of the credibility of all of that. And this is a person, again, who wrote a book afterwards, and months of going on when all of this stuff started percolating up. I think that's all relevant to consider as well.
Justice Hill.
Mr. Waters, you talked a lot about the timing of this case and the length of it. Now, the clerk is the public official who jurors have their first contact with from the courthouse and their last. She's the administrative face of the court, essentially. Her name's on the letterhead of the jury summons that the jurors get. She swears in the jurors. She swears in all the witnesses as they're about to testify. She coordinates the jurors' schedule. She's the liaison between the court and the jury. She's their guide or their Sherpa, so to speak. She's their point person. And she reads the verdict. And she signs their paychecks at the end of the trial. Now, justice is supposed to be blind. We all know that. But court officials, when it comes to the merits of a case, are supposed to be mute. That's the ideal. That's the aspiration. Even our Constitution prohibits the trial judge from commenting on the facts of the case in open court.
Yes, sir.
Now, after a 6-week trial, it's only human nature that these jurors might become bonded to this person. So you've talked about the timing, and I'd like to talk about the source of these comments and where they occurred, which was in the jury room. So can you comment on that?
Yes, sir. So I absolutely hear what you're saying. I think, though, that maybe overstates, and I don't at all distinguish or disagree with you about what a clerk should do and the role that they serve and all the rest of that. But I do think that overstates what Justice Toll was supposed to do and what this court is supposed to review, and that is the specific circumstances that occurred here. And I think that maybe overstates Miss Becky's sort of influence in all of this at this point in time. The jury, actually, the person who handled the jurors day to day was Bill Polk, not Miss Becky. And in fact, as Miss Rhonda testified, Miss Becky got sick, and Miss Rhonda was at the trial more than Miss Becky was. And so while certainly some of those factors may exist, I think when you look, and this is what I argued before, when you look at what was going on in this courthouse, when you look at the entirety of the specific facts here, when you look at Judge Newman on the stand, who was really, if you want to say the Sherpa, the shepherd of these jurors is Judge Newman, not Becky Hill. When you look at the entirety of this record, I don't think that, while you're exactly right that the clerk has that neutral role and serves those functions, that in this particular instance, Miss Becky's influence was that large, and there's no evidence of that in the record. And to go back to what Justice James was saying is, this is part of the rejection of that credibility, that all of those detailed things just so above and beyond the pale that the egg lady says happened, and all of that contact. No other juror said anything like that. And those were the jurors that Justice Toll found credible. And again, that has support in the record that Miss Becky has just decided egg lady of all people is the person that she's going to go through all of this with and not have similar conversations or similar things like that with all of these other jurors. And again, that in and of itself is support in the record for us to put those aside and focus on what the 11 said. Not that 11's good enough, but that 11 are credible, and that rejects these claims of the others that all have credibility issues that have support in the record.
The circumstances of this issue are not lost on us. In the courtroom, we have an excellent Attorney General with a very professional and competent team of prosecutors, including you, Mr. Waters. On the defense side, we have an extremely competent, top-drawer representation. We've got a superb trial court judge. And out in the hallway, we have a rogue clerk of court. And even if we accept the truncated version of what you characterize as innocuous statements, even you acknowledge it was improper. Perhaps not improper to the point of reversal, but you acknowledge it was improper.
Absolutely. And if I could respond very quickly.
Well, I want to make the note, because in my position as Chief Justice, I have to deal with the clerks of court in 46 counties. And the overwhelming majority of our clerks of court are dedicated, conscientious public servants who discharge the duties of their office with integrity and do not act like this. And I'll give you the final word.
Thank you, Chief Justice. I think what you just said highlights and proves my point when you went through all of the players in this trial and the relative insignificance of Miss Becky. And as I said before, with all of that going on, that some jurors really like, oh, well, Miss Becky said watch his body language, that is going to make the difference. What you just said of all that went on is why, not the truncated version, and I understand your point with that, but what the record reflects and what Justice Toll found is what really happened. That was the extent of it. I don't mean to imply they were innocuous. What I mean to imply is that they were neutral on their face, not proper, but neutral on their face and not egregious.
Thank you so much. Appreciate the fine arguments on both sides. At this time, before we go to the, you can do the reply now on this issue? I thought we were going to do the reply at the end. What's the, what was your understanding, Mr. Barber?
Mr. Chief Justice, if the reply would be at the end of
That was my
That's mine
understanding.
too. So we'll take a, say, 10-minute break. Everybody stretch their legs, restroom break, and then we'll be back in 10 minutes. Thank you.
No, no problem.
Well, time right now, 10:35, and as you saw, we are inside the South Carolina Supreme Court this morning, where the first half of arguments in Alex Murdaugh's appeal has just wrapped up.
Yeah, in the courtroom, it was nearly full, including court officials, pre-law students, as justices heard arguments over whether Murdaugh deserves a new trial.
Now, each side was given 20 minutes per appeal to present their case.
Defense attorney Dick Harpootlian, he argued the issue is not about guilt or innocence, but about the Sixth Amendment right to a fair trial. Now, he claims former Colleton County Clerk of Court Becky Hill improperly influenced jurors, including alleged comments about watching Murdaugh's body language and not being misled by the defense, and says that undermines the requirements of 12 impartial jurors.
Now, the justices pressed him on whether the defense met its burden of proving prejudice. Chief Justice Jean Toll questioned whether the record supports that jurors were actually influenced. That is when she saw the case.
Now, the state, they responded with Prosecutor Waters arguing that the alleged comments were brief, neutral, and did not affect the verdict. Now, he emphasized that most jurors testified they weren't influenced.
Yeah, and at one point, the Chief Justice noticed that while individual comments may seem harmless on their own, when viewed together, they could potentially take on a different meaning. Now, as we continue to follow this, we do have a team. We have Kiki Gushu, who is inside the courtroom, and she will be giving us an update when she comes back out. We also have News 19's Christy Calcagno, who's standing outside of the South Carolina Supreme Court as well. And we are going to continue to bring you an update as the court takes a short break. It's going to be about 10 minutes long.
Yeah, absolutely. You know, we learned a lot of information from this appeal hearing this morning. So much to unpack. We still have our attorneys in studio this morning who are going to help us out and kind of break down some of what happened in that first half of that appeals and answer any questions that we have.
Yeah, absolutely. Now, again, this is definitely something that a lot of people have been paying close attention to, just like millions of people watched as this double murder conviction or double murder trial took place. We're expecting the same amount of viewership when it comes to this as well, because as we know, this is a case that has captivated the country. And again, it's really important to note that this isn't a question about whether or not Murdaugh is guilty. That is a foundation that needs to be understood. Because a lot of folks are saying, well, why are we having this hearing? I think he's guilty. Again, it's not about guilt or innocence. This is all about whether or not Murdaugh received a fair trial. And the defense is arguing that there are multiple things that happened throughout his trial a few years ago that did not allow him to get a fair trial. And that is what the argument is happening right now.
Absolutely. And like we said, all eyes, it's on the South Carolina Supreme Court this morning. And I know this morning we had a lot of questions, folks asking, would Murdaugh be in the appeals hearing this morning? And obviously that's not going to happen. And our attorneys this morning, they broke that down, basically saying that is very normal that most folks are not going to be inside of their appeals hearing. So that is why, if you're watching this morning, you will not see Murdaugh in court this morning. And also, we got word that folks were wondering if Becky Hill would be at the appeal court appeals hearing this morning. And our attorneys this morning kind of informed us that she probably wants to be far away from what's going on at the state Supreme Court this morning.
Exactly. And so again, we know that her comments, Becky Hill's comments, are at the center of the argument that he deserves a fair trial, because they are saying that his comments influenced the jury. However, the state is pushing back on this. They are saying that her comments were minimal, neutral, and not proven to have affected jurors' final decision. So again, that is something that they are weighing, whether or not her comments influenced the jury's decision, because as you know, a clerk of court is upheld to the highest standard of the law, and they are not allowed to give their personal opinion or interact with a jury in this way at all. Now, one of the things that you saw as well is the justices, they've actually already been through all of the documents. They've heard all of the arguments. This is an opportunity for them to ask any questions that they have after reviewing all of the information that has been presented to them. And one of the questions that we're seeing a lot of the justices really hone in on is Murdaugh entitled to 12 completely impartial jurors, even if one juror was influenced? And so they're asking, does that require a brand new trial? So that's what they're really honing in on, is the impartiality of this jury. Now, we're going to check back in to see if we have our attorney, Dane Phillips, on standby to give us a little bit more insight into what we saw. All right, there he goes. Dane's been with us all morning, answering the almost a million questions that we have thrown this way, because for a lot of folks in South Carolina, this is the first time that we are getting to see a appeal hearing in front of the South Carolina State Supreme Court. I mean, they really move the curtain, and we're getting to see inside how this takes place. So, Dane, the first question, I got to know, what are your initial thoughts after what we've just seen?
Well, the thing that struck me the most from a legal standpoint is that they did not go deep into the interpretation by former Chief Justice Toll into the United States Supreme Court opinion, how it's applied from the South Carolina opinion of Green, but instead they focused more on the bigger picture of the legal issues, of the facts of the case. Again, everybody understands that this is about kind of that constitutional bedrock of a Sixth Amendment right to a fair trial by an impartial jury. And that was really the focus of the facts as applied. If I was the appellant, if I'm Murdaugh's legal team, you're feeling very positive from the comments. Now, I can tell you, as somebody who's argued before the court many times, just because you have positive questions or the tone of the questions seem in your favor doesn't necessarily mean that that's the way they're going to rule, but they have a lot of positive feedback from the court, in my opinion, that they are gravely concerned about what occurred in that courtroom, specifically with the conduct of Becky Hill, the credibility of Becky Hill, and the former Chief Justice Toll's finding that Juror Z was not credible and not providing a lot of specific basis for that when you got to have 12 unanimous jurors for that guilty verdict. And so that is kind of the biggest thing to me that's highlighted, is they didn't really go deep into the legal weeds, as I would say. It's like, it wasn't this big constitutional law argument. It was more about, here are the facts that we have that was laid out through that hearing, that motion for new trial hearing, and here are the kind of different phases as you could look at, from the set of jurors that say they didn't hear anything, set of jurors that said they did hear something, but it didn't affect the verdict. But then you got Juror Z, who says, here are the comments that were made in the affidavit, and it did affect the verdict. You have the credibility finding by former Chief Justice Toll, but you also have the juror that was struck, the egg juror. They went into that and all the different things that come into play there. I think it's very clear that the court is, again, as I said, gravely concerned about the conduct and, again, the credibility of what's presented. Ultimately, this is the strongest issue on behalf of Murdaugh's legal team, and from a constitutional perspective and from a factual perspective, it seems to be certainly something that's very favorable, potentially for a reversal.
And Dane, when we talk about these communications that Becky Hill was having with these jurors, when you heard those, I don't know if this was your first time hearing that communication, what are your thoughts about that?
Well, if any of those things are true, again, if anything were said, it's improper. Now, I understand from a Creighton Water standpoint, from the government standpoint, that in and of itself saying that today's an epic day, you're not going to have a reversal on that comment alone. I don't believe in any way, shape, or form that the South Carolina Supreme Court would overturn based on it's an epic day or he's going to testify today. Those are neutral, as he characterized it, as innocuous. those are not reversible. But once you get into watch his body language, again, depending on the Juror Z part of, whether he would be lying and self-serving, those kind of things, all those comments absolutely tips the scale and, as Chief Justice Kittredge said, moves the needle from the prejudice part. I mean, they weren't even going into the legal standard. They're just talking about just the very nature of the fact that you had improper comments and then the absolute prejudice created by having essentially the clerk of court, who is the face from an administrative standpoint of the court, making comments directly to the jury in the most sacred part, the jury room.
Now, Dane, the defense repeatedly framed this as a constitutional issue about the right to a fair trial. Legally, how high is that bar?
Well, I mean, at the end of the day, it is the cornerstone of any criminal case. You have been accused of a crime. And it doesn't matter whether, as you heard Justice James say, a burglary third 2-day trial, 6-week murder trial. It is a foundational issue that you have a right to a fair trial by an impartial jury. So the burden is essentially, is there an error and is there prejudice? In other words, did it affect the outcome? However, in this issue, we have a United States Supreme Court case that says once you prove that juror tampering, that there's irrebuttable presumption, that there is prejudice. There wasn't a whole lot of argument into that, because where former Chief Justice Toll said, well, we have this case in South Carolina State versus Green where a bailiff had made an offhanded comment, and it kind of it didn't overrule the United States Supreme Court's case. It just kind of added a little extra for how we handle these issues in South Carolina, where the appellant would have to, it changes the burden of the proving prejudice. I thought that was all going to be the primary issue this morning, since that is a legal issue on the legal issue on appeal that they just addressed. But it was really based on, again, on the facts, which makes me believe that the justices are they're firmly grounded on where they believe ultimately their interpretation of the Rimmer, the United States Supreme Court case, its application to Green in the South Carolina case, and again, how they're going to apply it. I think it's all about them addressing the ultimate factual issue of, you have former Chief Justice Toll finding Juror Z not credible. That's a major issue. The fact that I think Chief Justice Kittredge kind of tipped his hand that he believes at a base level her comments are improper. I mean, that he pretty much ended that of making his position known that her conduct was certainly improper. Now, whether, and he did qualify it, whether it crosses that threshold of a reversible error such that he would get a new trial is the quintessential question now.
And Dane, I know we are super early in this appeal hearing, but with your expertise, as of right now, if you were one of the justices, where would you be leaning right now?
Again, from a personal perspective, based on the record that I've seen, again, I watched the motion for new trial hearing. I've read the record on appeal as far as the relevant parts. I haven't read all 8,500 pages. I won't go that far. But I've read enough. Alex Murdaugh was denied his right to a fair trial. Again, the rule of law must prevail. This is not a situation where we're making a judgment issue on the morality of whether or not Alex Murdaugh is guilty, or any of the factual basis, or any of the personal opinions. This is purely on a legal issue. It is more than Alex Murdaugh. Although this applies to him, this is a higher standard, because this is how the law will be applied in South Carolina to all South Carolinians who are accused. And it's a fundamental bedrock cornerstone constitutional issue of having a right to a fair trial by an impartial jury. And we cannot allow outside influence in the sanctity of a jury deliberation room. You cannot turn a blind eye to it.
And one of the big things that we saw the justices pressing in on from both sides is whether a defendant is entitled to 12 impartial jurors. not 11. So how does that principle shape this case? How is this playing in to them making this decision? And based off of what you're hearing, how are they feeling about that?
Well, ultimately, you got to have all 12 unanimous to have a guilty verdict. If not, you have a hung jury mistrial. So you got to have all 12. That's why the 11 is a problem, and that's why Creighton Waters has focused on the fact that Chief Justice Toll found Juror Z not credible. Is trying to say the standard of having all 12 is not the issue because she's found that that juror was not credible. He has to do that. That is something he cannot concede. If Creighton Waters conceded anything about Juror Z, Alex Murdaugh is getting a new trial. And so it's absolutely cannot concede that Juror Z's sworn affidavit be found credible or be found sufficient to be part of the analysis of the court's interpretation of the law, because if you do that, that's the one juror. That is a mistrial. You do not have a unanimous verdict.
And now, if the conviction is overturned, how quickly could we see a retrial realistically happening?
Many years. You're going to be in a situation where if he was to be successful on this appeal and win, you're going to have a petition for rehearing filed by the Attorney General's office. And then, depending on if it's still the same ruling, they're going to file with the United States Supreme Court, I would imagine, potentially. I'd be shocked if they didn't. This will drag on for many years before he would see the courtroom in a new trial. However, again, once all that's exhausted, that's where it would go back unless it was overturned by a higher court.
And Dane, looking ahead, we've heard the first set of the arguments about having a retrial for Murdaugh. What can we expect once the justices come back from break?
So now that they've gotten the motion for new trial, the jury influence issue with Becky Hill out of the way, I believe Jim Griffin will be the appellant's representative that will come up to argue, and they'll be focused on all of the legal issues that happened during the trial itself. And so the primary issue is the financial crimes, the improper character evidence issue under 404B of the South Carolina Rules of Evidence, 403. Well, bog down the audience with teaching evidence law, but that will be the primary issue is improper character evidence, the financial crimes. Again, that was 2 weeks worth of character evidence that was presented. I believe that should have been significantly limited in scope. I think some of it's admissible, but I do believe it crossed the threshold between its relevance to weighing it with danger of unfair prejudice and should have been significantly limited. 2 weeks worth is absolutely, in my opinion, outrageous the way it was used. Now, in terms of other legal issues, there's a legal issue that's been raised about whether the state improperly commented on his right to silence, and there's other issues related to expert witnesses. So they're going to get into all of those, and the justices can ask questions about any of those issues.
All right, well, thank you so much, Dane. We're going to head back to this appeal hearing because they're about to get back started.
Thank you.
Mental evidentiary errors that individually and cumulatively denied Alex Murdaugh a fair trial. First, the court admitted testimony from a cell phone forensic evidence who confessed that he had never actually done a physical experimentation like the one about which he testified and knew nothing more than anyone else in the courtroom. Two, the court admitted gunshot residue evidence from a blue raincoat despite the fact that the only connecting witness definitively testified that what she saw was a blue tarp and could not be confused with a rain jacket. Three, the trial court admitted unfairly prejudicial evidence over 6 days regarding financial crimes spanning 6 years, the crimes that were committed by the appellants. Four, the prosecution violated Doyle v. Ohio by repeatedly impeaching Mr. Murdaugh regarding his post-Miranda silence after being arrested on the murder charges. And five, the court admitted firearms identification testimony based upon unprecedented methodology that the expert himself
could not state to any reasonable degree of certainty during the counsel hearing. In the interest of time on that fifth issue, I intend to rely on the briefs unless the court has any questions about that evidence. The evidence in this case did not conclusively prove defendant's guilt such that no other rational conclusion could be reached. Therefore, none of these errors were harmless beyond a reasonable doubt. There were no eyewitnesses to Maggie and Paul's murders. The murder weapons were never found. The forensic evidence does not support Alex's guilt. All crime scene criminologists, experts testified that whoever shot and killed Paul shot him in the head, his brains hit the ceiling, and blood and brain matter would have been on the guns and on the shooter. That was without a doubt. And there was no brain or blood matter found on Alex's person, his clothes, inside his Suburban, inside his home. They checked the bathtubs, nowhere. There were trace amounts of DNA found on Alex's clothing that were consistent with his explanation that he checked them for signs of life. There was minimal GSR, gunshot residue on Alex, which also was consistent by the SLED's own testimony, consistent with him going back to the house, getting a shotgun for personal protection, and waiting for law enforcement to arrive. Alex Murdaugh's interactions with others after he left the kennels that night and before he returned and called 911 was normal. He talked to his son Buster, he talked to his brother John Marvin, he talked to another lawyer, Chris Wilson, about the case. They all said his demeanor was normal. Visiting his mother, there was nothing out of the ordinary about his demeanor. There's no time of death established. The coroner did a finger test under the armpit. The state relies exclusively on cell phone data inside the phone to establish a time of death, which was unreliable in our opinion. The cell phone data showed at 8:45 p.m. there's a kennel video. And Alec had lied about previously in his interviews about being at the kennel with his family. But there's a kennel video at 8:45. There's nothing on the video that would lead someone to believe that there's a murder about to happen. It portrays a normal family. At 8:49, Paul used his phone for the last time. It had very little battery left on it. At 8:55, there was some action on Maggie's phone. And at 9:06, Maggie's phone registered movement for the last time, some 20 minutes after Alec testified that he left the kennel. We submitted an expert on acoustical testing, and it was uncontradicted that if you're in the house with the door closed and the TV on, air conditioner on, you could not hear gunshots down at the kennels. And then Alec's testimony himself denied killing his wife and son. So this was not an overwhelming evidence case. This was a very close case. And the cell phone and GPS data, frankly, pointed to his innocence, not his guilt, as I will explain in a moment. And that brings me to the first issue that I'd like to address, is that the state was allowed to present expert opinion testimony about a test that was done during the middle of trial from a cell phone forensic expert, a deputy from Charleston, who had previously been testified about chain of custody and other issues, that during the weekend after our expert testified, and it's critical to know that Maggie's phone was found on the side of the road about a quarter of a mile down Moselle Road and 15 feet off the side of the road. And when we finally got the GPS data during trial from General Motors and the OnStar data, Alec went by that location doing 42 miles an hour at 9:08 p.m. As I mentioned earlier, Maggie's last phone activity, when orientation change in the phone, was at 9:06. The question is, if Alec had thrown the phone out at 9:08, would it have registered an orientation change? Would there have been anything in the phone to record him tossing the phone out? And the testimony that the defense presented was, Mika Sturgis talked about the rise to weight feature. He did an in-court demonstration. I was going to bring my phone up here, but if you lift it up, it lights up. All of us have.
What's your theory as to when the phone was tossed out of the window of by someone? What does the timeline show? I take it your argument is that when you toss the phone, at some point it's going to the raise to weight feature will activate. So my question is, on the timeline that we have, and it's extensive,
Right.
what is your theory as to when the phone was tossed?
So, Justice James, with all due respect, I want to rephrase it. I think that's asking the wrong question.
Okay.
I think the right question is, would the phone turn on and record any sort of activity if Alec threw it out the window at 9:08?
Yeah, I know you say that, but I'm talking about in the timeline that we have and the cell phone extractions that we do have, when was the phone tossed?
Well, the state's, so you could say one explanation, it was tossed at 9:06, because that's when it registered. Or you could say at 9:06, it was down at the kennel. Well, we don't know. Honestly, we don't know. We don't know how it got put on the side of the road. There's no witnesses. But what's so critical to our defense is that at 9:08, when Alex Murdaugh goes by that exact same spot at 42 miles an hour, if he had thrown the phone out the window, what would have happened? And the state says they were just replying to our expert, Mika Sturgis, who said he's not qualified to say whether the light would come on or not, whether it would register anything.
Similar question. I don't think you have to have a theory. That's the state's burden. But when we're looking at your argument that Alec didn't throw the phone out when he drove by because it didn't light up, that raises the question of how it got there. Somebody put it there.
Without no doubt.
And it never lit up. So the point that you're making is it's wrong for the state to be able to prove that it might not light up. But to me, it looks like it definitely didn't light up, because whoever put it there, unless it was at 9:06, the phone did not light up. So I'm raising the question of whether this even makes any difference.
Well, it makes tremendous difference, because if Alec threw the phone out at 9:08 when he goes by that location, our evidence, not through our cell phone forensic person, but through our accident reconstruction acoustical guy, Mike Sutton, with Accident Reconstruction Institute in Raleigh, North Carolina, says that phone at 42 miles an hour will tumble. And when it tumbles, that raised to wake feature. So we did put in the evidence through two witnesses, both qualified, about what they testified.
I got that, but let's just hypothesize that Alec didn't do it. He didn't have the phone in his hand when he rode by at 9:08. Somebody came along at 9:20, these roving marauders, you call them, or whatever, and they killed the Maggie and Paul, and then they were responsible for getting the phone to where it ended up. Wouldn't the phone have lit up then?
It depends on how it was placed there.
If we don't know whether it would have lit up then, we also don't know whether it would have lit up at 9:08.
Well,
that's why I'm asking why this even makes any difference.
Here's what we know at 9:08. Alec car is going by that spot at 42 miles an hour. Did the marauders go by and pull over?
Maybe.
Were they walking? I mean, we don't know. There is no evidence in the record. What there is evidence in the record is he went by that spot at 42 miles an hour, didn't slow down, didn't speed up, and if he had tossed the phone out, it would have tumbled, and all it has to do is go upright, and the rise to wake feature would come on, and so to combat that, they had a guy sit around the weekend throwing a phone around his office from Friday
You
and Saturday.
cross-examined him very thoroughly, and said, he said he recorded nothing about his experiment. He wasn't an engineer. He didn't know more than anybody else, and he didn't testify to anything you couldn't look up on Google. So what's the harm in that? I mean, your cross-examination seemed to be very effective.
Well, the harm is the expert opinion he was allowed to express that says it was possible that the phone would not illuminate if thrown from a vehicle going 42 miles an hour. The harm was when Mr. Waters gets up in this closing argument and says, Paul Murdaugh got up here and testified as to the issues and to the fact that there's no guarantee, in fact, more likely than not, if the phone is violently thrown or flipped out or whatever, it's going to light up. I mean, that was critical to their defense to address, our exculpatory evidence that we went by there at 42 miles an hour, and if we had tossed the phone out, it would have shown something. If they wanted to test that, They needed to put an expert in a car doing 42 miles an hour, throwing it out the window, and then checking the phone to see what happens, and do it multiple times. But you don't sit around in an office as if you're playing cornhole with a beanbag all weekend, and then come to court and say, sometimes it lights up and sometimes it doesn't light up. And therefore, I conclude that, it's more likely than not it wouldn't have lit up if Alex Murdaugh went by there at 42 miles an hour.
This is certainly an unconventional moment at the trial, and I was reflecting back on 10 years of trying cases, none of which were 6 weeks long, and in the state's reply, everybody's tired, everybody's ready for the case to go to jury. It's almost like there's this unwritten rule of evidence that at that point in the trial you can pretty much do whatever you want. But the question is, what did they do? And you're saying when they stood up to speak to Judge Newman, they said, we got an expert. In their brief, they talk about it simply being an experiment. Judge Newman listens to all this, and he calls it an experiment. He doesn't call it expert testimony. He says, page 6721, he did not provide scientific testimony. He conducted an experiment and told the jury about it. And I'm just wondering, do we really need to go through a 702 analysis here, or should we be talking about the admissibility of an experiment?
Well, I believe this court's opinion in State v. White in 2009 that Justice Kittredge wrote, there's no distinction between, it's an opinion testimony.
Well, that was an opinion. That was an opinion based on the work of a drug dog.
Right. So, and here we have an opinion testimony that when Alex Murdaugh goes by that location at 42 miles an hour, the light may come on, may not come on. More likely that it won't come on. So that's the opinion testimony. And that is, whether it's scientific or experience, it doesn't matter under the analysis. But it had to be proven to be reliable, and it wasn't.
Mr. Griffin, I'd like for you to address the 404B issue, if you don't mind.
Yes, sir.
Do you believe any of the evidence about the defendant's financial crimes could have been admitted under 404B as motive evidence?
No, not a bit, Your Honor, not as motive evidence.
And I have some questions, I'm sure we all do, for Mr. Waters in terms of the expanse that was allowed under 404B. But what about like Ms. Seckinger's testimony, for example, on the day of the discovery of the theft of the Ferris fees? What about the impending motion to compel hearing in the so-called boat case a few days later that would have arguably exposed the extent of his financial misdeeds? Why wouldn't that have some relevance for 404B motive purposes?
Well, we have the benefit of extensive in-camera hearing, well, not in-camera, but hearing outside the presence of the jury, and where all of these matters were testified to. And Ms. Seckinger said that on June 7th, she went to confront Alec about, this Ferris fee. Now, understand this Ferris fee is a one-off situation from all his other scams and schemes. This was attorney's fees that were due to the law firm that he diverted to himself. That's the Ferris fee. And that's what was their concern, and her testimony was they weren't concerned that he was stealing money from the firm. They were concerned that he was hiding money from civil discovery from the boating case, and they didn't want any part of that. She also says when she's in there talking to him, he gets a phone call. They put his dad back in the hospital, and I took my CFO hat on, and I put my friend hat on, my mama hat on, and I started comforting him, and that was the end of it.
So until the moment of the call about the impending declining health of the father, we're in the motive territory. But once the urgency was removed by that phone call, it somehow's off the table?
I still don't think it's motive, because what the cases cited by the state and any case that you look to, for motive, it has to, and the cases that admit these type evidence in a murder case, is that the person murdered is either the victim, the person murdered is a threat to report the crime, the person murdered has life insurance, or the murderer is bound to benefit financially to get himself or herself out of the financial hole. I mean, none of those typical motive issues are present. what was present is this claim of sympathy, which in West Virginia v. McGinnis, and that really is the closest case that we can find about this, Your Honor. I mean, they reversed a murder conviction for letting extensive financial crime evidence and other information in, and I would read to Your Honor the conclusion from the court in the West Virginia Supreme Court. And it says, the cumulative admission of the evidence under 404B, however, presents us with a likelihood that the jury convicted the defendant because of his character and not because of the evidence surrounding the murder. In these circumstances, these errors cannot be regarded as harmless. And you can't just piecemeal it either. I mean, there were 10 witnesses over 6 days, 38 transactions.
Was there any 404B evidence that was proffered by the state that was disallowed?
No, Your Honor, not that I can recall. And then, you know, so you have 404B analysis and you have 403, and really the unfair prejudice just by the weight and the extent of that evidence, the sheer volume, 38 transactions, $9.97 million, 10 separate witnesses. In State v. James, I know it's a little different because State v. James involved prior burglary convictions with an enhancement, but the conviction was reversed where 7 burglary convictions were admitted when they only required 2, and there were limiting instructions given, and the court said that was it was not harmless error when you pile on that much, and this was piling on.
Let me ask you a question about the legal point of whether there's a logical connection or some logical relevancy, using the language our cases have used. I mean, you make a lot of good arguments that it makes no sense. Like this, he would never have done it for this reason. And obviously those arguments are in part at least for the jury to iron out, right? I mean, you made them to the jury and that they decide whether this makes sense in terms of a motive. But what I'm asking is, to what extent does the trial judge, when looking at a theory of motive that isn't 100% solid, to what extent does the trial judge analyze the believability, the ultimate usefulness of the theory of motive before admitting the evidence? And just to continue a second, you know, in Lyle, we said that the trial judge has to clearly perceive the connection. Right. In Perry, we of course quoted that, but we also talked about the trial judge using a rigid scrutiny. I mean, really, in Lyle and Perry, though, the question was not the existence of a logical connection, because in Perry there clearly was one. I mean, in Lyle there clearly was one, and in Perry there clearly was not one. At least the majority said so. But in both cases, the real question was unfair prejudice, and I'm just wondering if this idea that the motive theory doesn't work is really a question of unfair prejudice as opposed to a question of logical relevancy.
Well, it's both. You have to do both analysis. Chief Justice Kittredge asked me if it was motive evidence. I don't believe it is motive evidence. It's certainly unfairly prejudicial under 403, and I was, to answer your question, Justice Few, I was about to cite to Lyle, the standard in Lyle, which is a very high standard. And what you have, and I think it should require, and I believe the law makes it require, more than a prosecutor's best theory. I mean, there has to be some evidence to support it, and it has to be like life insurance policy, a windfall, things of that nature.
Or I hate to use this example, but perhaps this looming cloud, storm cloud, so forth, would have given him motive to do harm to someone who was going to blow the whistle on him, instead of,
that's right,
according to you, too many degrees of separation of murdering his wife and child.
Well, if there was evidence of that, and that's in the case law, yeah, if there were a threat to report, for sure. But none of that exists in
Was there any evidence that Maggie was getting wind of these financial misdeeds? She did have a bounce check or two, right?
I believe she perhaps
I mean,
had.
was there any evidence that she
Yes.
was going to confront him about money?
None whatsoever. None whatsoever.
And Paul, who's described as the detective, was there any evidence that he had any information about his financial misdeeds as opposed to him hoarding pills?
No, Your Honor. It was only his drug use Paul was aware of.
I want to branch off for a moment. On page 6,340 of the record, Mr. Waters was cross-examining Mr. Murdaugh. And if you read it, it is very, very compelling cross-examination. Of course, Mr. Murdaugh's on the stand, so his credibility is in question. Let's assume that this financial crimes evidence came in reply.
Right.
Because a series of questions that Mr. Waters asked Mr. Murdaugh was, you lie, basically suggesting he lies with ease.
Correct.
Seamlessly lies about everything. Did you lie to your brothers? Did you lie to their wives? Did you lie to Marion Proctor? Did you lie to Bart Proctor? And all these answers were yes. Did you lie to the Brandstetters? Did you lie to Chris Wilson? Did you lie to them about the kennels? Did you lie to Mark Ball? So when his credibility comes into question then,
right,
could this financial evidence have come in reply? I know that's not what we have here, but doesn't it kind of open the door, or maybe you would have chosen not to put him on the stand had the financial stuff not come in initially?
Well, there are 2 points with that. One, I don't think we cited case law that we don't waive our right to challenge that by putting him on the stand to address it.
I get that.
But to answer your question specifically, under 608B, Your Honor, you are not permitted to put in extrinsic evidence of these things. You can ask him about it, but you can't then take 6 days and 10 witnesses. I mean, you ask him the question, and if he answers it, you got it. If he denies it, you're stuck with it. That's what under 608B. You're allowed to cross-examine him, but you're not allowed to introduce extrinsic evidence.
What if the questions had been more expansive? Did you lie to your partners about not stealing $9.7 million? I mean, it becomes, it's a different dynamic, I understand, but what I'm trying to search for is, would this have come in anyway?
Well, I do believe under 608, it's fair ground for cross-examination on his credibility. But then you get the 403 analysis. Excuse me?
You're stuck with his answer, which would have been
Right.
yes.
Yeah, but you don't get to then start putting up 10 witnesses to prove something that he's admitted to.
You get a new trial is coming in, but it's only, at least under 608.
If he testifies.
If he testifies. And in that event, you get another limiting instruction that says you can only use this to analyze his credibility.
Correct. Thank you.
I think this question is about.
Oh.
Wait a minute, we're just getting started.
About the weapons? Yeah. We have a question. We want you to argue about the admissibility of the weapons that were seized and introduced that were from Mizell.
Yeah, so in the weapons that were introduced in the evidence that were seized from the home, there was no testimony from anybody, even their.
Well, it's beyond that. The experts admitted that he could not identify it as a murder weapon.
Well, he said he couldn't include them or exclude them. And so, as we said, these guns, we know nothing more about them today than we did, any other day. Yet they were allowed to put those in the evidence. And we've got State v. McConnell and another case where I think McConnell, where they put .22 caliber bullets in evidence on a shooting case. And the person was shot and killed with a .357 Magnum. And that case was reversed. There was another case that we also cited, lost my place in my notes, but that.
What was the purpose, as you understand it, for the admission of the weapons that were seized from Mizell?
To prejudice Alex Murdaugh. I mean, that was the purpose. It made nothing more relevant or not relevant. I mean.
Didn't you suggest, though, that the police who investigated this had failed to do a complete job, and in particular, that they had failed to properly seek out and find the murder weapons?
Absolutely, and that stands
And wouldn't
today.
a simple response to that suggestion be, we looked at every 12 gauge and 300 blackout weapon on the property, and here 4 of them.
Here's pictures of 4 of them, but you don't put them into evidence. You can have Greer testify, I tested all these guns. I don't know anything more about them today than I did yesterday. I can't include them or exclude them. That testimony is perfectly appropriate. But
After they were put into evidence, were they ever used or referenced again, touched again?
Absolutely. The Attorney General picks it up, holds it up, pretends that he's shooting somebody. He picks up the 300 blackout and reenacts the crime. Mr. Kinsey used them.
Well, they can be used for demonstrative purposes. You just object to them going back into the jury room. Is that what you're saying?
We did object to them going into evidence, for sure. And they could have had a demonstrative, demonstrative exhibit to demonstrate to the jury, but that's not what these were. These went into the jury, and they did an in-court reenactment with them.
Mr. Griffin, I interrupted you a little while ago to segue to the 404B issue, and I think you were either at or near the conclusion of your argument regarding the cell phone experiment.
Right.
And if I cut you off, I didn't mean to, and I want to give you an opportunity if you want to finish any thoughts you had on that issue. It seemed very important to you, and I want to give you that opportunity.
I was done with the cell phone. I was going to go to the blue tarp and then the Doyle v. Ohio issues, but I'll rely upon the briefs, and Mr. Barber may be able to address it on reply. But I'm happy to stand up here and answer any questions about those issues.
I got a question about the cell phone.
We have a question.
Help me out here. The evidence was Mr. Murdaugh didn't use his phone from 8:09 to 8:40 something, 8:50, maybe 9 o'clock, right?
Right.
Which was unusual for him, according to the evidence. What does it mean in the testimony of the cell phone extraction witness when a call was in the Verizon records but not on Mr. Murdaugh's extraction? What does that mean? There's a series, I made a series of notes. This call was not on his extraction. It was on Maggie Murdaugh's extraction, but not his. 905 calls Randolph, not on extraction. Does that mean that the inference is that he physically deleted it on his phone?
I believe so.
And there were probably 10 or 12 or more phone calls that were deleted, if that's what the explanation is about not on his extraction.
I believe that is the case, that the information was deleted from his phone for some reason or another.
And this goes to circumstantial evidence of something, that he deleted the call. Was there any explanation at trial from your side, not that you were required to give one, as to why those calls weren't on his extraction?
There's no testimony about that at trial.
Okay, all right.
I have thoughts about that, but it's not in the record.
All right.
Justice Hill has a question.
Maggie's phone did not record steps at the time, and you make a point about that.
Yep.
But you also, the location data got overwritten. Did that override the step data too?
That did not override the step data.
Okay.
And that was maintained in a different place. But the GPS data is pinging constantly, and there's only so much room. And SLED did not put that phone in a Faraday bag, which I didn't know what a Faraday bag was before this case, but they give them away at conferences, so it's not unique.
Thank you.
All right, no further questions. Thank you so much, Mr. Griffin. Appreciate it. Yes, sir, Mr. Waters.
Thank you, Chief Justice, and may it please the court. I'll start out by saying, and again, I'm not going to, unless this court would like me to go through the extensive facts that were presented here. But fundamentally, our case boiled down to 4 important points. Number 1 was motive, and I know we'll talk about that. And I believe that the motive was very compelling here, and we'll go into that. But the motive pointed to Alex Murdaugh. Number 2 was the means to commit this crime. And what the evidence showed were 2 family weapons were used to commit this crime, both of which could not be accounted for after the crime was over with. Number 3, opportunity, and this was huge. That timeline that was very detailed that frankly the defendant tried to use to be exculpatory actually was very inculpatory and showed that not only was he at the crime scene with the victims just moments before they died, but importantly had been lying about that to anyone who would listen. And that evidence was particularly strong when you look at the fact that when we look at that kind of evidence, we look at patterns. And what was also so important about him being there is that his phone showed no activity, as Justice James mentioned, from about 8:09 to 9:02. And then from 9:02 to 9:04, he had 283 steps, far, far more than he ever had in any comparable period during the review period that we had. So you had that evidence of opportunity showing that he was the one who had the opportunity to commit these crimes. And then finally, you had multiple acts of guilty consciousness of the various things that he told law enforcement and all the rest of it. So that's a classic case. It may have been a long case and put it all together, but it boils down to basic, good old, how do you determine who did somebody? Motive, means, opportunity, and acts of guilty consciousness. And I think the evidence was very strong with all of that. We started with the cell phone evidence, and I'll go to that as well, since that's what counsel started with. And I want to start out by saying, first of all, that this is clearly not preserved. I'm going to talk about that very briefly because, as Chief Justice Kittredge pointed out earlier, this was an old school judge. You got old school lawyers, old school prosecutors, and Judge Newman made it very clear at the beginning of this case what he expected with objections, that they be timely and that they be specific, okay? So this is not a case where preservation is a gotcha moment. This is a case where the judge was very clear about what he expected with that, and the parties that were trying this case are ones who understood that very well. So I think if there's ever a case to look at error preservation issues we've raised throughout this brief, this is that case to do that. But beyond that, let's look at what happened during the defense case. They called an expert who, Mr. Surgis, who is a former North Carolina deputy who has digital forensic examiner training in Cellbrite and Apple, and he was qualified in cell phone forensics. And while he was on the stand, he used an unidentified iPhone with an unidentified iOS operating system to demonstrate for the jury that just a general motion will cause the raise to wake feature to turn on. And they emphasized that over and over again, that all it took was a gentle motion. Just a gentle motion is all it took. And they did that demonstration on the stand. And so the state, in reply, called a deputy who had extensive training in digital forensic examination, same exact training, who was qualified without objection in the same exact cell phone forensics. And what was more important here was he was here to correct fundamentally what was a misleading statement from the defense examiner, because what he knows, and he knows how these things are programmed, he knows how they work, and the implication that if only a general movement will turn it on, that necessarily a more violent one like slinging it like a frisbee will turn it on, is false, because the phones are designed and programmed, the accelerometer in there are programmed so that while a gentle, normal motion when somebody wants to look at their phone will trigger it, violent motion will not, so that your phone's not constantly coming on when you're jogging or running or doing anything like that. People don't look at their phone like that, okay? And so the phones are designed to do that. So he did the exact same thing that the defense examiner did, except for he did it much better, because first of all, he used the exact same model iPhone. He used a similar iOS version that was used, and he manipulated it multiple times in many different categories. And it was there to ultimately disabuse the notion that if it comes on gently, it necessarily is going to come on when you sling it, because it just doesn't. And that is how iPhones work. And so when he was in cross-examination, and Mr. Griffin did a great job of cross-examining him, and at one point he says, well, I don't know anything about anybody else. Well, maybe that was an inopportune answer, but that's not the end of it, because he went on after that to testify, I have expertise in how cell phones work. I can tell you about the knowledge seed databases. I can tell you the ways iPhones, the software is written, what kind of code it's written on, and I can tell you how data is stored on it and the program that's involved in it, the programming that's involved in it. And frankly, his testimony proves the point, because he made sure that the jury understood that just because a gentle raised awake, a general motion will trigger the raised awake, doesn't mean that a violent motion will do that. In fact, it's more likely that it won't, and the phones are designed specifically to do that. That is an expertise that is beyond the knowledge of the average person. And again, this is not one, I think, as we talked about before, where you need to apply the counsel factors and all the rest of it. When you're talking about sort of an experiential type of testimony, the ultimate test is reliability. And he had the same exact qualifications, the same background, and was qualified in the same manner.
But his testimony was, sometimes it does, sometimes it doesn't.
That's correct. And that's the reality of how it works. Because again, these things are programmed to react to different types of inputs, and it's not an absolute guarantee. But the point that was important about that was that just because a gentle motion might turn it on doesn't mean that a violent one would. In fact, it's more likely that it won't, because the phones are programmed to do that, and like throwing it like a Frisbee.
This is probably not relevant to much, but why this phone being taken from the scene, and why not Paul's? Why not just leave hers there too?
Well, that's very interesting.
Was there any, I know, is there evidence, I think there's evidence that it was raised to wake at some point and put back down.
Yes.
And that was at 9:02, 9:04, something like that?
Correct. So the evidence, if you look at that timeline, and I could go into it in great detail, but what the evidence showed and what the reasonable inferences from it was, number one, Alex had Maggie's passcode. He did not have Paul's passcode.
You might need to stick closer to the mic.
I apologize. All right. So he did not have Paul's passcode. Paul's laying face down, and his phone is laying just on the outside of his rear end, outside of his pocket. And in fact, the defendant told police that he picked up the phone, or he tried to turn Paul over, and the phone just popped out. Okay. But what's interesting about that is what's so crucial about the time of death and the forensic timeline, as we called it, establishing that time of death, is that Paul was actively in a conversation with his buddy, Rogan Gibson, and that's who the kennel video was for. But he never completed that conversation, and both Paul and Maggie's phone go silent forever and ever, amen, at 8:49, about 30 seconds apart. Well, Rogan continues to try to contact Paul, all right? And so when we look at contact on Paul's phone, there's somebody who actually looked at it, and the backlight came on, which is indicative of somebody, the Face ID, not recognizing who it was. But as we know, those phones will display like messages coming in. And very interestingly, Alex Murdaugh, in the wake of the brutal murders of his wife and son, yeah, he calls his brother, but then before he starts calling all these other family members, he's blowing up Rogan Gibson's phone. Okay? So the inference is that he saw that, he can't get into Paul's phone, but he's concerned about Rogan. The other inference is that he takes Maggie's phone with him, because we see steps on her phone, and we also see activity of the orientation changing, and that orientation will only be logged if the backlight is on. And so when he gets back to the house, that's all of a sudden when his phone comes alive. From 9:02 to 9:06, there are 283 steps, but at the same time, we're seeing orientation changes, and he is calling Maggie's phone. In fact, we can see an orientation change 2 seconds before the call comes in, which is certainly susceptible to the inference that whoever's calling is looking to see that call come in, like somebody who's manufacturing an alibi, like somebody who tells the police in his first interview, look at my phone, I was calling Maggie. He calls her multiple times while he is running around like a chicken with his head cut off, and then jumps in the car. And even though he said that Maggie came home because he asked her, or she was worried about him, and Marion Proctor testified that Maggie came home to go visit Miss Libby, after all of that, and he's blowing up her phone, he doesn't take the 100 yards down to the kennels to drive by there. So again, not to argue the facts, but all of this was very indicative when you look at this timeline of Alex looking at Paul's phone, leaving it there, taking Maggie's phone, taking it up there, start manufacturing, making sure those calls are coming in, and then as he's leaving out in a haste, he's leaving out of the Moselle, slinging the phone out on the road. And the reason why the backlight, there wasn't an orientation change for that is because the backlight didn't come on, and that was the point of McManigle's testimony.
I'm not asking you specifically, I want to change gears to 404. I'm not asking you specifically in this case because I know you believe your motive is very plausible. But in general, how plausible does motive have to be? I mean, could a prosecutor want evidence in and work backwards from there? How does a trial judge analyze that?
Well, I think that the trial judge is fundamentally the gatekeeper and ultimately has to analyze that under the 404 test, which is it relevant? Is it fall under an exception? Is there a logical connection? Is it clear and convincing? And is it, the 403 analysis? I think that.
So not just the evidence you're trying to admit as motive, but the motive itself has to go through a 404 analysis. Is that what you're saying to me?
Well, I'm saying that the evidence that's being presented, every bit of it, yes, has to go through that and be part of that 404 analysis. But I think here, and I'll talk about this, that there's an unbroken chain, and that's why the extent, which it was extensive, but there's a reason why, and it wasn't overkill, it wasn't cumulative. But yes, the trial judge is absolutely the gatekeeper for that. Now, what we did here, and I think this is the best practice, is we wrote a detailed pretrial motion and laid it entirely out, wrote out every bit of it, wrote out the entire theory, and put that out for the defense and said, Judge, defense, this is what we're planning on doing. And in opening, I was very careful. I just said there's going to be things going on in his life. I didn't talk at all about that. And then we did the in-camera hearing, and we were very careful. And before I even broached those subjects, I raised that to the trial judge to ensure that the entirety of that was being considered.
Was there any 404B that was disallowed?
There was. So there was 404 of evidence of an affair that Marion Proctor and Maggie's concern about affair that he excluded as too remote. And then there was a side of the road and narcotics evidence, but ultimately that eventually came into play because of opening the door.
Was there any 404B related to financial crimes that was disallowed?
I think no, but I think that
That's what concerns me, and I want to just gently push back and give you an opportunity to respond. Yes, the judge is a gatekeeper. Unlike the federal counterpart of 404B, our case law has said that our version of 404B is a rule of exclusion, not inclusion. Right. And the gate here was just left open. And I couldn't find any example of financial crime evidence that was excluded. And the granular detail in the expansiveness of which everything under the sun was allowed is arguably problematic. Even the nature of the victims, there are many examples here, and I want you to respond, so I'll just share one. I think his name is Tony Satterfield, was testifying. Well, we had to hear about the disabled brother. How is that relate to motive evidence? That appears to be that not only is he a thief with a motive for murder, he's a despicable, low-life character. I mean, the very evil that 404B is designed to prevent, and then ultimately 403 as the final safeguard.
Well, first of all, I'll say that this was never argued nor presented as propensity evidence, and frankly, this court has recognized, and other courts have recognized, that the less likelihood of propensity when there's a vast difference between the type of 404 crime and the crime it issued. You know, once a stealing white-collar lawyer, always a wife and son murderer, that's never was the inference and all the rest of it. Satterfield was independently relevant, and we streamlined this inquiry intentionally, and the defense made their general objection to the 404, but never did, once we kind of crossed through that door. We presented all of that in camera, never made any specific, like, limit this part, limit that part. We tried to streamline it all. The only reason Satterfield was a witness who testified specifically was because Satterfield was one of the factors in the gathering storm. Satterfield, of course, there had testified that appellant had reached out to him and that he had reached out to appellant in the months leading up to the murders, I think even in June of 2021, asking about the case and about the settlement. And Alec, of course, is lying to him and saying, yeah, I'm still working on the case, I'm still going. But the reality is that he stole almost $3.4 million and had spent it 2 years ago.
But what did one of the Satterfield children's status as mentally disabled have to do with any of that?
Well, I think the point of that was just sort of the background of how Alec had interacted with them and how this was a family that was close to him.
Did the fact that the young man was disabled add to the fact that he stole?
I think what it added to, again, was we had a witness who was testifying for independent purposes, and that was just a background fact of the pressures on Alec, because he had taken this family under his wing, a family who had one individual that he had told, I'm going to help you, I'm going to take care of you, one of whom had special needs. He had spent all of that money. They're asking questions about it.
The sympathy directed toward the victims of the crime is not related to the motive. If he's a thief, and that was the motive for doing it, this extraneous information that tugs at your heartstrings is not related to that. And like when I asked you the question earlier, you responded by immediately segueing back to the financial crime itself.
Right.
Not this extraneous stuff of every granular detail of his acts of theft.
Right. And I will just say, in putting that in, that was just, we had a witness testifying, that was part of the background information that witness testified to, and that, again, it was part of his interactions with this family that was part of the pressures, one of a myriad of factors that were all coming to a head in June of 2021.
If you had condensed your theory of motive, the whole gathering storm thing, down to the essentials and left out all the stuff that the Chief Justice and Justice James were talking about. In my view, you could have done that in about an hour and a half or 2 hours. You took 12 and a half hours to do it. So then you're taking that condensed version, you're presenting it to the judge to try to establish a logical connection. This is following up on something Justice Verdon asked, and also asked the same question of Jim Griffin.
Right.
What is the level of inquiry that the trial judge goes into to kind of get to the legitimacy of the theory of motive? Obviously, the jury would be the ultimate decision maker on that, but to what extent should the trial judge question whether it's a valid and legitimate theory of motive?
Well, I think that the words of the logical connection are there, and I think that as far as the trial and the clear and convincing nature of the evidence, but I think as long as it is a passable theory of motive and that motive is logically connected to the underlying crime, then ultimately, as you say, it's for the jury.
In all the cases that I think we've looked at this logical connection question, it's been either easy, yes, there's a logical connection, or easy, no, there's not one.
Right.
Here, it's not easy. It's debatable, right?
Your Honor, I would say, and if you'll permit me, I'll go through why these are all connected and why this is a unique situation, and it demands, it's a complicated situation, and I would submit demands a complicated analysis of the law. It's not the typical case where you have a one-off crime, a few hours. It's not Adams, right, where it's an armed robbery just a couple hours before and they're smoking crack and that sort of thing. This is a long, unbroken chain. And Your Honor, you can't understand the boiling point, which was crucial to the state's motive. And I always say motive is not an element, but it's the only element. And particularly in a case like this, where it's the murder of a wife and son, it is what everyone wants to know. And there's no disconnect between someone having a financial motive for a crime. I mean, it's in the movies, it's in Fargo,
I hadn't seen Fargo. Get to the point.
All right, yes, sir. All right, but I'm just saying this is in a number of movies. But let's look at why this is all interconnected. First of all, it's all interconnected, despite how temporal the temporal time period, because What's relevant to motive is what is in the appellant's mind, okay? And what he knows is potentially going to be and is about to be exposed. And that's all of it. And frankly, it eventually was. So what is relevant is not, well, it was just yesterday or it was last week or it was a year ago. What is relevant is what does he know all is about to come out? And that's a decade of him constantly staying one step ahead of the game through one theft as another. And that brings up the second point, that this is all interconnected. It's an unbroken chain, and you can't truly understand, in what is crucial, motive, you can't truly understand the boiling point if you don't understand the slow burn leading up to that, okay? And the defense put motive in issue as right. Their biggest thing was, frankly, character evidence of he's father of the year. There's no way he could have done this. So this, in the case law, says that where motive is a central issue like that, that there is a wider scope. But let's talk about it's interconnected. The jury could not understand the full weight of the pressures if they didn't understand that entire criminal and financial history. You can't understand the need for it without understanding the lifestyle, the bad real estate deals, the maxed out loans. You can't understand the Badger theft of over $1 million if you don't understand that they had, with his bank co-conspirator, had stolen $1 million from the Plier loans, and that had to be accounted for. You can't understand the need for fake forge and why he did that if you don't understand the complications of having to steal that $1 million.
I think all of that is completely accurate. Mm-hmm. The disconnect that the defense is getting at and that I'm trying to ask you about occurs when he takes the what the judge called some sort of urgency. He had a nice phrase he used when he was ruling on it. How do you get from that to murdering your wife and son? That's the disconnect that the defense is focusing on. They're not focused on the disconnect between forge and stealing money. That everybody understands that. And my question is, when analyzing that disconnect, what's the point of law? What's the rule of law that we look at, that the trial judge looks at?
Mm-hmm. Well, again, I think that the trial judge makes that determination of whether there's a logical connection and whether or not the evidence is clear and convincing. And I understand that under South Carolina there is a gatekeeping function that is there, but I think that as long as that
Let me throw out a couple of examples and I'm going to leave this alone. Mm-hmm. Obviously, you think there's a logical connection. Is that enough for the trial judge? Or does the trial judge have to decide for him or herself whether there's a logical connection? Or does the trial judge have to look at whether there's a reasonable possibility that the jury might find there's a logical connection?
I would assert that the trial judge should look to whether or not that is a reasonable inference from the evidence. And if it's a reasonable inference, and then it should go to the jury. I mean, that's what we do with all sorts of evidence, is determine whether or not there's a reasonable inference from this evidence. And if so, reasonable inferences are for the jury.
Can I follow up on that?
Yes, sir.
I think Justice Few wrote State versus Perry, and
I wrote 3/5 of it.
Yeah, it helps the Forrest Gump and me understand it. Mm-hmm. This 404B evidence. I am also struggling with the logical connection. Your brief is excellent, phenomenally done, but you say in the brief on page 87 that according to Perry, relevant is defined as evidence having a tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable, so forth and so on. You emphasize the word any. And what I fear is if we get on that train and emphasize the word any, that allows speculation to enter the room. Help me out with that, because I would accept, you emphasize in your brief, boat wreck, boat wreck, boat wreck. That's all Alex Murdaugh wanted to talk about when he was on video.
Right.
I get that. So I think there's clear evidence of motive for him perhaps to kill Paul, because this boat wreck case was becoming an anchor around his neck. And then you could stop right there or get into the boat wreck accusation more. But your emphasis of the word any, to piggyback on what Justice Few was saying, I'm struggling with the logical connection that comes from the word any. Mm-hmm. That means, it seems to me you're just saying whatever we say that makes sense, let's stick with it.
Well, by emphasizing that word, I don't think, and I'm not at all trying to assert that any sort of speculation would be sufficient. What I am saying is, again, the words logical connection. And I think that if it is a reasonable inference, as I just said, I'm not saying that the trial court should just entertain any speculation or any sort of fanciful thing that they come up with. I would, though, encourage y'all, though, to look, not only at the brief, but look at the filing that we did beforehand, and look at the PowerPoints and look at the closing argument. That this is not just a speculative motive. This all ties together, and I had a whole series of how I could go through all of that, I think there's about 10 factors of all things that were all coming to a head, all of that gathering storm that were coming ahead to that day. And that ultimately this, if you're looking at the validity of this, it actually worked. It actually worked, because when all of this happened, Paul, who you just mentioned, had become that liability. Well, Maggie was too, okay? Her name was on Edisto. Her name was on Moselle. And he was at the end of his rope and unable to move like he needed to move financially, and out of options. He had burned through $792,000 in less than 2 months. And all of these things were coming to a head. But when this happened, everything changed. All of a sudden, he was the center of attention. All of a sudden, the sympathy factor kicked in. All the inquiries stopped, and the boat hearing stopped. The plaintiff in the boat hearing said, this has totally changed the balance of my case. And what did he set about doing? There was testimony that he wasn't overly concerned about Buster's security. He wasn't overly concerned about going after the real colors. But you know what he did do? He fixed the glitch. He fixed the glitch so that his lawyer friend would send back or at least send an email saying all the money's here, and put that to bed. So if we're looking for that logical connection, whatever standard is applied, this is not speculative. I understand that it can be hard to accept that. Why would somebody do this? But that's precisely why this motive evidence was so probative and so important. And even though this is a unique case and a unique, maybe lifetime set of facts that will never be seen again, that's all the more reason why this needed to be admitted, and for the jury to fully understand this unique individual from a unique background and a unique set of family circumstances and a unique lifestyle and a unique history that all was about to come unraveled. And that was more important to him than anything, and that when this action took place, not only did 2 of his liabilities go away, but all of those hounds at the gate went away as well. And if it wasn't for a check falling out of a file a few months later, it might have worked. It worked for a couple of months.
I got one more question to go back. What does it mean when something's not on his extraction?
It means that, the inference from that is that the user or someone deleted it.
Thank you.
I want to ask a question about tool mark.
Sure. Justice Hugh has a question, sir.
Yeah, I want to flip over to talk about the tool mark testimony by Mr. Greer. There are a lot of cases around the country that have held that this idea of examining shell casings for tool marks is a valid method in trying to determine which guns a cartridge was cycled through. In fact, I'm not aware of any that go to the other direction. So abstractly, it seems to me like it's a valid theory. Maybe not. I'm just setting that aside for purposes of my question. But our cases have required not only that the theory be valid in the abstract, but that the theory be reliably applied. Justice Hill wrote about this in Warner at the Court of Appeals. We decided a case called Galloway recently where we stressed it. And really, I think if you go all the way back to Watson, that's what the court was talking about. As I read this record, there's nothing, I mean literally zero, about how Paul Greer used the method. He says he used it, but he didn't say, I found 4 different individual markings. He didn't say, here they are, here's where they were, nothing. And the thing that really troubles me about that is during the cross-examination by Mr. Griffin, I think this was in front of the jury, Mr. Griffin says, isn't your opinion in this case about the shell cartridges being fired from the same 300 blackout, isn't that based upon your presumption that each 300 blackout manufactured in the world makes unique tool marks when it cycles a bullet and ejects it? Now, that's a legit question. For a tool mark and firearms examiner, in my view of it, there's only one answer, and it only has one word, and the answer is yes. It's like DNA. If DNA is not different in every individual, then the fact that DNA, it would be of no use to anybody. Fingerprints are the same way. If fingerprints weren't unique to every individual, then we wouldn't have fingerprint evidence. We also don't have tool mark analysis of cycled gun cartridges unless each gun makes a unique individual mark, right?
Yes, sir.
So when you don't tell the jury anything about how Greer applied the method, and Greer mistakenly fails to discuss the central theory of the whole method, how have you demonstrated to the judge that the theory was validly and reliably applied in this case to these facts?
Yes, sir. Well, I think as we look at the specifics of the testimony, and I would start with, I think with this issue and frankly the TARP issue and the cell phone issue, that these are questions that go to weight, not admissibility. And I understand what you're saying.
What Judge Hill said in Warner or what this court said in Galloway.
Right.
That's not the law.
Right. Well, ultimately, I think that in this particular instance, if you look at the entirety of his testimony, he went through the acceptance generally of this for over 100 years. He went through the SLED procedures. He went through the acceptance and peer review in journals and the quality control procedures, the blind review. So while there may not have been a more specific explanation of that, the general discussion of the applicability and the reliability of the science was clearly in this record. And on top of that, I will also point to this that was in the record that shows that reliability. There's two things. Number one is that the examiner was able to distinguish between the cases around Maggie's body and the cases outside the gunroom door and the cases across the street and say that those were all cycled from the same weapon, but was able to distinguish those from matching it to the one blackout that was recovered, okay? And so that distinguishing right there shows an inherent reliability to the science. And on top of that, then another blind examiner came up with that same conclusion. So that ability that was in the record to separate the wheat from the chaff answers the question, even if it wasn't explicitly answered, as Your Honor points out.
Thank you for your answer.
All right. Mr. Waters, thank you so much. Appreciate your argument, sir.
Right. Thank you, Chief Justice and the court.
Mr. Barber, you're going to handle a reply.
Mr. Chief Justice, may it please the court?
I want to ask you, because it's fresh, you don't get free minutes uninterrupted. I was listening very carefully to all the arguments. Mr. Waters was trying to defend the admissibility of the expansive nature of the 404B. And I thought he made a very compelling point, because one cannot fully understand, I think he used the word bowling point, without all of these interconnected parts. And so that's the logical connection that gives the judge the discretion to allow the fact finder to consider the evidence. So I'd like you to address that 404B issue, and particularly that position argued by the state.
Yes, Your Honor. I thought that the strongest point, really counter to that, was look at what was actually admitted. We had the victim impact testimony from the financial crimes, which I think the questions made clear have no connection. What did they connect to? Mr. Waters had a theme through his examination of all the witnesses. He asked every one of them, did you know the real Alec? Did you really know him? That was a question that was asked every single acquaintance. Did you really know him? You didn't really know him, did you? The theme there clearly was that you didn't really know. He's really capable of anything. He's a bad person. You don't know what he's capable of. And that's why that evidence that's why you had the mentally disabled, victim of a financial crime, which has nothing to do with the supposed motive of I need to conceal something because I might get caught, right? It has to do with you don't really know me. I'm a really bad person. And because you don't really know me, you don't know what I'm capable of, so please speculate that I'm capable of murdering my wife and my child. That was the purpose of that evidence. We didn't have, whatever it was, 12 days of financial crime testimony just to prove the fact that he stole a bunch of money and might possibly have had some fear that he might one day be caught for having stolen that money. And then the speculation is, well, he wanted a distraction, and we can talk about why this would, the logical leap to I'll just murder my family and be the center of attention, and how that's somehow going to get scrutiny off of me, obviously doesn't make a lot of sense. And I think he, more than most people, is in a position to know, given his background, that putting himself at the middle of a high-profile murder investigation is not the best way to distract attention from his own affairs. So I believe that's why that's the logical disconnect. And then the real reason that it's admitted is this trial theme that you'll see in every single witness who had a personal acquaintance with him. Every single one asked, did you know the real Alex Murdaugh? And that's why that was admitted.
Thank you, sir.
If I could, I would like to speak a little bit to the cell phone questions that both got. I believe, respectfully, maybe the factual predicate behind some of the questions might have been a little off. By way of very quick background, the iPhone has a database that records with a timestamp every time the screen lights up, every time it goes off. Various events will cause the screen to come on and off. An incoming phone call turns it on. It stays on for a period of time, it turns off. Incoming text messages, other kinds of alerts. And then there's this rise to wake feature, which is slight movement of picking up the phone causes it to come on and off. Now there's an entirely separate feature called an orientation change, which is it moves a different way enough to rotate the screen we've all seen from portrait to landscape, and that only happens if the screen's already lit. The importance of all this is Maggie's phone screen was lit continuously from about 9:02 to almost 9:07 p.m., right? So it's lit that whole time. It did not just suddenly light up at 9:06 and 12 seconds. At 9:06 and 12 seconds, what happened was the final orientation change, which was a process that took 8 seconds and ended at 9:06 and 20 seconds, right? And at that time, at that exact time, there was an incoming call from Alex Murdaugh, right? So it's rotating, someone's rotating it while he's calling the phone. Her phone was lit up that whole first 5-6 minutes because he was called her phone, I believe, 3 times, texted 1 time. It stays on for a minute after. That's why it stayed on the whole time. So it could have, if the issue is with the screen lit, it was lit at 9:04, 9:05, 9:06. So if throwing it out of the moving car causes the screen to light up, it could have been thrown out at any of those times. But it goes off before 9:08 and 20 seconds, which is when we now know, drove by the point where it was recovered. So the screen is off that whole time. It doesn't come on again until there's another call, 20 minutes later, right? So it's dark the whole time he passes it. So the issue is...
This is all directed at my questioning Mr. Griffin about the importance of the expert, of the testimony, the evidence.
Yes, Your Honor, absolutely.
Your answer is that it's important if the murder occurred between 9:02 and 9:07. Why is it important if the murder occurred after 9:08?
Your Honor, it's not when the murder occurred, it's when, after the murders, when a phone is thrown to the side of the road.
Right, but the phone wouldn't have been thrown to the side of the road before the murder.
Correct. The point is that at the time that we know for certainty the defendant drove past where the phone was thrown, the screen never came on. There's a long period of time before that when the screen is on continuously.
You make a great point. If all this occurred before 9:07, then my questions to Mr. Griffith were, as you pointed out, factually flawed.
Mm-hmm.
But if it all occurred after 9:08, now you answer the question, because I think the validity of my question is now squarely on the table.
If your question is, could it have been thrown out after 9:08 p.m., then the answer would be that would be inconsistent with the screen not coming on, yes. The point is the phone had to be thrown out before he drove past that spot. And that fact was not known until near the close of the state's case, right? Because somebody at General Motors was watching the trial, saw when the FBI agent testified on cross that they don't cooperate with murder investigations. Somebody took exception to that, and they produced accurate data, I mean, to pretty much every 3 seconds, not from his vehicle, but from a server General Motors keeps, far away, tracking his every movement, even though it was years earlier. And so all of a sudden, we know exactly where he is and know with certainty it's to the second when he drives past that spot, and we know that the phone is dark the whole time. So the question becomes, is it possible to throw the phone out at that moment without the light coming on? And as Mr. Griffin said, we don't know how it got there. Somebody could have stopped the car and gently put it out, but we know he didn't do that. So that's the central question. And the testimony from the defense was, here's the feature, everyone can see it. I'm not qualified to say whether throwing it from a car will cause it to do whatever. And we had an accident reconstruction guy who was qualified to say that. But then the defense rebuttal expert, they bring in a chain of custody expert from the direct who says, well, I threw it around my office, no one saw me do it, but I'm here to offer you what Mr. Waters accurately described as an expert opinion, that if it's a gentle motion, this is what it does, but if it's a violent motion, this is what it does, and this is why it's programmed to do and behave in that fashion. That's clearly expert testimony. It was well beyond his expertise. He was offered as somebody who knows how to use Celebrite to download the extractions that we've been talking about. And as to the preservation, it was immediate objections as soon as this came out. The motion was renewed the first time the jury left the room. The judge ruled, Judge Newman ruled for the reasons he gave in the record, which we assign error to. It was not an untimeliness ruling. So I don't believe that there's merit to the preservation argument there. The judge even said that the objection was preserved for the record.
Is there any dispute that Mr. Murdaugh called 911 20 seconds after OnStar recorded that he arrived at the scene where the bodies were?
No, there's the timestamps that OnStar produced and the 911 timestamps are not in dispute. I would note that the nature, it's a rural area, and just because you first got there, it's dark. You don't necessarily immediately see someone the first second OnStar says that you pull up, and you've got to get out and look, and then his phone is connected to the Bluetooth,
Well, what do you say to the state's argument that that's not enough time for him to do what he said he did, which was go check on the bodies, which were 30 feet apart?
In 20 seconds, to look at two bodies that are 30 feet apart, I don't think that's impractical at all. I think I could, if you think about one pace is about 3 feet. If you're alarmed, and you could take a pace in less than a second, right? That's not, you don't even have to break a run to do that.
Can you respond to Mr. Waters' comments or argument about the clerk of court?
Absolutely, Your Honor. I think the most important point to point out with that is that there was absolutely no finding by Judge Toll that Juror Z was dishonest. That is not a finding.
She said she was ambivalent.
Your Honor, she said that only as to her response to the question forbidden by 606B about the influence this had on her deliberations in the deliberation room. She said she was ambivalent whether it was that or pressure from other jurors during deliberations. There was no question of her credibility when she was recounting what Clerk Hill said to her before deliberations began. None. The only evidence presented at that hearing, the only evidence contradicting anything Juror Z said or the alternate said or that was proffered by the egg juror in affidavit, the only evidence whatsoever was the testimony of Clerk of Court Becky Hill. It was not credible at the time, and it turns out that Judge Toll, was good at judging credibility because it has since come out that she perjured herself at that hearing when testifying about a different issue, but about her conduct at the trial. So she was the testimony of a perjurer at that hearing, admitted perjurer, is the only evidence contradicting the statements, the sworn statements from Juror Z, from the alternate juror, from the sworn affidavit of the egg juror. So our position would be that it is would be wholly unsupported by the record to credit that denial from Clerk Hill over all the other evidence in the record. That would, if that finding were made, which the state argues was implicitly made, certainly wasn't explicitly made, that would be an abuse of discretion. However, we argue that that wasn't implicitly made because Judge Toll didn't reach these sort of almost nitpicking, was this said versus that said. She found that her word exactly was improper. Improper comments were made to the jury. She found that it was a deliberate attempt to influence the jury, that she had a book deal. That was all found. But it didn't matter whether it was this comment or that because her decision was controlled by an error of law, which was essentially that the defense had the burden to show some sort of but-for causation to the verdict. It didn't matter because it didn't affect the verdict. Whatever was said was improper, but the verdict would have been the same no matter what. That's the written order. And that is the error of law because the prejudice, which has to be shown, is the prejudice to the fair trial, which is that these things were said to the jurors, right? That's the bias, right? This was said to the juror. That's the bias. We've shown the prejudice when we've shown that it's been said to the juror because now we don't have an impartial jury. There's no need to show the effect of the bias on the verdict.
But he says the comments were fleeting and innocuous. And Judge Toll said limited in subject and not overt as to opinion.
Yes, Your Honor, and maybe to address a question that was asked at the very beginning, is that a question of fact or law? What was said? That's a compound question. What was said is a question of fact. Characterizing it as an application of law to fact is a mixed question. To the extent you have to disaggregate it and say, well, what was said? Again, the only evidence in the record, right? Unless you were to accept the found to be not credible testimony of Clerk Hill, who's also perjured herself, the only evidence in the record is that those don't believe the defense was said. Don't be fooled by the defense. That's the evidence in the record. All right, so given that said, to characterize that as neutral as to opinion is an abuse of discretion, and it is a misapplication of law to those facts. To find that that wasn't said would also be an abuse of discretion because it would be a finding wholly unsupported by the record.
Maybe one? Yeah. I'm just going to remark that it's not fair to you and Mr. Waters that y'all had to talk about every issue and these other two deadbeats over here only had to talk about half of them. But are you good to talk a little bit about some of the real nuances of the tool mark?
Absolutely, Your
Okay.
Honor.
You put in the pretrial hearing, or Mr. Griffin did, so the theory of tool mark is set forth in several documents that have been widely circulated and published by the AFT and so forth. But there have been criticisms of those, and one of the most striking ones is this idea that the conclusion, how they reach a conclusion, is circular, and that makes some sense, really. But my question to you is, wouldn't you say that those criticisms go more to the application of the theory than they do to the validity of the theory?
Yes, Your Honor. If I could, it's important to, I think the best way to look at it is to compare it to DNA evidence because it's so striking, right? Everything in the universe is unique, right? The tool marks are all unique. The question is, do we have a process that can reliably distinguish, the cause of this mark to the exclusion of all others, right? That's the actual question. I did this process, and I can say, with some degree of certainty that, these two tool marks are made by the same weapon and not two different weapons.
To shorten it up, I'm suggesting that you just asked a really good question. Do we have a process to differentiate? And I'm suggesting that these criticisms that have been published, particularly this idea of the circular thing, would answer that question. Yes, we have a process, and it works, it's valid, but it has to be meticulously applied. Is that a fair way of interpreting those criticisms?
It's certainly fair. Where I was trying to go with that is with DNA evidence, as the court knows from the many DNA cases that it's had recently, these differences are quantified, and you get a very, 1 in 8 billion or whatever chance that these, came from different people that we say it's a match, right? Here, you have this very circular and very subjective. What you have in the end is two marks that look really similar, and somebody eyeballs them and makes a subjective judgment call that these two look really similar. And our basis for that is circular because we say, well, I look at this part and that part, and it's like, well, how do you know that means they're the same? Well, that's what we've always done. That's what I was trained to do, and it's very circular.
The theory says you have to find whether they match. And the next question is, well, how do you know that? And you say you have to find sufficient alignment. And nobody ever comes down with a hard rule like you got to find 5 marks on the same cartridge that are identical to the 5 marks on this cartridge. Whereas with DNA, particularly with the ideas like touch DNA, you have the expert saying, I was able to identify 8 pairs of chromosomes and they match to what was at the crime scene or to what we found from the defendant, and that gives a 1 in 1 million chance that it is somebody else.
And to do anything like that with tool mark, you would have to quantify the similarity and differences of the tool marks.
And that's what I'm getting at, is all of that goes to the application of the theory, I think, not to the abstract validity of the theory.
Absolutely, and there could be a day that with computers or AI that you can quantify and do something differently. But right now, having somebody eyeball it and say they look pretty similar to me, I think they're the same, that's not a reliable application of the theory. It's totally subjective. It's not quantified in any way, and it's certainly not something that could be subject to any sort of
I wasn't trying to get you to concede that the theory is valid. I was really just trying to focus in on the importance of an explanation of how the theory is applied in an individual case. Thank you.
No further questions?
Hearing no other questions, Mr. Barber, thank you so much. And
Thank you, Your Honor.
on behalf of the entire court, I want to commend excellent counsel on both sides. Thorough, detailed briefs, very helpful to the court and its staff. That is combined with arguments that reflected a commendable command of this lengthy and complex record together with applicable law. And it has all resulted in excellent arguments today. You've represented your respective positions professionally, and we all on the court commend counsel for both sides. We are adjourned.
Well, after 3 hours, we have just finished listening to that appeal hearing for Alex Murdaugh and his double murder conviction.
Yeah, it was a lot of information. And like she just said, we just wrapped up from the South Carolina Supreme Court. We heard arguments in Alex Murdaugh's appeal centering on whether he received a fair trial or not.
Yeah, we can't stress that enough, that this is all about whether or not he received a fair trial, not if he is guilty or not. So what the justices are are going to do now, they're going to take all of this information from the hearing, continue to look over the thousands of pages of documents that they have, and we are learning that within the next couple of months, we could possibly be getting a decision from the justices. But again, we were not expecting one today. That decision from the justices, again, will happen in a couple of months.
Yeah, but we're going to have so much more on this and break it all down. But first, we're going to go to the break. We'll be right back.
We are continuing breaking news of the coverage of Alex Murdaugh's appeal hearing, which just wrapped up moments ago. Now, today, the South Carolina Supreme Court heard arguments in Murdaugh's appeal centering on whether he received a fair trial.
Yeah, defense attorney Dick Harpootlian, he argued that Murdaugh is entitled to a new trial, claiming that former Colleton County Clerk Becky Hill improperly influenced jurors. Now, he pointed to allegations she made comments about body language, credibility, and even wanting a guilty verdict to help sell a book. Now, the defense says even subtle remarks could have tainted the jury, and under the Constitution, Murdaugh was guaranteed 12 impartial jurors, not 11.
Right. Now, the state pushed back, calling the comments fleeting and arguing there's no proof that the verdict was actually influenced by her comments. Prosecutors also defended the trial judge ruling that no prejudice occurred. Now, justices questioned both sides extensively, focusing on juror credibility, burden of proof, and whether the alleged conduct warrants a new trial.
Yeah, no ruling was issued today, but we do know, speaking with our attorneys all morning, that can take a very long time before a ruling is actually made.
Exactly. And my friends, we are actually going to be sitting down, talking with an attorney to break down everything that we just saw over the course of 3 hours, so that way you have a clear picture of what happened in this hearing and exactly what is to come. But first, we know that forecast is so important, so we're going to hand things over now to meteorologist Tim Miller.
Whitney, thank you. We'll have a quick look at our forecast, where we've had some showers throughout the day today, and that's going to continue really for the rest of the afternoon into this evening. Here's a live look at our satellite and radar loop. These showers, very light in nature, but again, they're scattered about. And that's going to be the case again through the afternoon, through the evening time with the rain here. Temperatures, though, holding rather steady. 63 degrees, our current temperature. I still think we'll be approaching 70 a little bit later on. Maybe some peekaboo sunshine by the time everything's said and done. The winds are from the southwest to west, gusting up to about 20 miles per hour. So that's bringing in certainly the warmer temperatures. So 70 today, 37 tonight. As the skies clear, the front moves on through. 63 with sunshine tomorrow. So a big difference, but still actually 63 is where we should be on average. Look at our 7-day forecast. Notice that Saturday is Valentine's Day. Showers late. The best chance of rain, though, is Sunday at 80% with a high of about 65. Again, that's on average. That's your forecast.
All right, thank you so much, Tim. Now, the first half of the hearing, we really focused, or saw them really focus on jury tampering. And the second half of the hearing, the focus was really put on evidentiary challenges. And that is something that they asked a lot of questions. I had a lot of questions about the justices.
Absolutely. You know, coming from, you know, where that phone was tossed, what happened for the light to go on it. They were given timestamps. So much was given to us this morning and to this afternoon, and it's a lot to break down.
Yeah.
So we're going to turn right now to the professional who can help us with everything. Dan Phillips, thank you so much for joining us in studio. You've been with us all morning. So we kind of want to get your thoughts on this appeal as a whole right now.
Look, if I'm Alex Murdaugh's legal team, I'm feeling really positive. Given the tenor and kind of tone of the questions, you know, they were very direct from the justices, that very favorable, I think, to the defense in terms of the issues that were raised on appeal. Again, I can tell you from personal experience that you cannot base their questions on ultimately what the outcome's going to be. But if you're going off of just the basis of the questions, the grave concern that the court had on a lot of those legal issues, a very positive takeaway from Alex Murdaugh's legal team, that he has a very strong appeal, which earlier you asked what my personal belief was, and it's that he deserves a new trial. And I know that's a hard pill for a lot of people to swallow, but again, when you look at this from a pure legal perspective and receiving a right to a fair trial from an impartial jury, I believe it's clear based on what's presented.
All right, Dane, one last quick question before we wrap things up. After listening to this whole hearing, what is the biggest takeaway that you have, or that you think the viewer should have after watching the hearing?
Well, the biggest takeaway is it's not over today. There's going to be many months that we got to wait for the court to settle on whether this is a split decision in terms of whether the justices are all on the same page and whether there's a dissenting opinion. So it's not over, and that's kind of the very nature of the Alex Murdaugh saga, is it feels like it never ends. It's always going to be one more thing to wait on, and so it's with great anticipation to see how the South Carolina Supreme Court rules.
Absolutely. Well, thank you so much. We're going to have so much more on this on WLTX Plus in just a few moments, so you can turn on over there to continue this. Thank you so much for joining us at News 19 at noon.
News 19 is on your side. You're watching WLTX Plus.
Good morning. Please be seated. The case for oral argument this morning, State versus Murdaugh. We're ready to proceed.
Please, the court, Your Honor.
Yes, sir.
Well, you just heard from the South Carolina Supreme Court this morning as justices began hearing arguments in the appeal of Alex Murdaugh's double murder conviction.
Yeah, in today's hearing, it centered on two major arguments: allegations of jury tampering and whether evidence or financial crimes should have been allowed at his initial trial.
That's right. Now, the outcome could determine whether Murdaugh's convictions stand or whether the case returns to court.
Now, after more than hours of arguments this morning, the South Carolina Supreme Court, they wrapped up its hearing on the Alex Murdaugh appeal.
News 19's Kiki Gushu and Christy Calcagno standing outside of the state Supreme Court right now. Kiki actually inside of the courtroom during this whole hearing. And so we are wanting to hear from you about how the atmosphere was.
Yeah, absolutely. Inside the courtroom, it was pretty packed. We're sitting shoulder to shoulder, and I thought it was really interesting. It was actually a younger crowd. There were a lot of pre-law students in there, kind of wanting to see how this hearing would go and really learn from it. And I would say the justices were very actively engaged. I was a little bit surprised they got to go over that time limit, that allotted time limit. The trial did, or the hearing went a little bit longer, as the justices asked really intense questions, really deep questions. And it was interesting to see how the attorneys were able to respond to those questions. A lot of them, kind of bringing up hypotheticals, which I thought was interesting.
They were also bringing up a lot of previous court cases that the South Carolina Supreme Court did cover. We're talking involving Greer, involving a lot of those too. What did you kind of see as far as sitting there and you're looking at the justices? Are they all taking notes on your end? What did you see from them?
They were all ready with their questions, is what I would say. They were leaning in, a lot of them, hands on the face, leaning in, listening, and making facial reactions. A lot of them I saw, would kind of, react, making sure that they knew that they were heard. But I did think it was interesting. We didn't hear immediately from Justice Hill over in the corner. We didn't hear a lot from him in the beginning, kind of about the financial crimes. And then he did start asking a lot of questions, especially when it came to which evidence was admissible in the trial and whether that should have been allowed.
Yeah, speaking of the evidence, what was interesting is not only did they bring up the financial crimes, but it was also interesting when we were hearing on it, they were talking about the guns and they were talking about the cell phones as well, right?
There was a lot of time spent on these cell phones, Christy. They talked a lot about whether Alex Murdaugh could have dumped Maggie Murdaugh's phone out of a moving car. They're really getting into that data, what data is admissible in court, and whether there should have been a different standard when it came to cell phone data.
Yeah, so right now we are hearing as well as when it comes to Greer being on there on the stand back in the court involving the guns and the shell casings. So that was something that we were hearing as well on top of everything that happened with Juror Z. We're talking about egg juror as well when it went over to Becky Hill, right?
Yes, we started out with Becky Hill, and a lot about Becky Hill was about whether she actually influenced the jury. But then it came back a little bit, and the justices were really talking about whether whether those 11 jurors were enough, and whether the juror Z was impacted by Becky Hill, if her verdict was impacted by Becky Hill.
Yeah, Kiki's going to have much more about that. We are also still waiting to hear from any press conferences regarding from walkers as well. We did also see the Attorney General Alan Wilson was not taking any questions, and he did leave the South Carolina Supreme Court. We'll be getting more details from here live at the Supreme Court. I'm Christy Calcagno alongside News 19's Kiki Gushu. We'll send it back over to you guys in the studio.
All right, thank you so much, Kiki and Christy. And one of the things that we just learned moments ago, one of our managers came in and let us know that the prosecution, Creighton Waters and his team, will not be holding a press conference. However, we have learned that Harpootlian and Murdaugh's defense team will be holding a press conference within the next 30 minutes or so. So that's definitely something that we will be on the lookout for.
Yeah, and absolutely. We know a lot today was discussed, a lot we all kind of indulged in and took in, and it's a lot to break down. So for that, we have brought in our experts this afternoon to kind of help us with everything that was discussed inside of the state Supreme Court. And Dame Phillips, thank you so much for joining us. You've been here with us all morning and into the afternoon. So want to recap that appeal hearing that you just heard. You heard the entire thing. What are your thoughts so far?
Well, as I said a few moments ago, that kind of the attitude of leaving that based on the questions that were asked is that the court has grave concerns as to the issues raised on appeal, specifically the two primary issues of the jury tampering through Becky Hill as well as the financial crimes, the improper character evidence. But they also delved pretty deep into what they would say is improper expert opinion testimony, whether it was related to cell phone, digital forensic evidence, as well as firearm ballistics evidence. There was a pretty significant amount of time spent on those two issues that, for the most part, many people didn't believe was going to be given a ton of time for this oral argument. And so overall, I felt like the overall tone and attitude of the questions that Alex Murdaugh's legal team is feeling very positive going, or at least leaving the South Carolina Supreme Court today, that they certainly are in a good position potentially to have this case reversed on appeal.
I want to talk about Juror Z for a hot second. We spoke briefly during the hearing. The state, they kind of pushed back, calling the comments fleeting and arguing that there was no proof that the verdict was influenced. However, we know through the affidavits that the juror Z said that they were influenced. We also know that the judge said she basically did not believe Juror Z. What reason do we have behind that?
Well, that's kind of one of the big issues raised by Murdaugh's legal team, is the fact that former Chief Justice Toll did not fully provide a basis challenging Juror Z's credibility, because former Chief Justice Toll did not find Juror Z completely uncredible or incredible. The issue was essentially that parts of that testimony were not credible. However, Becky Hill was found not credible as well. She has her own perjury issues, her misconduct in office guilty plea. Certainly credibility being the primary issue, is you have a sworn affidavit by one of the 12 jurors who says these comments were made and it affected her decision, it affected the verdict. By the very nature is you got to have all 12 unanimous verdict, all 12 jurors to be unanimous on a guilty verdict. That is the heart of the issue of how the Supreme Court is going to handle that issue with Juror Z, because Chief Justice Kittredge made clear, pinned down Attorney General Creighton Waters, that those comments, or at least comments in general by Becky Hill, were improper. Now, there's a dispute from the Attorney General side, from the respondent side, about whether the comments are, for Juror Z's point, are credible. That is the heart of that issue. How is the Supreme Court going to side on that? It remains to be seen, but that is at the heart of it.
All right, Dane, and one last question. We want to go ahead and start looking forward to what we can expect to happen next. So over the next couple of months, what will the justices be doing, and how will that opinion, that decision be given out?
So each justice has law clerks. There are staff attorneys as well that work there. They will be essentially making their own decisions, and then they will be sharing them with the other justices, kind of doing a head count. And from that standpoint, they will know whether there's a majority versus whether there'll be a dissent, and then who's providing potentially dissenting opinions. And so right now is each justice outlining exactly what their position is on each of the issues that were raised on appeal, and then comparing that with the other justices to see where they're at. And the interesting thing is, again, based on what I've watched today, I do believe there is a good likelihood that we may have a reversal. Now, that doesn't mean that it ends there. The government, the South Carolina Attorney General's office, can still file a petition to the United States Supreme Court, depending on what the issue is. But there is certainly a likelihood that we could see a reversal and remand for a new trial in this case.
Dane, we want to thank you so much for joining us. In full transparency, Dane has been here since 6:30 this morning, breaking down every moment of this hearing, really helping us to understand what's going on. So again, we appreciate you so much. We appreciate your expertise. And for really, because sometimes legal jargon can go over a lot of people's heads, but I feel like we all are so much more informed about what exactly happened and what to look forward to because of your expertise and your time. So again, we're going to cut you loose. We want to thank you again for joining us today.
Well, thank you so much. It was a pleasure.
Absolutely. Well, thank you so much. Now, the hearing, it focused on two major issues. First, allegations that the clerk of court improperly influenced jurors. And second, whether financial crime evidence should have been allowed during the original trial.
Right. Here's how the defense framed that first argument.
This matter we're discussing this morning, a fair trial, a jury not poisoned by outside influences. I've never seen a factual pattern like this, where the clerk of court, sets out to influence the verdict, to get a guilty verdict for financial gain.
Right. Here, if Becky Hill is not credible, it's not because she didn't see it, it's not because she doesn't remember it, it's because she's a liar. Is that right?
I would say that ultimately she said she was not completely credible, and yes, sir.
So there's only one way that Becky Hill can be not credible, and that is that she is a liar.
I think that Justice Toll did not credit parts of her testimony as she looked at everything. Now, she didn't specifically find that she is a liar, but ultimately she didn't credit that testimony. But what I think is important is that neither Justice Toll nor the state relies on Becky Hill. What we rely on is what is most important, and that is the 11. The overwhelming majority of these jurors who sat there and looked Justice Toll in the eye, who judged their demeanor, who judged their credibility, and who ultimately were clear as a bell that there was no sort of improper influence on their verdict.
Absolutely, a lot of information that they were giving there as it regards to Becky Hill, and you know she played a huge part in this appeal today. I know when we were speaking with all of the attorneys this morning, they were saying that that one thing with Becky Hill is what is going to be the biggest issue to kind of get over with this hearing, as it relates to if this appeal is accepted or not.
Right. And one of the things that I found interesting is I noticed that the justices made it very clear, because so much time was spent talking about potential jury tampering, they made it clear that this is not what typically happens when it comes to Court of Clerks. They wanted to let South Carolinians know that most Court of Clerks by far adhere to the rule of law and uphold that standard. And so I realized that that is something that they wanted to make very clear, that the situation with Becky Hill is rare. And speaking of rare, I mean, when we talked with the attorneys earlier this morning, this whole case it's rare.
Right.
They called it a unicorn, and I think that it's a great way to describe it. I mean, the situation with the jury tampering is a unicorn. The situation with how many people have been just captivated by this, that's a unicorn situation. The fact that an appeal may be granted, that's also extremely rare. And so this continues to be a case, as we continue to follow it, that stands out from so many other cases that we have seen, because we have so many instances of rare happenings.
Absolutely, and that's why when we were speaking with those attorneys this morning, I wanted to ask the question of, because of what Becky Hill did, does that kind of put a negative light on the justice system, because this case has gotten international attention, and so a lot of people now could have that idea in their head, like, if I go to court, if the clerk of the court doesn't like me or doesn't feel what I did was correct, do I have a fair trial?
Right. And one of the things that we also learned this morning, so a lot of conversation has been about Murdaugh getting a retrial because of either jury tampering, or they spent too much time talking about financial crimes. They admitted too much, which was not fair characterization of him. But also we learned this morning that every time a lawyer objects in a case, they also, during the appeal process, will look back to see if that judge made the right decision and how they decided to move forward with that objection, whether they allowed it or whether they shut it down. And so that's why you also heard so much information about things outside of the jury tampering and the financial crimes.
Absolutely, and like you said, this is far from over right now. It could take months before we get an update or a decision. Of course, we are going to be on your side, covering that through and through, giving you every update as we get them. Of course, stay with us right here on WLTX, as we have so much more news to give you. All right, welcome back. We have been following the Alex Murdaugh appeal hearing all morning and to the afternoon. We've had crews inside the courtroom, outside the courtroom, and we've also had some attorneys here breaking everything down.
Exactly. Now, a lot has happened over the past 3 hours. The hearing started at 9:30, lasted to just before 12:30, so it went on longer. And that's because even though there was an outline that we had been telling you guys about throughout the week, they're Supreme Court justices. If they have questions, they are going to go over that time limit to get those questions answered, and understandably so. We were hearing from the attorneys that because this is such a high-profile case, so many eyes are on it, and they want to make sure that everything is done to a T, which they always do, but especially in this case. And so very understandable that they had a lot of questions regarding both the prosecution's and the appellate side of what happened and whether or not there should be a retrial.
Absolutely, and we had our cameras live inside of the courtroom, but we also want to know what the actual courtroom felt like,
Yes.
you know, so that's why we had our Kiki Gushu inside of the courtroom, you know, getting everything as far as like the emotional standpoint inside of the courtroom. And Kiki, kind of just take me into the courtroom. What was it like on the inside, and what were you seeing and what were you feeling in the atmosphere?
Yeah, Xavier, there was a lot of intrigue. There were faces, there were expressions in the crowd, and the justices were very engaged and with asking questions. Now, I am going to invite Joe McCulloch in with me. He is a criminal defense attorney here in South Carolina, and he also represents the family, the Cook family in the boat crash involving Paul Murdaugh, and also the egg juror.
Well, let's call her Ms. Crosby, but I think she'd like to be done with the egg lady description, but she was frequently mentioned today, as I knew she would be.
Can you tell us where that egg lady name did come from?
Well, on the final day of the case, before the jury received the case, Judge Newman called Ms. Crosby around, back then referred to only by juror number, told her that she was being excused, that she'd done nothing wrong, but he'd made the determination to excuse her, and she asked, "Can I have my eggs?" Because only that morning she had brought all the jurors a dozen eggs apiece, and her dozen eggs were in the refrigerator. So that's where the name came from.
So I think there was some confusion. I had people beside me asking, who is the egg juror? So that is, if you were wondering, that's your answer.
Well, her affidavit may have broken some eggs today.
Absolutely, absolutely. Let's talk a little bit about that. So when they were talking about these claims of Becky Hill, former clerk of court in Colleton County, influencing the jury, how much of that do you think will actually become part of this, what the justices take into account?
I think that's, to me, really the issue. There is, because of our case law, very limited case law on jury tampering and the standards by which judges, trial judges, should evaluate that, and that's really a central issue here. So I think this case will be, in my view, decided on that issue, with this court clarifying how and what the standard is for jury tampering. The defense takes the position that once they produce credible evidence of tampering, that then the burden shifts to the prosecution to prove it didn't influence the jury. The judge who held the hearing on the new trial motion for jury tampering concluded that she would not grant a new trial on that basis. The defense contends she used the wrong standard. And this court seemed very interested and, if not concerned, that Ms. Crosby, the egg lady's affidavit, was considered by the court, but her testimony was not allowed. The stated reason being that she wasn't on the jury, but yet the alternate was allowed to testify. So the inconsistencies there, I think, have got the attention of this court.
Yeah, absolutely. And I just want to touch on for a second, talking about kind of that big second piece, was whether the financial crimes were admissible in court. And a lot of that centered kind of around the motion, and specifically the Satterfield brother with the mental disability being brought into the courtroom. What are your thoughts on that?
Well, we have a rule called 404B that says that evidence that is collateral to the issue of, in this case, murder, and that is the financial evidence, should only be admitted if it has a reason and a purpose. Here the prosecution contended motive. This court seemed very concerned, individual members of this court seemed very concerned, and the Chief Justice referred to it as the granular nature. Why was the prosecution so insistent on going into such granular detail when you could have put this financial issue out there that he was a thief, if not a liar, in an hour? And the Satterfield situation was part of a detail that the Chief Justice, I think it was, said that was really, to me, intended to raise sympathy, not to be a probative matter, not necessary. So those are very significant issues, probably tedious and boring to the non-lawyers out there paying attention to this thing. But I think the central issue is jury tampering. The financial evidence is a significant issue to trial lawyers like me.
Absolutely, absolutely. Thank you so much, Joe. I'm going to send it back to y'all in the studio, and we'll be bringing you more analysis throughout the day.
All right. Thank you so much, Kiki. Yeah, I remember watching the trial as it was happening, and the egg lady actually started trending. And it was a moment of levity in a very, very serious case. And so that's how she got that name, as McCullough explained there. But again, yeah, we were able to really get an inside look at to how this process happens, because there are Supreme Court hearings, appeal hearings, if you did not know. You can see those. The lawyers let us know that those are streamed live all the time. But I think this is going to be the first time that many South Carolinians, really many people across the nation, have watched a state Supreme Court hearing unfold, hearing the arguments from appellate, hearing the arguments from the prosecutors, and watching how that whole process goes. And it honestly has been a great learning experience for so many people who don't know how this process goes. Now, again, I would be remiss if I did not reiterate this, because I'm seeing a lot of folks on social media saying, he's guilty, I don't know why we're doing this. And again, the appeal hearing is not about the morality of the charges, the morality of the conviction. It's not about whether he's guilty or not. The appeal hearing is happening because his defense team says, hey, look, he didn't get a fair shot. He didn't get a fair trial. And so really all this is about is determining from the justices whether or not Alex Murdaugh received a fair trial. Now, everybody can have their opinions about whether they think he did it or did not. You'll see that like going all across social media. But the reason that it's really focused on what happened inside the courtroom is because they're trying to figure out if he received a fair trial, because as we know, our Constitution says we should all receive a fair trial.
Sixth Amendment. So, and that's something that we have been talking with our attorneys about. And you heard him on the show this morning saying he does not believe that Murdaugh received a free trial. But right now, we want to do a live press conference to Alex Murdaugh's defense attorney. So we're going to turn things over there.
And he pointed out she was a self-confessed perjurer. So one of the justices react to that. So, I mean, I think, look, do I regret anything we did today? No. Am I proud of the arguments we made? Yes. Did we cover everything we needed to cover? I think we did. Phil, you got something to say? No?
No,
Okay.
we covered everything.
Is there anything you wish that they then would have asked you about or delved deeper into in their questioning?
I don't think so. I mean, if we had had an hour and a half each side, you know, we would have covered the waterfront. But frankly, getting 40 minutes or 50, we had 50 minutes. That's highly unusual. And our goal is to answer their questions, what they are interested in. And so that's really, you know, having done this for many years, I mean, I've learned that you win an appeal on your briefs, and our briefs were excellent, thanks to Phil and Maggie, and not so much Dick. But that, you know, and the argument is really where you can step on it and lose the case. And so I don't think, you know, we did any of that. And so, you know, we'll see where it heads.
Or sometimes you find out they're thinking about something you never thought about, and we didn't hear that today.
What do you go back and tell your client? What do you tell Alec now about what happened today?
Did you speak to Alec
Not yet.
No, we will. I would say to him, we had a good argument today. The justices were engaged. They were prepared. They'd read the stuff. They understood the stuff and had very intelligent questions that indicate to me that they're wrestling with the issues we asked them to wrestle with.
How important is this to Alec? I mean, he's insisted he's innocent for all this time. I mean, is he kind of put everything, you almost have got to push all your chips in at this point?
Well, as you know, he's not going to get out of jail if we win this. He believes, advocates that he did not kill Maggie and Paul. He believes somebody else did. What?
He knows he didn't do it.
Yeah, he knows.
It's not a belief. So that's what he expresses to us. But frankly, you know, he accepts that he's in prison. He doesn't regret being in prison, believe it or not. He's got a very positive attitude. He said he deserved to go to prison for what he did financially, but he can't accept the fact that he was convicted of murdering his wife and son, to which he constantly proclaims his innocence, and we believe him to be innocent as well.
He always has. And of course he says, since I didn't do it, SLED ought to go find who did. And again, one of our problems has been from the get-go. From that night, he was the primary suspect, the only suspect, and they've never really looked at anybody else.
You all had 5 minutes uninterrupted by each justice. What goes into how you strategize, or what goes into those first 5 minutes?
Again, you just heard from Murdaugh's defense team, who come out of this looking pretty positive, because we heard from attorneys who say they felt like it was a win for the defense. And so we've been waiting to hear from their team, and they also believe that things went pretty positive. Now, a lot of folks had questions. Why didn't we see Murdaugh in the courtroom today? And it's very normal to not see. That's actually procedure for the person that the trial is around to actually not be in the courtroom, because again, this is a hearing. And I asked even earlier, I was like, will he get to watch it? Like, we all have been watching it. And from their best knowledge and understanding, he actually didn't watch it. So he is relying on his defense team to give him the play-by-play about what happened during the hearing.
Yeah, and we also found out this morning that in the event that, you know, if this does get approved, this hearing, it could take months. It could take maybe even a year before we get anything back. And we also learned that if it's denied, that there is more steps in this process. They can do a federal appeal. And there are so many, well, not so many other options, but there is another option if this one is denied. But like the attorneys have been saying all morning, a lot of eyes are on this case right now. And those justices, they have a very, very big job ahead of them to make these decisions and argue their points.
Exactly. All right, my friends. Now, we want to go ahead and hand things over to meteorologist Tim Miller. I know all eyes are talking about the Murdaugh trial, but we also want to make sure that you are prepared if you head out today, because we are expecting some rain.
That's true, Whitney. We have been tracking some showers and some light rain pretty much all morning, and we continue this afternoon, a little bit after 1 o'clock, and it's still continue to be some showers. You notice these breaks of the rain, as promised. That's been the case pretty much throughout much of the morning and afternoon. We'll continue to get these breaks. It'll rain, it'll in and out. And that's going to be the case really pretty much throughout the rest of tonight. Up to Newberry, to Chapin, there's our showers there. Satellite view pretty much shows the same thing. Big batches of rain out towards our west. That will move in tonight before everything starts to clear out. Temperature 66 degrees. We're warming up nicely thanks to those brisk southwest winds, around 10, 15, maybe even up to 20 miles per hour for the rest of this afternoon. So here's how it looks. 68, around 70 today, 37 tonight. As the front moves through, skies will clear, and we'll have a really nice day tomorrow, again with abundant sunshine, a temperature of 63. 7-day forecast shows seasonable temperatures, and our next decent chance of rain comes on Sunday. That's your forecast.
All right, thank you so much, Tim. But we're going to go ahead and wrap things up. Again, we have been covering all morning since 7 o'clock the appeal hearing for Alex Murdaugh on that double murder conviction. Again, he is accused or has been found guilty by a court of murdering his wife and his son. And so today we saw both his defense team and the state explain why or why not he should receive a retrial. Again, reiterating the fact that this is not about whether or not he is guilty. This hearing was just about whether or not he received a fair trial. And they talked about a number of things in this hearing, two of the biggest ones being, A, did Becky Hill influence the jury's verdict? And B, if all the evidence that was allowed to be brought before the jury should have all that evidence been presented, specifically speaking of the financial crimes. We talked to the defense attorneys this morning who said that they just went overboard when they spent 2 weeks just talking about the financial crimes. And many folks are like, wait, the financial crimes are part of the state saying this is a motive for murder. But the defense attorneys told us earlier, they said, listen, 2 weeks of speaking about that, they said it was overkill. They also said that one of the issues with the financial crimes, all those financial crimes being admitted during the court case, is that it didn't necessarily all of them speak to what he was being tried for, and that was murder.
Absolutely. And we're going to dive so much more and
so much more
deeper into this later on today. So we hope you join us for a special edition of WLTX Plus at 3 o'clock this afternoon. Thank you so much for joining us.